Mr. Kowski, Mr. Brewer.
Thank you, Mr. Castor. On behalf of Lanny Brewer and myself, we do have some preliminary remarks that we would like to make. Mr. Smith is committed to providing information to this committee about the work of the Special Counsel's Office, while following all laws and rules restricting a former prosecutor's ability to disclose certain information. To that end, we appreciate the committee's assistance in working with the Department of Justice to provide Mr. Smith with authorization and clarification on the parameters around Mr. Smith's testimony today. Of course, some restrictions remain on Mr. Smith's testimony, two of which I would like to highlight before we begin. First, as the committee is aware, in its letter of December 11th, 2025, the Justice Department admonished Mr. Smith that he is not authorized to divulge information that is prohibited by law or courts, including that which is subject to Federal Rule of Criminal Procedure 6E. It is our understanding from communications with the committee and the Justice Department that DOJ is interpreting a matter under Rule 6E to be limited to the inner workings of the grand jury. On a call with committee staff and with the Department of Justice on December 11th to discuss the scope and application of grand jury secrecy requirements, Assistant Attorney General Patrick Davis agreed with Mr. Castor's statement that based on DOJ's authorization letter and its interpretation of Rule 6E, it would be virtually impossible for DOJ to prosecute Mr. Smith for violating grand jury secrecy restrictions. Second, according to the Justice Department, discussion of Volume 2 of the Special Counsel's reports and any information or conclusions in Volume 2 or in drafts thereof is specifically prohibited by Judge Cannon's January 21st, 2025 order. This morning, just over an hour ago, the Department of Justice sent us an email affirming its view that Judge Cannon's order applies to Mr. Smith and that it precludes him from disclosing any non-public information that may be contained in Volume 2, including, but not limited to, interview transcripts, search warrant materials, business records, toll records, video footage, records obtained by grand jury subpoenas, attorney-client communications, and potential Rule 404B evidence. This restriction significantly limits Mr. Smith's ability to discuss the classified documents case. Nevertheless, Mr. Smith is committed to doing his best to answering questions consistent with the department's guidance. And I ask that that email from the Department of Justice that was sent earlier this morning be made part of the record.
That'll be Exhibit 5.
Thank you. I also want to clarify that the email from the Department of Justice says that Mr. Smith can disclose information in answering questions where that information is in the public record and has been made publicly available through authorized means. And I want to specifically cite that language because yesterday the Department of Justice disclosed to Senator Grassley some emails related to the execution of the search warrant at Mar-a-Lago. I anticipate that those emails may be used during today's deposition and that Mr. Smith may be asked questions about that search warrant and the probable cause supporting the search warrant that was signed by a judge in the Southern District of Florida. And I just want to confirm our understanding that because those emails were released by the Department of Justice to Chairman Grassley, everyone here has a mutual understanding that those emails were made publicly available through authorized means.
And we would concur with that. In our discussion with the Justice Department, and it was in the context of the member toll records subpoenas, they indicated that documents that are in the public realm are fair game for discussion and don't apply to the 6E prohibition, the disclosure of 6E material. And we would further acknowledge that if Senator Grassley posted these materials on his official website, that is an authorized release. I mean, these are materials that were produced to the House and the Senate, and if Senator Grassley posted them publicly, they are certainly part of the public record.
Thank you, Mr. Castor. We are in agreement.
Mr. Castor, can I just note one thing for the record, that counsel for the minority have not been involved in any of the discussions that Mr. Koski just discussed between the Judiciary Committee and Department of Justice. I just want to make that clear for the record.
All right, noted.
Thank you. My understanding is that if, for whatever reason, the questions today move into an area that we believe Mr. Smith cannot answer because of some legal restriction, we have reached an agreement with the committee staff that we will raise our concern in the moment to see if we can navigate around the restrictions. And if we are unable, we will move on to another topic and then revisit that issue during a break or at the end of the day. Yes.
Just to augment what my partner said, we had proposed to the Department of Justice that it have a lawyer here present today, so that if any issue came up, we could immediately resolve it, because Mr. Smith is committed to answering every question he can lawfully. The Department of Justice chose not to have a lawyer here today.
Thank you. Finally, I feel compelled to make an observation about the risks of participating in this deposition. The most powerful person in the world has said that Mr. Smith should be in jail because of his work as special counsel. Not because Jack did anything wrong, but because he had the audacity to follow the facts and the law and apply them to that powerful person. And through its actions, this Justice Department has demonstrated its eagerness to follow President Trump's orders, despite the facts and the law. Yesterday, the President's Chief of Staff is reported to have confirmed in interviews that the President is indeed pursuing criminal prosecutions against his perceived adversaries as part of a retribution campaign. In the face of those threats, Mr. Smith appears today undaunted, comforted by the knowledge that not only did he do nothing wrong, he conducted his work as special counsel with integrity, impartiality, and an uncompromising commitment to the rule of law. If the committee will allow, Mr. Smith has some remarks that he would like to share.
Okay, before that, I would just note from Exhibit 4, the December 11th Justice Department letter, they specifically say, at the last paragraph on page 2, as to your question about the department's recent disclosure to Congress of certain internal communications considering whether to authorize toll record subpoenas, which Congress publicly released on November 25th, 2025, you are correct that the department does not believe that the specific materials it produced to Congress are covered by 6E for the reasons described above.
Thank you, Mr. Castor. That's helpful. We are in agreement on that. My concern is that that doesn't address Judge Cannon's order, which the department has said Mr. Smith is still bound by because the toll record subpoenas were not part of the classified documents case. And so Judge Cannon's order is a separate legal restriction that exists independent of Rule 6E.
Okay, and I would just note on our call with the Justice Department, their position was, of course he can talk about it if it's in the public realm. And that admonition from the department was not limited to, the toll records question or something in, Judge Cannon.
Mm-hmm. Thank you.
Mr. Smith, you had some remarks as well?
Yes, thank you. Thank you for the opportunity to discuss my work as special counsel. I was taught as a young prosecutor to follow the facts and the law, and to do so without fear or favor, to do the right thing the right way for the right reasons. For nearly 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations, and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors, FBI agents, and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs. I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
Need a copy? Give us another copy.
I'm sure.
We can get you a copy, yeah.
You just made some pretty definitive statements about, your belief that President Trump was guilty of these charges. Is that correct?
Yes, I believe we had proof beyond a reasonable doubt in both cases.
And doesn't the Justice Manual prohibit prosecutors from asserting that a defendant is guilty of something before a jury makes a determination?
When a case is pending, yes.
Okay, and so you think you're free from that, from the Justice Manual rules, once a case is dismissed?
No, I think that it's important to state clearly the amount of evidence we had and the basis for why we proceeded. Why we proceeded as we did is because we had a strong case, as I set forth in the final report.
But your final report makes what seems to be conclusive determinations of President Trump's guilt, as opposed to laying out simply the facts and the evidence that you have. I mean, you draw those conclusions that, in your view, he's guilty. Is that not the case?
Well, to be clear, the cases were never tried. We were never put to our burden before a jury, so we didn't conclusively prove it. The reason the report was written the way it was written, and the reason I said what I just said, is because it was our belief that if we went to trial, we would prevail.
But your report differs, if you look at Special Counsel Herr's report and Special Counsel Mueller's report, I mean, the language that you use and the way you describe the things that you believe President Trump committed, is different. Her was careful to use words like jurors could find or might, at most, would likely conclude, whereas the language you use is pretty definitive.
Her report states his assessment of the evidence. Mine does as well, and as I said, I feel, and feel to this day, that we had a very strong case, and so I communicated that.
Okay, but you would agree that it's the role of the jury, not the special counsel, to weigh the facts and to determine guilt?
Ultimately, yes.
Okay. And then one other thing about you relating to your statement, and we'll get into this a little later on, but the toll record subpoenas for members of Congress, we have some very serious concerns about acquiring these toll records, relating to senators and members of the House. I mean, members of the House and the Senate have protections under the Constitution that allows them speech or debate protections. And the toll record subpoenas, in our view, and if we had to litigate it, the House lawyers would take the position that those toll record subpoenas violated the speech or debate protections. And is that something you disagree with?
Yes.
Okay, and we'll get into that a little bit later. We first wrote to you on October 14th, inviting you to testify. And then we worked with the Justice Department and your counsel to make sure you had access to everything you needed to prepare for today. Did that occur? Did you have enough access to the information you need to prepare?
Yes.
Okay, so we asked the Justice Department to make all your files available, to allow you to go to the Justice Department whenever you wanted to, with your lawyers, whoever you wanted to. And I just wanted to confirm that you had the opportunity to review whatever you needed in your files before today.
Yes, we reviewed the files.
Okay.
That's correct.
There might be an issue with classified materials. We don't intend to ask you anything about anything classified. Obviously, if your security clearance is no longer valid, there's an issue on that front. But everything except classified information was supposed to be made available to you, and I just want to confirm that that was the case.
I'm not sure if everything was. For example, the emails of people on my staff. I'm not sure I had access to that, but we did spend, consistent with what you said, time
Okay.
at the Department of Justice, and we had
Okay.
the opportunity to review
Okay.
files.
And that access was made available early, like November 10th, if I'm not mistaken, and I think you guys started reviewing it somewhat shortly thereafter?
That sounds about right.
Okay. You have referenced in your pleadings, I believe, and also in public statements you've made, the famous Robert Jackson speech entitled "The Federal Prosecutor" that he delivered at the second annual conference of the United States Attorneys in 1940. You're familiar with the Robert Jackson speech?
I am, yes.
Okay. And this is widely available on the internet. I didn't make copies for everybody. Everybody can Google it right now as long as your phones are working. And I'm just going to flag some things that Robert Jackson said and just get your reaction to see if you agree with it or not. He says in the second sentence, "The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous." Do you agree with that?
I agree that prosecutors have a lot of discretion, yes.
Jackson stated, "While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst." Do you agree with that?
I do.
On page 4 of his remarks, in the penultimate paragraph, Attorney General Jackson states, "What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain." Would you agree with that?
Yes.
If a prosecutor is obliged to choose his cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get, rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it's not a question of discovering the commission of a crime and then looking for the man who committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offenses on him. Do you agree with that?
I do, I think, yes.
Okay. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. Do you agree that that is a concern?
These are principles, and I agree with these principles.
Okay. In times of fear or hysteria, political, racial, religious, social, and economic groups often, from the best of motives, cry for the scalps of individuals or groups because they do not like their views. Do you agree with that?
Yes.
He concludes by saying the qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you agree with that?
Fully.
And do you think during the pendency of your special counsel work that you tried to live up to those standards?
I do.
Was there ever a prospect after you were appointed special counsel when you thought maybe you would not bring an indictment against President Trump?
Absolutely. When I took this case, I did not know enough about the facts or the law to have a judgment about whether we should proceed in either case, both cases, or neither case. I used my time when I was appointed to get up to speed on the facts and the law. But if the facts and the law did not justify going forward in this case, I would have been perfectly comfortable in doing that, as I have throughout my career in cases involving political figures when I was in public integrity and throughout my career. So I did not have a preconceived outcome in mind when I took this job.
Was there any point where you and your prosecutors that formed your team debated not bringing charges against the president?
Of course. I mean, that is the process of being a prosecutor, is you are analyzing evidence, you're collecting facts, and you're debating whether it's what the facts mean, the inferences to be drawn from the facts, or debating what the law is, and whether you can prove what you think is happening here or not. And so that was a continual process to decide if in fact we could go forward. And that, again, just to be clear, that is a process that I have undergone in my career personally and with prosecutors I've supervised.
When was the decision made that you believed you needed to move forward with both indictments, both in Florida and D.C.?
Well, so the decision wasn't made at the same time. To the best of my recollection, in both cases, the final decision was shortly before we sought indictment.
Okay. In June of 2023, you had a meeting with the Attorney General to present a prosecution memo and basically asking for his blessing to bring the indictments. Is that correct?
We did have a meeting, and I think it was around that time. I didn't think about it as his blessing. I was presenting what I intended to do, and he had the ability to countermand that if he wanted to.
Okay. But certainly, you couldn't bring an indictment without his authorization.
He could block me from doing that. That's correct.
Okay. And during that June 2023 meeting with the Attorney General. Did you guys discuss both indictments, potential indictments? Or just the Florida indictment or just the DC indictment?
If it was, I don't have a specific recollection of dates, and so you can check me on public records, but I believe by late June, the classified documents case had already been indicted.
Okay.
So it, again, this is my recollection, but that would have been, a discussion in late June would have likely been about just the elections case,
Okay.
if it was about an indictment.
Okay, and the Attorney General in the June meeting, it's been reported that he expressed some reservations about the DC case. Is that correct?
I had several meetings with the Attorney General about both cases, and in those meetings, we regularly discussed legal issues, factual issues, things of that nature. Never in those meetings did he tell me I couldn't or shouldn't go forward or should go forward. It was more talking through with another experienced lawyer the legal issues present in the cases, as well as if I was going to go forward, how to best frame those.
Okay. Coming out of the June meeting, it's been reported that he asked you to spend some time with the Solicitor General to review the DC case. Is that correct?
Again, I don't recall specific conversations. What I can share with you is we consulted with the Solicitor General regularly during my time as special counsel. That was a choice I made. We wanted to make sure not only that we got the facts right, but that we got the law right as well. And so I would be surprised if the first time I consulted with the Solicitor General would have been in late June. That would surprise me.
Okay, but you did have a one-on-one meeting with the Solicitor General in person?
I've met the Solicitor General in person. My recollection is most often it would be members of my senior staff speaking with her staff about these legal issues. I did have conversations with her as well, but the majority of that was her staff and my staff speaking about things.
Okay. And as it's been reported, the Attorney General at the time was concerned that the proposed indictment or the proposed prosecution plan, may have relied too heavily on statements that the president had made and infringed on his free speech if you were going to prosecute him for it. Is that fair?
As I sit here right now, I can't remember specific conversations. I do remember that we knew that a sort of First Amendment defense would be part of the case. And I think when I mentioned to you earlier about how to frame the case, we wanted to make clear that this was not about trying to interfere with anyone's First Amendment rights, that this was a fraud. And as you know, under Supreme Court precedent, fraud is not protected by the First Amendment. And so in my mind, it was important to make that clear in the indictment. And that's why when we litigated this issue before the district court, we prevailed.
But the president's statements that he believed the election was rife with fraud, those certainly are statements that are protected by the First Amendment, correct?
Absolutely not if they are made to target a lawful government function and they are made with knowing falsity. No, they're not. That was my point about fraud not being protected by the First Amendment.
I mean, there's a long list of disputed elections. I mean, the election of 1800, 1960, year 2000, where candidates believe they were wronged by because they lost. And there's a long history of candidates speaking out about they believe there's been fraud, there's been other problems with the integrity of the election process. And I think you would agree that those types of statements are sort of at the core of the First Amendment rights of a presidential candidate, right?
There is no historical analog for what President Trump did in this case. As we said in the indictment, he was free to say that he thought he won the election. He was even free to say falsely that he won the election. But what he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. That he was not allowed to do. And that differentiates this case from any past history.
A lot of these statements, though, people come into the Oval Office. I mean, the president isn't conducting his own due diligence. He is receiving people in his office that are telling him these things, whether it be Rudy Giuliani, whether it be John Eastman, whether it be Jeffrey Clark, whether it be Sidney Powell. And, for the most part, he is just receiving this information, and, his statements are almost just regurgitating what these people have told him. I mean, isn't that the case?
No, and in fact, one of the strengths of our case and why we felt we had such strong proof is our witnesses were not going to be political enemies of the president. They were going to be political allies. We had numerous witnesses who would say, I voted for President Trump. I campaigned for President Trump. I wanted him to win. The Speaker of the House in Arizona, the Speaker of the House in Michigan. We had an elector in Pennsylvania who is a former congressman who is going to be an elector for President Trump, who said that what they were trying to do was an attempt to overthrow the government and illegal. Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so the president got information from people he trusted on other issues. He rejected it whenever it didn't fit him staying in office. And there was a pattern in our case where anytime any information came in that would mean he could no longer be president, he would reject it. And any theory, no matter how far-fetched, no matter how not based in law, that would indicate that he could, he latched onto that. And we were confident that we had very strong proof of that pattern. He also, I would just add, very consciously did not try to reach out to the sort of people who have the most expertise on these issues. He reached out to people who he thought could back him up.
Yeah, but let's be honest. The president doesn't reach out to anyone. People are brought to him. I mean, he doesn't, like, the people you mentioned that you were going to call a trial, those aren't, some, Pennsylvania Republican official. I mean, that's not somebody who was in the Oval Office communicating with the president.
Well,
right?
Well, with respect to the Arizona Speaker of the House, that is someone the president reached out to. He also reached out to governors. He reached out to the governor of Arizona. He reached out, and again, Republicans, his allies. Our case was a case in which the president was preying on the party allegiance of people who supported him. And these are, again, the record is rife with examples of him reaching out to those people, inviting them to the White House. And another example, sir, is the folks from Michigan. He invited them to the White House. They told him, you lost because you underperformed with educated females. They told him that when he brought them there. And again, our case was filled with examples of that.
Were you planning on calling John Eastman as a witness?
I do not believe we would have, but we would have welcomed if the defense called him.
Okay. It gets tricky, though, for the defense to call him because the people like Eastman and Clark and, Rudy Giuliani and Sidney Powell, I mean, they were shrouded by the special counsel as, co-conspirators 1 through 6. And so they all feared that they were going to be prosecuted if they said anything. Isn't that fair?
Well, they were co-conspirators. I can't get into what was in their mind or not. I can tell you some of the co-conspirators met with us in proffers and did interviews with us. And so the idea that someone like Rudy Giuliani, who sat with a proffer for us, he was available as a witness, and we would have welcomed President Trump calling him as a witness. Boris Epstein sat for an interview with us. We would have welcomed calling him as a witness. Kenneth Chesborough would have welcomed it.
Why didn't you charge any of those folks?
I'm sorry?
Why didn't you charge any of those co-conspirators?
As we stated in the final report, we analyzed the evidence against different co-conspirators. My staff determined that we did have evidence to charge people at a certain point in time. I had not made final determinations about that at the time that President Trump won re-election, meaning that our office was going to be closed down.
Right. You've had a 30-year career as a prosecutor. You've prosecuted gang members, right?
Yes.
You've prosecuted organized crime members, right?
Not as much.
But, surely one of the, fundamental principles of prosecutorial work is you work from the bottom up, and you try to get as many fact witnesses to work with you. And a lot of times those fact witnesses have criminal liability, and a lot of times those lower fact witnesses, the smaller fish, are almost always they're either prosecuted or they are given an immunity because they fear they're going to be prosecuted. But here, you didn't, you kept laser focused only on President Trump.
2 points. One, as I said, we were considering prosecutions of these people, and I think, I don't want to say what the ultimate conclusion would have been, but that was something that was being considered. The second thing, I think, to understand contextually is this was a case where the issue was how to present it in a concise way. We had so many witnesses, again, so many witnesses who were allies of President Trump available to us to testify. This was not a case where we needed more witnesses. It was a case where we needed to be able to present the case in a streamlined way because there was so much evidence.
In this book by the Washington Post reporters on page 310, you're familiar with this book. Have you read it? It's called Injustice by Lenig and Davis.
No, I have not read it.
Are you familiar with it?
I have not seen it. I mean, I saw that it came out in the news, but I have not read
Okay.
it.
Did you cooperate with the book? Did you talk to Carol Lenig or Aaron Davis?
They reached out to my counsel. I did not speak to them.
And did you ever speak with them during your tenure at the Justice Department?
No.
Anyway, they report, and these are reporters. They get some things wrong. They called Chairman Jordan the chairman of the Senate Judiciary Committee. They said Speaker McCarthy voted in favor of the second impeachment, and I can confirm that it's just laughably inaccurate. And so reporters get things wrong, and so if that's the case, please flag it. But in the book on 310, the reporters write, as each new tranche of information about fake electors came in, members of Smith's team intermittently raised the idea of opening separate case files on Giuliani, Eastman, and others. Each time, however, Smith dismissed the idea. He said he did not want the office getting bogged down and potentially prosecuting those around Trump. Is that?
I don't think that's accurate. I did make the decision that the first case we brought was going to be Donald Trump, and I was aware that there was evidence against other people, but I don't think that characterization is accurate.
Okay. Now, people with different views than you can say the special counsel's office is only interested in prosecuting President Trump because an election's coming up and he's going to be the Republican nominee. And the special counsel works for a Democratic president. The special counsel works for a Democratic attorney general. And so the special counsel's laser focus on President Trump is simply to prevent him from either being the party's nominee or being a successful party's nominee, or at the very least, keeping him off the campaign trail. How do you respond to that?
All of that is false, and I'll say a few things. The first is the evidence here made clear that President Trump was, by a large measure, the most culpable and most responsible person in this conspiracy. These crimes were committed for his benefit. The attack that happened at the Capitol as part of this case does not happen without him. The other co-conspirators were doing this for his benefit. So in terms of why we would pursue a case against him. I entirely disagree with any characterization that our work was in any way meant to hamper him in the presidential election. I would never take orders from a political leader to hamper another person in an election. That's not who I am, and I think people who know me and my experience over 30 years would find that laughable.
So did you develop evidence that President Trump, was responsible for the violence at the Capitol on January 6th?
So our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him.
But you don't have any evidence that he instructed people to crash the Capitol, do you?
As I said, our evidence is that he, in the weeks leading up to January 6th, created a level of distrust. He used that level of distrust to get people to believe fraud claims that weren't true. He made false statements to state legislatures, to his supporters, in all sorts of contexts, and was aware in the days leading up to January 6th that his supporters were angry when he invited them, and then he directed them to the Capitol. Once they were at the Capitol and once the attack on the Capitol happened, he refused to stop it. He instead issued a tweet that, without question in my mind, endangered the life of his own vice president. When the violence was going on, he had to be pushed repeatedly by his staff members to do anything to quell it. And then even afterwards, he directed co-conspirators to make calls to members of Congress, people who were his political allies, to further delay the proceedings.
Did you sought gag orders in both the Florida case and the DC case, is that correct?
We sought an order in the DC case under Rule, I think it's 57.2, and we did that because Donald Trump was making statements that were endangering witnesses, intimidating witnesses, endangering members of my staff, endangering court staff. As you might remember, in the right around when the indictment was released, he issued a tweet saying, "If you come after me, I'll come after you." He called, in a tweet, he called General Mark Milley a traitor and mentioned that what he'd done in olden times, people would be put to death. As a result of the things he was saying, the judge in this case was received vile death threats. And with respect to DC, both the district court and the Court of Appeals, a panel of judges, found that his actions were in fact causing what we said they caused. They were causing witnesses to be intimidated and endangering people. And I believe it was the Court of Appeals also found that in addition to intimidating or chilling witnesses who existed, it would chill witnesses who had not yet come forward because they'd afraid that they would be next. So yes, we did file that, and I make no apologies for that.
I mean, which witnesses do you think he would have intimidated? I mean, are there any specific witnesses did you identify for the court?
We did a filing. I don't recall the specifics in that filing right now, but as I said, one of the issues from my perspective was not only the witnesses who he had specifically called out and caused threats to be issued, this phenomena that was found by both courts. It was the result of that is that a rational witness who maybe had not come forward would be completely afraid to, because they would see that they would be next. And I think both courts agreed with that.
Well, I mean, the Circuit Court of Appeals ultimately slimmed down the gag order, isn't that correct?
It did, yes.
And what was the difference between the gag order you proposed and Judge Chutkan agreed to and the final gag order that the DC Circuit approved?
Okay, I'm going to go off my recollection. I know one of the differences was him making threatening statements towards me personally was was allowed. I think in the district court in our application, we thought that shouldn't be allowed. I will share with you that I told my staff that it was much more important to me that he not be able to issue threats to court staff and my staff than me. And so the Court of Appeals did narrow it in that way. And as I'm sitting here now, I'm not debating you that they narrowed it. I just can't remember the specific details.
Okay.
But the phenomena, they concurred that the phenomena I'm describing to you today was real and
Okay.
had real world consequences.
18 United States Code 1512 deals with tampering with witnesses. Did you identify any violations of 18 USC 1512?
We did not bring any charges.
And did you allege that he violated any terms of his release?
We did not.
I want to turn to the member toll records topic. What's the difference between a subpoena for toll records and a 2703D order?
Well, a subpoena for toll records is non-content, doesn't have any content, doesn't have like the header of, say, an email, things of that nature. Whereas I think if I'm correct in the terminology, I think a 2703D would be regarding emails and what could have information like that.
Could have content?
Well, at least again, this is my recollection. I haven't looked at this issue in some time, but I think it means it's not content, but it could at least have, say, the header like of the message, like not the content of the message, but it might include the header.
Did you use any 2703D orders on members of Congress or senators or their staff?
I do not recall that at this time.
Did you use any pen registers? Like, maybe just walk us through what a pen register is and trap and trace.
Yeah, my understanding or my recollection is a pen register or trap and trace is a thing where you're watching who someone's calling going forward. Like, so, if there was a trap and trace on my phone, it would see going forward from today who I called. And a pen register, I'm mixing up the terminology, but one is like calls in and the other one's calls out.
Okay. And did you use any of those techniques on members of Congress, senators, or their staff?
I don't recall anything like that.
Okay. And when you say you don't recall, you think the answer is no, but you're not able to give a definitive answer?
Yeah, I have nothing in my memory that tells me that we did anything like that.
Okay. And so with the toll record, so as it relates to members and their staff and senators, it's just the toll records as far as you remember?
That's my recollection.
Okay. And
Well, I'm sorry to interrupt you.
Yeah.
Before I was special counsel, the people who were working on one of the investigations did get a search warrant for the cell phone of one Congressman
Perry. Yes, we are very familiar with that. With the toll record subpoena, maybe just walk us through like what you get. You get the incoming, the telephone numbers that call a particular cell phone, right?
That's correct.
And you get the time that the call occurred.
Yes.
And you get the length of time of a call?
I believe that's correct.
Okay. And you also get the list of numbers that the outgoing. You get the incoming and the outgoing, right?
That's correct.
And is there any other information that the toll record subpoenas provide?
That is the what I understand is the major thing you're seeking to get with the toll records.
Okay. And when you get one of these subpoenas, you just send it to the carrier, correct? Doesn't involve the judge.
The subpoena, yes, that's correct.
Okay.
Doesn't require a judge.
The only time a judge gets involved is if you're seeking a non-disclosure order, is that right?
If it's a subpoena for toll records, that's correct.
Okay. And do you always seek is it the practice of your team to always seek the NDO?
Well, in this particular case, there was a grave risk of obstruction of justice, given the obstructive conduct of President Trump as is set forth, for example, in the indictment in Florida. President Trump tried to obstruct that case in multiple ways. As I mentioned earlier, in the litigation we had regarding 57.2, we had numerous instances of him attempting to, in our view, intimidate witnesses or keep them from cooperating. And so given that reality, we did seek non-disclosure orders for the toll record subpoenas you're talking about.
Okay. And ordinarily, you just go to, how do you pick your judge for that when you're seeking the NDOs? Some of them were signed by the chief judge, and then others were signed by a Magistrate Judge David Baker, at least as it relates to the members. How do you pick the judge? Or do they pick it for you?
I don't know that we picked the judge. I have to say, in my role in this, I wouldn't have known that. I don't know that even a prosecutor can pick the judge, but
Okay.
I don't know what local practice in Washington D.C.
Okay.
would be on that.
I mean, sometimes I think Boasberg signed the NDOs for the senators, and then as it related to Speaker McCarthy and some of our members on the Judiciary Committee, it was the Magistrate Judge David Baker. And so you don't have any idea why
Well, a common practice in my experience as a prosecutor, certainly when I was a prosecutor in Brooklyn, is there'll be a duty judge or a duty magistrate, and so whoever has duty that day is who you go to.
Okay.
I just want to be clear, in this case, I don't have a recollection if that's how it works in D.C., but it may well have been that way.
Okay. And these NDO orders, at least the ones we've seen, they're all the same. Is that a fair statement?
I think they're usually very similar, yes.
Okay. And you submit a proposed order, correct, for the judge to sign?
That's correct.
And part of the language in this states that the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution, destruction of or tampering with evidence, intimidation of potential witnesses, and serious jeopardy to the investigation. Is that something you remember?
Yes, those are the, in the law, and the number is escaping me right now, but in the law that sets forth the reasons why you could get a non-disclosure order, I believe those are the different prongs, if you will, of that statute.
As it relates to members of Congress and senators and their staff, definitely their staff as well, I mean, that presents concern that we don't have an opportunity to, quash the subpoena. How does your office deal with that prospect?
Well, the nature, and I should also be clear that when you're getting an NDO, say for toll records, it's not based on an allegation that necessarily the person who has the phone number is personally going to obstruct the investigation. It's that if this gets out, people could obstruct the investigation. So I want to make that clear. Second point would be, you are correct in that inherent in getting an NDO is that at various times, people who might have arguments about why to quash a subpoena won't be able to make those arguments. In our investigation, this came up with Twitter. We wanted to get records from Twitter regarding President Trump. Twitter, and we applied for an NDO from the judge. Twitter refused to provide the records unless they could tell President Trump about that. And so we had litigation with this in the district court. The district court agreed that there are situations, and there was that Twitter argued that President Trump should be able to assert executive privilege over the records we wanted. And as a result of that litigation, the district court found that it was proper of us, given the level of obstruction in this case, to get that NDO. That decision by the district court was upheld by the Court of Appeals. And then that decision by the Court of Appeals, Twitter, my recollection is Twitter sought to get the Supreme Court to overrule that, and the Supreme Court refused to. And so I tell you all that to say,
And then you find them, right?
well, actually, that's before. They refused to comply even after she ruled, and she set a schedule of fines, and so part of the appeal was.
You sought the fines, right?
Absolutely, yes.
Okay.
But the point of telling you that was that inherent in an NDO is it may be that certain arguments about why a subpoena should be quashed can't be made. So that happens, and I think there's a parallel in those situations.
When it comes to members of Congress, though, there are the speech or debate protections, which you totally sidestep. I mean, the toll records provide enormous, valuable information because it shows who a member of Congress, who a senator is taking calls from, and who they're calling. And if you map it up against the Senate or the House calendar, you can see what the inputs are to their legislative decision making, which is at the core of speech or debate. Do you agree with that?
My office and I personally take the protections of the speech or debate clause seriously. I think they're part of our Constitution. They're an important part of separation of powers. I think our respect for the speech or debate clause is evidenced by the litigation we engaged in this office. We conducted litigation with Congressman Perry and also Vice President Pence, taking that very seriously. And I would just also add that my office had folks who were really the department experts on speech or debate. And when we sought these subpoenas, we got approval from Public Integrity, who are the sort of keepers of that issue. Yeah. And they concurred in us getting these subpoenas.
They did, and we saw some of that email traffic, and I would respectfully disagree with their view of the speech or debate law, as you might imagine. When you sought these non-disclosure orders, the judge didn't know it was a member of Congress. Is that correct?
I don't think we identified that because I don't think that was department policy at the time.
And you had some litigation substantial litigation with Congressman Perry over the seizure of his phone, but you didn't have any litigation with us over the seizure of members of the Judiciary Committee's phones because we never knew about it.
That's correct.
Sorry, I just want to clarify. I think you said regarding the seizure of any senators' phones?
Representative Perry had his phone seized.
Yes, but are you suggesting that there's a seizure of a senator's phone?
No.
Okay, I just wanted to clarify that. Thank you.
The only seizure I'm aware of is Congressman Perry. Do you know of any other seizures?
That's the one I recall.
Okay. So no other members of Congress, no other senator had their phone seized?
I don't recall.
Did you seek search warrants for the content of any, of the telephone calls or the content relies mostly to text messages? Did you seek a search warrant for the content of any text messages from members?
From members?
Yeah.
No, I don't recall
Okay,
that.
it was just toll records.
Correct.
Okay. But by not telling the members, by going through this NDO process, they didn't have an opportunity to litigate the speech or debate concerns.
That's correct.
And that's unfair, in our view.
I understand your position, and as I said before, we respect the speech or debate clause. I'm aware of no case in the Supreme Court or the DC Circuit that says that getting non-content toll records from a third party violates the speech or debate clause, particularly where, and I think an important point here is these records were not sought to use against members of Congress who were targets. The investigation we were conducting was President Trump and his co-conspirators, who were all obviously not members of Congress, but also private, not even members of the White House.
I mean, the House and DOJ has a big disagreement on this. I mean, the William Jefferson case, you familiar with the Rayburn House Office Building case?
I am.
Okay. And so when issuing grand jury subpoenas for toll records, do you consider yourself bound by that opinion?
Yes, but I would say that opinion does not deal, that is a case where there was a search warrant of a congressman's office. That congressman was a target of the investigation. The search warrant wasn't seeking non-content toll records. It was seeking the actual records, legislative material of the congressman to be used against that congressman.
Right. But, I mean, the court in the Rayburn case concluded that there is a documentary non-disclosure privilege, not just a prohibition on the evidentiary use of that material against members.
I'm not debating the Rayburn case exists. What I'm saying is in the Supreme Court or the DC Circuit, there is no case that says non-content. Rayburn dealt with content. Non-content records, not secured from a member, but secured from a third party, are subject to the speech or debate clause. And if I may, the correspondence we talked about, that reading, which was the reading of my staff who are very familiar with this, was consistent with the department's position on those issues, and public integrity, which was sort of the keeper of this issue, concurred in our getting these subpoenas.
We're making exhibit, we up to number 6?
Yes.
And this is some back and forth. What Exhibit 6 is going to be an email between your office and Public Integrity regarding the Senate, the toll records for the senators.
Thank you very much.
Thank you.
Thank you very much.
The relevant, these documents are helpfully not based.
Yeah. If you want to show me yours, I can look for it here.
Okay.
So the department has, if you're going to, has requirements for all prosecutors that, if you're going to bring a tax prosecution, you have to consult with the tax division, right?
Correct.
If you're going to bring a national security related case for classified documents, handling of classified documents, you need the National Security Division to okay that, right?
Correct.
And as it relates to, sensitive political matters, the Attorney General has to okay, and there's been a series of memos, both from Attorney General Barr and Garland and so forth, correct?
Sensitive political matters, I'm not sure if that's the terminology. There's an election year sensitivities memo, and there's also regulations, specific regulations for specific situations, yes.
Right, and the FBI calls it a sensitive investigative matter, and, they need to get they can't do anything without getting the director of the FBI to okay, getting search warrants against members of Congress and so forth, correct?
I'm not as familiar with the FBI regulations as the DOJ regulations.
But is public integrity, before you seek member toll records, is the hoop you have to jump through public integrity?
So it was for my office because I directed my staff to consult them anytime we were going to do that. I understand that was more of a practice and tradition. It's since become a specific requirement after these toll records were issued, but it was my policy to do that, and it was, again, consistent with my policy of wanting to sort of leverage the expertise in the department. So we did that.
Is this back and forth, and your staff had a memo that it, I think, basically put in email And then public integrity responds with this message. Is that essentially the extent of the back and forth with public integrity?
I don't know that this is the extent of it. There's a line here that says, "As you are aware," that makes me think that there was also a telephone conversation, but
Okay.
I don't, just to be clear, I don't have a specific recollection of that. I told my staff that in this situation, if we're going to seek these toll records, you need to consult with public integrity. As you can see from the email chain, I wasn't on that email chain.
Were there any other boxes you had to check? Did you have to tell the Attorney General or the DAG to get these toll records, or was it just you and public integrity?
My direction was to for our staff to go to public integrity. It may well have been that this is the sort of thing either I would have briefed the Attorney General on, or J.P. Cooney, who was our contact with the leadership of the department, may have told them about. But the thing that I was most concerned about was making sure public integrity, who was the sort of the experts on this issue, that they were consulted.
I mean, this isn't, if you look at the email, it's not that fulsome, right? It's not a complete analysis of the constitutionality or even the propriety of the call record subpoenas under the speech or debate clause. I mean, is that fair to say?
Yes, certainly there could be more analysis, but again, I don't know if there was an additional conversation that, it seemed, I'm drawing an inference, I don't recall this,
Right.
but this seems to me to indicate there may have been an additional conversation.
So the email, from our perspective, it seems to be a cursory litigation risk assessment. It's not, it doesn't raise the issues that we would raise if we were litigating the speech or debate matter. Because, I mean, our position is that the toll record subpoenas do violate speech or debate. I mean, if you get a list of all the people calling members of the Judiciary Committee before a floor vote, that is pretty core protected material. This back and forth with public integrity doesn't address very much. Is that fair?
Well, again, I don't know if there were additional conversation or conversations. I also don't know, frankly, if this is the only email on this issue. So I don't think I would call it cursory. I think an important context here is that the people involved in this, including the people on this email chain, as well as one of my senior counselors, Ray Hulser, who was really the department's expert on these issues, that these are people with expertise in this area discussing it with one another.
But if you believe what the Washington Post reporters wrote in their book, they say, according to their sources, that you were legendary for being dialed into, every last detail of these cases. That you were, they stopped short of calling you a micromanager, but they say that, you looked at, witness outlines, 2 days before witness interviews. Is that fair?
I did that with outlines of interviews, yes.
And you had, at points, you had daily meetings with the teams, and you wanted to know, every last detail of your case. Is that fair?
I try to be a responsible supervisor, yes.
But when it comes to taking the members of Congress, phone records, you weren't as plugged into that. Is that fair?
No, I don't think that's fair. I spoke with my staff about this. I ultimately approved it.
Right.
I had faith in the expertise of my staff. They discussed it with me. I felt there was a basis for it. I felt it was relevant and material to the investigation. And I also felt comfortable because I knew that my view about that would be tested by an analysis of public integrity.
Well, look at the last sentence. Low likelihood that any of the members listed below would be charged, and the litigation risk would be minimal. Not to mention, they're not going to know. So the assessment is, as Steve described, pretty cursory. We're not going to charge anyone. We're not going to get sued. They're not going to know. Who cares about speech or debate? That's what the assessment looks like to me. Your response?
Chairman, I would disagree with that characterization of it.
Well, that's what the sentence says. We're not going to charge these people. I doubt if they take us to court. It'd be hard for them to take us to court because they're not going to know for years that we did this. Move ahead. And you said fine to that.
I approve these subpoenas, yes.
Okay.
And, our view is this is inconsistent with the DC Circuit case law, which establishes that the speech or debate protections includes a non-disclosure privilege, period. It's not just a privilege against using that material against the members. It's also a privilege against taking that information and using it against a third party. If you're going to prosecute Jeff Clark with Scott Perry's phone records, we believe that the DC Circuit holds you can't do that. And this back and forth with public integrity doesn't factor that in. That's concerning to us. Did you have any discussions with the Office of Legal Counsel or the Solicitor General's office? Were there any other components in the Justice Department that analyzed this?
On this discrete issue, I don't have any recollection of those entities being involved in that discussion.
Okay. And there's a statute regarding Senate phone records. Are you familiar with 2 United States Code 6628?
Yes.
And did you analyze or factor in that statute before you issued the subpoenas for the senator toll records?
As I sit here today, I don't recall specifically discussing that statute. I will say that my reading of that statute as it existed at that time is that that was a statute directed at providers. It actually envisions that a provider might actually get an NDO application, and the provider who has the best information about whose phone line is whose, that they're best situated to make these judgments.
Okay, so that was my next question, is like, whose responsibility it is to flag that there's a statute, a law, that bars NDOs with regards to certain Senate phone numbers? Whose responsibility? Is that the Special Counsel's office? Is that the carrier? Is that the judge? Does the judge have to sort of figure this out? The magistrate judge? Certainly the magistrate judge doesn't have to figure it out like all on his own, does he?
Well, that statute, as I said, my reading of that statute, the language of that statute as it existed at that time, is that it's the job of the carrier, and to me that makes sense because they're the ones who have the best and most accurate information about whose phone lines are whose. They actually have that information.
Okay. But the package of materials that you send off to the magistrate judge or the chief judge, whoever the duty judge, as you mentioned, you don't identify that it's a Senate phone number or a member of Congress in those applications. So there'd be no way for the judge to know that there's these additional considerations. Is that fair?
I think that is fair. I think the department guidance on that issue has changed since these events we're talking about. And so
Okay.
now if one were to do that, you would notify the judge.
Okay,
But
and my time's up, so unfortunately I have to leave it there. We'll go off the record.
Mr. Smith, let's just start with the bottom line up front. One of your investigations focused on whether any person violated the law in connection with efforts to interfere in the lawful transfer of power following the 2020 election. Is that correct?
Yes.
At the conclusion of that investigation related to the interference in the lawful transfer of power following the 2020 election, when your office indicted Mr. Trump for his criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
For these charges stemming from Mr. Trump's criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to prove these charges beyond a reasonable doubt?
Yes.
And we know that it's more than just a reasonable doubt. Did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump after he attempted to criminally overturn the 2020 election?
I did.
Now, the second investigation that you were appointed to lead focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. When your office indicted Mr. Trump for willfully keeping highly classified docs after he lost the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
And for these charges stemming from when Mr. Trump left the office in 2021 with these highly classified documents, did you believe that you had sufficient evidence to prove the charges beyond a reasonable doubt?
Yes.
And did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump for his unlawful possession of these highly classified documents?
I did.
How many years of experience do you have as a prosecutor, Mr. Smith?
In total, I've been a prosecutor a little short of 30 years.
Can you give us a high-level overview of the different offices you might have worked in as a prosecutor?
Sure. I started my career as an assistant district attorney at the Manhattan District Attorney's Office in New York City. I prosecuted local crimes there for 5 years. Afterwards, I became a federal prosecutor in the Eastern District of New York, which is in Brooklyn and Long Island. And I was there for about 9 years. I prosecuted larger, more complex cases when I was there. I was eventually the chief of criminal litigation there. I left that office to go overseas and work at the International Criminal Court for a little short of 2 years. I coordinated investigations of the Office of the Prosecutor there. I then returned to the Department of Justice, where I was the chief of the Public Integrity section of the Department of Justice, and I did that for somewhere between 4.5 and 5 years. I left Washington, D.C. and moved to Nashville, Tennessee, where I was the first assistant U.S. attorney and then later the acting U.S. attorney in the Middle District of Tennessee, which is in Nashville. I left government for the only time in my career. I was worked for a private company for a brief period of time, a period of months, and then I was offered a position by the State Department to serve as a war crimes prosecutor at a European Union war crimes tribunal in The Hague, the Netherlands, and I was there for a little over 4 years before I became special counsel.
I'm sorry to interrupt. Can you just speak up a little bit?
Oh, I'm
I know-
sorry.
Yeah, the people in the back have trouble hearing you.
Sorry about that.
And can you describe the types of cases out of all these years of experience? Just give us a broad overview of the seriousness of the cases that you've brought in your career.
I've worked on all sorts of cases. Early in my career, I was a member of the offices in Manhattan, the domestic violence unit, and so I did a number of cases of people who are abusing domestic violence victims. Those are some of the most memorable cases in my career. I worked on gang cases, RICO gang cases, in the Eastern District of New York. I worked on the Abner Louima case, which was a assault of a Haitian immigrant by police officers. I did an international murder for hire case, other sorts of violent crime cases. I was one of the night of 9/11, I was part of the command center, and in the weeks afterwards, I was involved in responding to what happened on 9/11. After the Eastern District of New York, when I was overseas, I worked on war crimes cases that were in all sorts of different jurisdictions and all sorts of challenging investigative situations. And political corruption cases, obviously, when I was in public integrity and also in Nashville.
So taking all these cases you described, I heard cases about, gangs in New York, it sounds like there were war crimes cases, there were domestic violence cases you just described. Taking all that experience, when you finished your investigation in the special counsel's office, you believed that you had sufficient evidence in this case to prove Donald Trump committed those crimes after the 2020 election?
I did.
And you believe that you had enough evidence to get a conviction with Donald Trump taking or willfully taking the classified documents after he left office in 2020 and returned to Florida in 2021?
That's correct.
So we've heard a word a lot from this administration, from the majority Republicans, and that word is transparency. And yet, Mr. Smith, we're in a closed-door deposition today, meaning that members of the public and even congressional members and staff who are not part of the Judiciary Committee are not permitted to attend this proceeding. Did you offer to testify publicly before this committee?
Yes.
How did you offer, I guess, how did you make the offer to testify publicly to this committee?
I think it was through my counsel.
Did you send a letter to the committee? Did your counsel send a letter to the committee offering to publicly testify?
I think that's right.
We'll enter that letter into the record just for your background. And this will be Exhibit 7. It'll be an October 23rd, 2025 letter signed by Mr. Lanny Brewer and Mr. Peter Koski. It's addressed to Chairman Jordan and Chairman Grassley regarding Mr. Smith's public offer to testify publicly. Are you familiar with this letter, Mr. Smith?
Yes.
Can you tell us why you felt it was important to make a request for a public hearing?
I'm proud of the work that we did at the special counsel's office. I'm particularly proud of the people I worked with, the career public servants I worked with, who've been vilified by President Trump and people who work for him, and I think someone needs to speak up for them.
Did you want to testify publicly because you had something to hide about your investigation?
No.
Did you want to testify publicly to rebut some of these accusations from the president that you just mentioned about your investigation?
Yes, that's what I meant. Accusations not just against me, but against career prosecutors, career FBI agents who have served our country and who've been vilified wrongly. I think it's really important to correct the record on that.
Were you granted the request to testify publicly before this committee? The answer's probably obvious as we sit in this room, but were you granted that request?
No.
Were you given any reasons or provided any reasons why you were not allowed to testify publicly and directly to the American people?
I don't recall that.
Are you aware that even President Trump thought that you should testify publicly before our committee?
I heard that.
Yeah, just to make it clear for the record, Mr. Trump said, and this is a quote, "I'd rather see him," as in Jack Smith, "testify publicly because there's no way he can answer the questions." So let's turn to a few of those questions. Do you recall the October 14th, 2025 letter to you from Chairman Jordan requesting a transcribed interview?
I know he sent a letter asking for me to be interviewed, yes.
We'll enter that into the record and make it Exhibit 8.
Thank you.
And I'll give you a second just to look through it as we pass it out. So in this October letter to you requesting a transcribed interview, the chairman characterized your investigation as, quote, "politically motivated prosecutions of Donald J. Trump," end quote, and said you conducted a, quote, "unnecessary and abusive raid of the residence," end quote, of Donald Trump, and that claimed that you, quote, "manipulated key evidence in the investigation," end quote, among other claims. Do you recall these accusations to you in the letter from Chairman Jordan?
Yes.
The Republicans of our committee have made these letters to you public. You can read it on the committee's website, including these accusations that your office was weaponized. But this proceeding is behind closed doors, and Majority Counsel just warned you earlier about keeping the contents of this deposition confidential. Do you remember that warning that you received at the beginning of this deposition?
Yes.
So we will get into this in more detail later, but just to quickly touch on this, do you agree with the majority's characterization that your office was weaponized?
No.
Was your special counsel's office weaponized in any way?
No,
Did you conduct a politically motivated prosecution of Donald J. Trump?
I did not.
Would you like to have explained directly to the American people why these characterizations are not true?
Yes, and again, particularly as to the career prosecutors and agents who've been vilified.
Are you concerned that given that this deposition is not open to the public and the public cannot hear your answers or observe your demeanor or hear the way that you're responding to questions from the majority, that some of your responses may be selectively published or released in a way that mischaracterizes your answers?
I would hope that wouldn't happen.
But are you aware that's a risk of your testimony here today?
I'm sure that's possible.
Based upon your knowledge, is it generally the practice for the special counsel who investigated presidential conduct to be given the chance to testify at a public hearing to be able to explain their findings to the American public?
Yes.
So let's just take a few of those. Are you aware of special counsel Robert Mueller testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in July of 2019. Are you aware of special counsel John Durham testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in June of 2023. Are you aware of special counsel Robert Hur, who came up earlier in the majority's hour, testifying before the House Judiciary Committee?
Yes.
For the record, that occurred in March of 2024. Also want to touch a little bit on, speaking of just transparency and a fulsome investigation into this committee's request for documents related to your investigation. We're going to enter into the record another letter from Chairman Jordan. This one's addressed to Attorney General Bondi. This letter seeks records related to the Arctic frost files, and it's dated October 29th of 2025. This will be Exhibit 9. And you might not be familiar with this document, so I'll give you a second to review it. It's not very long, though.
Okay, I've reviewed it.
So after reviewing it, are you now aware that Chairman Jordan has sought the production of files related to your investigation from the Department of Justice?
Yes.
And just to read that request, it's request number 2. It says, in quotes, all DOJ documents and communications referring or relating to Jack Smith's special counsel investigation for the period of November 18th, 2022 to January 20th of 2025. I just want to get a better understanding of this broad request of all DOJ documents and communications referring to your investigation. I guess what types or categories of documents are associated or would be associated with your investigative files?
There would be numerous documents. I mean, it was a prosecutor's office, so the sort of documents you would associate with a prosecutor's office.
Just to make it clear for the record, can you just give a few examples of what those records or memos might look like or what they might be about?
Prosecution memos, email correspondence with my staff, analysis of the case, things of that nature.
Would these documents include internal decision memos or other records of major decisions made by you and your team during the investigation?
Yes.
Do these files include communications with the Attorney General or the Deputy Attorney General during the course of your investigation?
I don't think I had any files that would fall into that category. I'm not sure if there'd be, my deputy also communicated with the Deputy Attorney General's office, so there may be, but I don't think that's to me.
Do these files include communications just with other DOJ offices? I think earlier you mentioned possible communications with the Solicitor General. Would those files include possible communications with that person?
Yes.
Could I just follow up on that for 1 sec?
Sure.
You had no communications with the Deputy Attorney General?
No, I took the question to mean in terms of like email or things of that nature. We met, I met with the Attorney General, the Deputy Attorney General, at times at their request. So those things did happen. I'm just saying I don't recall me having any sort of email communications with either of them.
But in terms of the special counsel offices, just following up Mr. Golden's question, the office as a whole, if there were email communications between members of your team and the Attorney General or the Deputy Attorney General, would that probably be a part of your special counsel case files?
Yes.
And as far as you're aware, the current Department of Justice has full access to your documents and memos and files from your investigation, is that correct?
They should.
In fact, you reviewed those files in preparation for your appearance today, right?
Yes, we were given access to a computer that had files on it. I can't say that it's all the files, but we were given access to that, and I reviewed that in preparation of today.
Did you follow DOJ protocol in your decision-making, including consulting with relevant offices like the Public Integrity Section, the Office of Legal Counsel, and any other entities as required and encouraged by DOJ policy?
Yes.
Were there examples where these consultations were memorialized in writing, either before or after you met with these offices?
Yes.
So given the majority's claim that the investigation was biased, do you think the case files would help eliminate some of the majority's questions about the actions you took while special counsel?
I have no objection to people looking at the case file.
To your knowledge, has DOJ released all the special counsel's files, either to Congress or to the public?
I don't know what they've released to Congress.
Do you believe it's in the public's best interest to view the full case file rather than just selective samples as they've come out so far?
The reason I'm pausing is I'm not sure it's proper for me to weigh in on that. I don't know if there are, for example, confidential information regarding witnesses that shouldn't be made public. And so I think that's a matter for others besides me who have the case files in their possession now to review and decide.
So let's just narrow it a little bit. Do you think it would be beneficial for the committee to review the case files so that we can understand why certain investigative steps were taken?
I'm going to leave that to others to decide. I'm here and I'm happy to answer any questions you or anybody else might have.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened.
It never happened.
I also just want to note the authorization that you got from DOJ, and I think this is marked as Exhibit 2. No, sorry, Exhibit 3 by the majority. It was quite broad, right?
Which one is this now?
This is Exhibit 3, a letter from the Department of Justice to your counsel.
I have my own copy.
Apologize, we've got a lot of letters here, so.
Take your time.
Just don't have a lot of evidence
Here you go.
that's been disclosed.
Okay, I have the letter now,
Okay,
yes.
so I'm looking at page 3 on the bottom, but this letter essentially walks through a series of topics that you are authorized by the DOJ to discuss.
Correct.
Okay. So on the bottom of page 3, I'm reading here from the letter. The extraordinary events underlying this matter constitute exceptional circumstances warranting an extraordinary accommodation to Congress in this particular case. Given these extraordinary circumstances, to the greatest extent allowable by law, the department authorizes Mr. Smith to provide unrestricted testimony to the committee, irrespective of potential privilege, including the names of line attorneys and agents in the department as it pertains to the matter identified in this letter, and as limited in paragraph 1 through 5. And the paragraph 1 through 5 essentially goes through the investigations that you undertook and I guess a couple of tangential matters related to the Office of Professional Responsibility and the Arctic Frost investigation. Is that correct?
That's what that says, yes.
Okay. So given that DOJ gave you unrestricted or authorization to provide unrestricted testimony, would it make sense that DOJ then should also give this committee unrestricted access to the case files that's currently in its possession?
I'll leave it to others to decide that. I will say that the paragraph you read is different than it's been with past special counsel. Past special counsel usually testify about the contours of their report. They've changed the process here, and I'm still here willing to answer questions.
Okay, thank you.
We're gonna, I believe we're on Exhibit 10 now. We're gonna move on to Exhibit 10, which will be your Special Counsel Report, Volume 1, dated January 7th of 2025. I know this is a document, I know this is a document you're very familiar with, but we'll pass it around. So as the date of your report says, on January 7th of 2025, and as your time as special counsel was coming to an end, you provided a final report to the Attorney General where you explained the prosecution and declination decisions that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this final report an accurate account of your investigation and its findings?
It was.
Based upon your understanding, is it generally the practice for a special counsel's report to be made public to the American people?
I believe so. I know at times they've been, portions have been redacted in the past, but my general understanding is yes.
So to the best of your knowledge, do you recall Special Counsel Mueller's report being made public?
It was public, yes.
To the best of your recollection, do you recall Special Counsel Herr's report being made public?
Yes.
To the best of your knowledge, do you recall Special Counsel Weiss's report being made public?
I don't recall. It may be, I don't know.
Was your report made public in full?
This report as to the elections case, I believe it was made public.
Did you have a separate volume or a volume 2 of your report?
That's correct.
Was that made public?
No.
Touching on volume 2, in your letter to the Attorney General, you also recommended that volume 2 of this report, which discusses the classified documents case, not be publicly released while the cases of Mr. Walt Nauta and Mr. Carlos de Oliveira remain pending. Do you recall saying that in your letter to the Attorney General?
That's what's in the letter, yes.
Can you explain, please explain why you included that recommendation?
When, as special counsel, when you draft a report like this, it's not for me to decide whether it gets made public or not. It's for the Attorney General, and it's for him to also to decide what portions, if any, get redacted in that. And so what I stated was my, in essence, recommendation that it should not be public because these cases are pending and there are facts in here that it might not be fair to have that be public while they have charges pending against them.
Understood. So other than the fact that the cases of Mr. Nauta and Mr. Oliveira were still pending, as you just discussed, did you have any other reasons to believe or to recommend that volume 2 of the report should not be publicly released?
Well, again, that wasn't my choice. My choice was to write a report for the Attorney General to make a decision about whether it would be public. I have no objection to it being public, and I didn't then, as long as it complies with the law in terms of 6C and other issues like that.
Yeah, but just going back to that recommendation, in making the recommendation in the letter that it not be made public, understanding that it's the AG's decision to release the report, did you have any other reasons for making that recommendation other than the ongoing cases of Mr. Nauta and Mr. Oliveira?
I'm sorry, I misunderstood your question. No reason other than that.
Is there any other reason right now, since Mr. Nauta and Mr. Oliveira's cases are no longer pending, is there any reason now that you can think of, other than Judge Cannon's order, where volume 2 of the report should not be released?
Judge Cannon's order is the reason.
Excuse me, can I jump in? Do you know who was responsible? Did you dismiss the Nauta and Oliveira cases?
No.
Do you know who dismissed them?
I don't recall, but I imagine it's a matter of public record.
If I told you that it was after Donald Trump was inaugurated, would you agree with that?
I don't recall, but if that may well be true.
For the purpose of this remaining conversation, since that's a publicly identifiable fact, I will represent to you that it was done by the Trump administration. You charged that case, correct?
Correct.
You went through your extensive experience as a prosecutor. Do you believe that Mr. Nauda and Mr. Oliveira were guilty of the crimes that they were charged with?
Yes, we believed that we had proof beyond a reasonable doubt for all the charges and that we would have gotten convictions at trial, yes.
And are you aware of any reason within the rules, protocols, and regulations of the Department of Justice that that case should have been dismissed?
In my view, no, it shouldn't have been.
Real quickly, before I turn over to Mr. Jayapal, are you able to speak about Volume 2 today?
I'm not.
Can you explain what you can and cannot speak about with respect to Volume 2?
Well, there is an order of Judge Cannon, an injunction regarding Volume 2. I want to make very clear that I do not want to do anything to violate that injunction or that order. And so, given that I have not seen, looked at Volume 2 since I submitted it to the Attorney General almost a year ago, I do not have a exact recollection of what is in there and not. And so, unless something is in a public filing, or, and people can point me to a public filing, or in, I think, the category that was mentioned in the letter that we got this morning of publicly, I can't remember the terminology, but properly publicly released information. I do not want to, I want to be clear, I do not want to violate that order, and I don't want to do anything that could even be remotely construed as violating that order.
Wait, so, I'm sorry, but DOJ did not let you review Volume 2 of your report?
It may well have been there, but I chose not to review it because I didn't want any implication whatsoever that I was somehow violating the order by looking at it, not being a member of the department now.
So before we go to Ms. Jayapal, I just want to clear up two things. One, so you've been an assistant DA, you've been a federal prosecutor, you were an international criminal court prosecutor, you were the chief of the public integrity section at DOJ, and you were first assistant U.S. attorney in Nashville and the acting U.S. attorney. Do you have any idea how many cases you've actually handled and prosecuted?
That I've handled or supervised others handling, I'm sure it's in the thousands.
In the thousands, okay. Have you ever been prosecuted for selective prosecution, vindictive prosecution, or partisan discrimination?
Never.
Have you ever fired a prosecutor because they refused to engage in a prosecution on grounds that there was not sufficient evidence?
No.
Okay. And in all of the cases that you have supervised and prosecuted yourself directly relating to domestic violence, relating to conspiracy, relating to murder, relating to war crimes, have you encountered the problem of witness intimidation?
Very much so.
Will you speak a bit about the problem of witness intimidation and what that does to the rule of law and justice?
Witness intimidation is probably the most corrosive thing that can happen to the rule of law. And that is why, as a young prosecutor, you are taught to move your cases expeditiously, because you know that if there is someone trying to obstruct your case, the longer they have to do that, the more they can subvert justice. And I've worked on a number of cases. I've worked on murder cases where witnesses were murdered. I've worked on cases overseas involving very serious witness intimidation and obstruction of justice. And as I mentioned earlier, this case as well. And so that was foremost in my mind as we were conducting these investigations, but it's something I've encountered in different contexts throughout my career, even back to those domestic violence cases that I started in earlier in my career. Attempts to threaten or influence those witnesses are a way to subvert justice.
So what kinds of actions and precautions can you take as a prosecutor to prevent it and to try to protect witnesses against intimidation and violence?
So depending on the situation, there would be different sorts of steps that you could take. Obviously, if it's an imminent threat, like someone's coming to kill the witness today, you try to move them and protect them for a period of time. But if it's a more pervasive threat, where a defendant or people on his behalf are issuing statements and issuing threats, trying to get people not to cooperate with your case, or trying to make an example of people who have cooperated with your case, the best thing you can do is limit their ability to make those threats and shorten the time they have to make those threats.
Thank you. Let me go to Ms. Jackson.
Can I just, one thing on volume 2 before we go? It's obviously a case related to classified documents. Without getting into the detail, how was it how was it written? Was there an unclassified portion and a classified portion, or is the classified material interwoven in the volume?
I don't think I should even talk about that. I don't want to have any implication that I gave some sort of insight about how that report is constructed. And so I don't really think I could speak about that given her order.
Can I ask you this question? Is it possible to release parts of that report while also protecting classified material?
I very much want to answer your question, but I don't want to say anything that will imply what is in the report, and so unfortunately, I don't think I can answer.
Okay, Dan, I'm going to go to Ms. Jayapal. We'll come back to you. Yeah.
Thank you. Mr. Smith, I want to get to questions of transparency again, but I want to pull out to a bigger question. Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic.
You stated in your testimony in the first hour that you've tried to be as transparent as possible with the American people about your investigation. The chairman of the committee has repeatedly put out that you were subpoenaed for your testimony today, and in fact you are here under a subpoena, but you had requested to appear voluntarily in a public hearing. Is that correct?
Yes.
And why were you willing to appear voluntarily in a public hearing?
We conducted our investigation in a way that I'm proud of. I'm particularly proud of the people I conducted the investigation with, and I wanted to speak for them.
And is it generally the practice of special counsels to appear in a public hearing? I know you have a couple of questions on this, but I want to reiterate this.
That is my general understanding, yes.
And can you tell us again why I understand you want to stick up for the prosecutors, the people that were part of the investigation. Can you tell us why it's important for the American people to hear directly from you about your investigation, what you discovered, the process that you went through?
Well, as I said in the beginning of, I think, in my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Yeah. Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
Yeah.
I just don't know where that goes. It's counter to how I was raised.
And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
Can I jump in really quickly, just on the witness intimidation issue? As I understand it, you were asked a lot of questions about filings that your office made as it relates to trying to protect witnesses, specifically the gag orders. Do you have any regrets about the steps that you took as it relates to seeking gag orders against this defendant in an effort to protect witnesses?
Our applications for orders limiting Donald Trump's ability to intimidate witnesses, intimidate court staff, intimidate my staff, I have no regrets about that.
Dovetailing on that, have you only been further convicted in the decisions that you decided to make as it relates to that in watching some of the president's actions even in present day?
I think the record of our case speaks for itself on these issues.
Could I just follow up on the gag orders relative to the defendants? In every case, a judge decided that that was warranted, correct?
In the cases in the District of Columbia, a judge
Correct.
did decide that, and the Court of Appeals agreed. They narrowed the order, as I said earlier. In Florida, we applied for an order because of statements Donald Trump had made that I viewed endangered FBI agents. That hadn't been decided when the case was dismissed.
Thank you.
And just to kind of finish up on this point, you yourself, I'm not sure if this was discussed by the majority, but have you yourself been intimidated as a result of the actions that you took in this case?
I'm not going to be intimidated.
Have you been threatened?
Yes.
Have you learned of other persons, whether they worked under you as attorneys or other support staff? Are you aware of any threats that have been made against any of them?
Yes.
And, okay, I'll stop there.
Mr. Magoo?
Thank you, Mr. Smith. I really have two questions. First question, which our counsel ably covered, just so we're clear, you wanted to testify publicly today, correct?
Yes, I was willing to.
And Chairman Jordan declined that opportunity, correct?
Yes.
Any thoughts as to why Chairman Jordan is scared to have you testify in public?
I'm not going to characterize the chairman's decision. I offered, he decided that we would do it in this setting, and that is what it is.
Well, I think Americans who review this transcript, once it's concluded, will understand why. If you have any questions.
Marcus, let's come back to you.
Okay, thank you, sir. I'm going to switch gears a little bit to your appointment as special counsel. Do you recall when you were appointed as special counsel?
Yes, it was November, I believe, November of 2022.
Does November 18th of 2022 sound right?
That sounds about right.
Do you recall the day that Donald Trump announced his candidacy for the 2024 election?
I believe it was shortly before that.
So who offered you the position of special counsel?
The Attorney General.
And what was your understanding of why the Attorney General felt it was necessary to appoint a special counsel in this circumstance?
I believe the Attorney General made a public statement about why, and that public statement is my understanding.
We can maybe enter that public statement in a little later, but what did you understand the scope of your investigation to be specifically when you were appointed?
The scope was defined by the appointment order, which encompassed the two investigations that I've referred to today.
And can you just make the record clear again, just briefly describe those two investigations and then appointment order?
Sure, and I don't have the order in front of me, so just generally.
Actually, so we'll make that an
Yeah.
exhibit. We'll make it an exhibit. Let's make the appointment order an exhibit. And this will be exhibit 11, I believe. Make it easier just to refresh your
Sure,
recollection.
thank you.
So after you've taken a minute to review it, and please take your time, the question will be, what did you understand the scope of your investigation to be?
Okay, so consistent with this order, the scope was two investigations, both of them ongoing at the time. The first was an ongoing investigation into whether any person or entity violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on or about January 6, 2021, as well as any matters that arose or might directly arise from this investigation.
Do you know why, or have you heard why the Attorney General chose you to be the special counsel?
Why he chose me?
Yes.
No,
Okay. At the time of your appointment, I understand you were living in the Netherlands, is that correct?
that's correct.
Did you lobby for this position?
No,
Did you petition the Attorney General to be the special counsel?
I did not.
Did you reach out to any former colleagues of the Department of Justice expressing your interest in being the special counsel?
I had been in contact with a former colleague by the name of Marshall Miller. He had returned to the department sometime that summer, and I had spoken to him and expressed to him an interest in, if there was the right position, returning to the department.
Ultimately, why did you accept the special counsel position?
Because I thought I was the right person for the job. I knew that this would be a challenging job. I knew it would be a job where whoever held the job, or whatever decision they made, somebody would want to attack them for that decision. And I felt that given my nearly 30 years as a prosecutor, it made me uniquely qualified to do the work.
Did you have any reservations about accepting the special counsel position?
No?
There were a lot of attacks on you shortly after you were named and throughout the time as special counsel. You said earlier, I think you used the term intimidated. I guess, how did you move forward consistently with those attacks while special counsel?
I think attacks and praise are noise, and as a prosecutor, I've learned to tune those things out. I'm more concerned, again, about the attacks on my staff. But for myself, I understand that that's can be part of the work at times.
Did you accept the role, as some have suggested, because you had animus towards President Trump?
No.
Did you accept the role, as some have suggested, because you hoped to influence the 2024 presidential election in favor of the Democratic nominee?
No.
Did you accept the role because you thought it would help the Democratic nominee by prosecuting Donald Trump before the election took place in 2024?
No.
Let's consider the same facts related to the attack on the Capitol on January 6th or the mishandling of classified documents. So that's the facts that we're going to consider here. Take the same facts but insert a president who was a Democrat. Would you have still accepted the role of special counsel?
100%.
Considering the same facts, so the same fact pattern of the attack on the Capitol on January 6th, the same facts of unlawfully taking classified documents after leaving the White House, would you still have accepted the role of special counsel to investigate former President Barack Obama?
Yes.
Again, considering the same facts, would you have accepted the role of special counsel to investigate former President Joe Biden?
Yes.
Looking back, and you've talked about the investigation steps that you've taken here in the deposition today. I think I've heard you talk about, process of an investigation and how that's important. Would your investigative process have differed if the President of the United States would have been a Democrat?
No.
Someone have a follow-up on that?
Yeah. I served on the January 6th Select Committee, and we spent a lot of time looking through the criminal statutes that may have been implicated in the attack on the peaceful transfer of power, the attempt to overthrow the election, and then the violent assault on the Capitol. And we, in our conclusions, cited a number of statutes which ended up, I think, being part of your investigation, including conspiracy to obstruct a federal proceeding, conspiracy to defraud the United States, false statements, and so on. But you added something which I think was very interesting, which was a conspiracy to violate voting rights, which is something that we hadn't done. And I wonder if you would take a moment to expound on why you thought you had sufficient evidence to prove beyond a reasonable doubt that there was a conspiracy to violate the voting rights of the people.
Sure. The right to vote in a presidential election is one of the most sacred rights that Americans have. And in this particular case, we had strong evidence that the defendants in this case sought to interfere with, obstruct, injure that right. We had evidence, and just a couple examples, where President Trump was asking local officials to find 11,000 votes. When you find 11,000 votes, you're diluting other people's votes. We had evidence that they were targeting certain states and particularly certain parts of certain states, generally urban parts of states, to have those votes thrown out with no factual basis whatsoever. I believe we cited this in our final report, but there's even statements of the co-conspirators in this case, at least one it's coming to mind now, specifically saying we want to get rid of these votes. We want to subtract them. And diluting the vote count in that way, there's strong precedent for that being a violation of the statute that we charged.
There were 60 federal or state court decisions rejecting claims of electoral fraud, electoral corruption that had been brought by President Trump or his teammates. To what extent did that figure into your analysis of that problem?
Well, the lawsuits, we made clear in our indictment that there are proper ways to dispute an election, and asking for an audit, which President Trump did, and I believe in only 2 of the states that were in question, that's a way you can do that. Filing lawsuits, completely legal and proper way to do that. But in this case, those lawsuits were part of our proof that put President Trump and his co-conspirators on notice. The suits, the results, and the things that court said in finding those suits without merit were one component of evidence that put him on notice that these allegations were false. Also, there were instances where there were pretextual lawsuits. There was one lawsuit, for example, that was filed in New Mexico minutes before the deadline, so they could say there was a dispute in New Mexico so they could proceed forward with the fake electors ballot. There was another lawsuit in Georgia where one of the co-conspirators explicitly said in an email, we're on notice that the things in this lawsuit aren't accurate, so we shouldn't have the president sign a certification of this lawsuit. And then they played with the language a little and had him sign a certification nonetheless. And so these lawsuits, well, filing a lawsuit absolutely clearly is something you can do. They were probative evidence of the criminal intent in this case for those limited reasons I just suggested.
Can I go back to volume 2 just for a second? You said that the department gave you access to volume 2 and you chose not to use it?
That's correct.
Did,
I believe so. I did not, given the injunction, want to look at that. And so I believe it was there, but I was looking at other things. I didn't look at that.
Did they give you access to any classified information that was a part of your files?
No.
Did you or your attorneys have any discussions with the department about that?
I don't recall.
Do you still have your security clearance?
No.
When and how was that taken away?
I think in the normal course of things, when you leave government service, you sign papers basically saying you don't have your security clearance anymore. It's vague, but that's my recollection of what happened at my conclusion of my service.
Do you know if your attorneys requested for you to have temporary security clearance so you could review your own files?
I don't believe we did.
And because you didn't look at the volume 2 that they provided to you, you don't know whether or not classified material was provided to you in that volume?
Again, I don't want to speak about anything that could infer the content of volume 2.
When you provided volume 2 to the Attorney General, did you provide proposed redactions?
I believe we did, but I believe we did.
And the redactions were?
But I just want to be, I'm sorry to interrupt you, sir. With the understanding that it was ultimately the Attorney General's decision whether to make it public, whether to do redactions, things of that nature.
And what were the nature of your proposed redactions?
I don't recall as I sit here now.
Was it related to the classified information?
I don't recall. It could have been 6E, it could have been things of that nature.
Did you make proposed redactions because of your concern at all about the ongoing case against Nauda and Oliveira?
I don't recall that, but I can't be conclusive. I really don't have a good memory of the subject.
Thank you.
I'm curious, shifting gears just a little bit. When you first sat down, the majority was asking you questions that seemingly were tied into the general duties of a prosecutor, and your resume has been laid out. It is interesting, or at least it was interesting to me, to hear the majority characterize who should be prosecuted under the current circumstances. I'm not sure if you've followed along, but are you aware that under this DOJ, they have indicted Tish James as well as they ultimately indicted James Comey? Are you aware of that?
I am.
And are you also aware of the fact that this DOJ has consistently dismissed members of the DOJ for refusing to bring forth indictments that they don't believe have merit?
Yes.
The majority was asking you about why it is that you characterize your belief that there was guilt as it relates to the indictment that you sought. As a trained prosecutor, typically, are you supposed to go after people that you don't believe are actually guilty?
I'm trying to, there's a couple of negatives in that question.
I know.
Yeah.
They were trying
You're
to.
not supposed to go after people who you believe are not guilty.
Okay, thank you. In your experience of 3 decades, have you ever needed to seek the same indictment 3 times while being rejected?
Never.
Okay, I think that's all I have for that.
Have you ever prosecuted someone that you did not believe was guilty beyond a reasonable doubt?
Never.
As we hit, I know we're getting close to the end of our time. I want to hit on a few questions. And I apologize if they come off as very obvious to you with your experience and the way that you conducted yourself with the Department of Justice. Did Attorney General Garland or other DOJ officials direct investigative steps within your office of the Special Counsel?
No.
Did Attorney General Garland or other DOJ officials direct litigation decisions within your office?
No.
Did you experience Attorney General Garland or other DOJ officials interfering with your ability to conduct this investigation?
No.
Did President Biden ever give you any instructions about what you should or should not do related to these investigations?
No.
Did you ever speak to President Biden about these investigations?
No.
I think Mr. Moskowitz has a question.
Thank you, Ranking Member. Do you know the definition of retribution? Webster's definition? It's a noun.
Off the top of my head, I do not.
If I proffered that it was exacting a punishment against someone, would that sound about right?
Yes, and yes,
Your lawyers lost their security clearance, is that correct?
yes,
People who worked under you were fired, is that correct?
that's correct.
You're here today on a deposition that Sherman has brought you into, but I wouldn't give you a public hearing, is that correct?
Yes,
Did you see the comments by the President's Chief of Staff talking about retribution?
I did.
So, everyone was fired. You're here on a deposition. Your lawyers lost their security clearance. It seems like it meets not only the definition in Webster, it seems like this is exactly what Trump's Chief of Staff was talking about. No?
I have no doubt that the president wants to seek retribution against me. I have no doubt that that's the intent.
I don't want to put you off. In
Yeah.
fact, the exact quote was, he doesn't wake up thinking about it, but when there's an opportunity, he goes for it. I mean, this seems like a opportunity. Do you think the White House gave instructions to Chairman Jordan to set this deposition?
So I am eyes wide open that this president will seek retribution against me if he can. I know that. I don't frankly connect that with this hearing. I don't have any connection. I came here, I was asked to
No,
come
you
here.
think there were 0 conversations between the White House and Chairman Jordan?
I don't know, but I'm here in good faith, and I was asked to come testify. I
What's the
offer-
likelihood that there were less than 0 conversations between the White House and Chairman Jordan?
I'm not going to speculate on that. I will say I agree that this department wants to seek retribution against anybody who worked on cases against President Trump. I just don't have any evidence
Why do you think
that
the Chairman wouldn't give you a public hearing?
that's not for me to say.
I want to go back to your testifying that in every case you've ever brought, you've believed that there is proof beyond a reasonable doubt to demonstrate that the defendant is guilty. I'm not sure it would be even ethical to bring a case if you didn't have that belief. But is there anything inconsistent about having that belief that you can sustain the prosecutor's burden of showing beyond a reasonable doubt all of the elements of the crime are satisfied, and also wanting to see that constitutional due process is observed in the trial? Is there any conflict between those two?
I don't see one.
In other words, as a prosecutor, you go in with the belief that you can make your case, but you also want to make that case within the rule of law and within due process. And you've never experienced that as a problem, right? You've never wanted to trample the rules of due process in order to convict someone.
That's correct.
Okay. Mark, back to you.
I just wanted to piggyback on something that Ms. Crockett brought up earlier, but are you familiar with Justice Manual 927-220?
You're going to have to give me more than the number, I think.
All right. So that provision basically states the condition with which a prosecutor can commence or recommend federal prosecution. And I can quote from that section for you. It says, prosecutor may commence or recommend federal prosecution only if he or she believes that the person will more likely than not be found guilty beyond a reasonable doubt by an unbiased trier of fact, and that the conviction will be upheld on appeal. So does that sound familiar to you?
Yes.
Okay. Did you follow this provision when you indicted President Trump in the election interference case?
Yes.
And did you follow that provision when you indicted President Trump and his co-conspirators? Oh, sorry, no, just President Trump in the classified documents case?
Yes.
And his co-conspirators? Did you
In
follow
that case, yes.
Okay. And the majority in their hour questioned you about why you included conduct that has not been found, that has not been brought forth before a trier of fact, right? That has not been proven in a court of law. But aren't you just essentially restating the standard that was that's stated in Justice Manual 927-220?
Yes, with our report, I wanted to explain my prosecutorial decisions, why we made them, the basis for them, and that's why we wrote the report the way we did.
Thank you.
In my last few minutes of our hour, please bear with me as I go through these next questions. There's a lot of inferences and accusations being made about your bias as a special counsel's office, and I want to make sure that we rebut these in the first hour. I think it's important too. So, did the Attorney General or any other DOJ official ever press you to be more aggressive in your investigation of President Donald J. Trump?
No.
Did the Attorney General or any other DOJ official ever suggest that you were expected to bring charges against President Trump?
No.
Did anyone from the White House, including President Biden, ever tell you they expected you to bring charges against Donald Trump?
No.
When you eventually did bring charges against Donald Trump, how did you make that decision? Walk us through it at a high level, if you don't mind.
Sure. It was based on the facts and based on the law. I ultimately made that decision, but I consulted with my team of prosecutors on that case, who were outstanding public servants, people with great experience in complex investigations. I took their advice and counsel in making that decision, and I tried to consider all factors, including both the strength of the case that we believed we had, possible defenses, all things of that nature.
So which based on what you just said, it sounds like you made this prosecution decision based on the evidence in the law. Is that correct?
That's correct.
What would you have done if you felt any improper pressure from a DOJ official or the White House?
I think people who know me and have known my reputation would know that that would not end well. If someone tried to pressure me to move a case in one direction or the other or wasn't supported by the law, I wouldn't stand for it. And I would also say the people who worked in my office wouldn't stand for that either.
Yep, we're at our hour, so we'll end there. Thank you.
Mr. Jordan, you're gonna start with some stuff?
Mr. Smith, who's Marshall Miller?
Marshall Miller was a prosecutor I've worked with.
And, well, let me go back to last hour. You said, the Democrats, I believe, asked you whether you lobbied for the position. And you said you didn't, but then you followed up and you said you made a call to the Justice Department, someone you knew there, and I think I got the quote right. You said, if there was the right position, I would be interested. What was the right position you were talking about?
If I could take you back, Marshall Miller is the person I was talking about.
Well, that was my next question.
Yeah, I learned that he was returning to the Department of Justice. I was still overseas at this point in my State Department position. I reached out to congratulate him about coming back to the department.
And what position did he have at the department?
He was a senior position in the Deputy Attorney General's office. I'm not sure I'm going to get the exact title right, but it was a senior position in the Deputy Attorney General's
My
office.
understanding, he was Principal Deputy Attorney General, number 3 position.
That could well be.
Okay, so you called him and you told him what?
Well, I initially called him to congratulate him on coming back to the department.
Okay.
And at some point, I told him that if the right position came up, I would be interested in returning to the department.
And what was the right position?
I wasn't specific about it. I just told him if the right thing came up to sort of keep me in mind.
What did you have in mind? Do you want to go back to running the public integrity section?
So
Do you want to be a line lawyer? What do you want to do?
what I recall is right around then, there was a domestic terrorism unit being set up. And I don't know if I shared that with Marshall, but that idea that was being set up, I was interested in things like that, but I didn't have a specific,
When did the call take place?
well, it wasn't, I'm not going to remember specific conversations. I know shortly after he returned, I reached out to congratulate him on returning to the department. At some point, I don't know if it was then or in a call after that, I said if the right position came up, I would be
And so
interested.
you're saying today, you were in no way referencing what many assume might happen, which would be there be a special counsel looking into President Trump. That wasn't on your mind. You weren't anticipating that.
When I told him I'd be interested, no.
Okay. Let's go back to where we left off in our first hour with the toll records. So you seem to indicate that you felt the burden was on the carrier to comply, and that you felt that was consistent with the statute that applies to the United States Senate. Did you feel like you had a burden at all to tell, to let the carriers know that we in fact are looking for toll records for numerous United States senators?
I'm sorry, sir. Which statute are you talking about?
The statute applies to the Senate, where you reference that you think the burden is placed on the carriers to deal with this issue with senators, done by the House, but the senators. In our first hour, you said the burden's on them to, if they're going to let the Senate know that their toll records are going to the government, the burden is on them. And I'm just asking, do you feel like there was any burden on the prosecutor, on you, to tell, to make that public?
To make that public?
Not to make it public, to let the carriers know, we are in fact, make it public to the carriers, we are in fact asking for toll records for United States senators.
Sir, I don't recall discussing that particular statute. I may have. What I meant to communicate was that reading that statute as it existed at the time, reading it now, it's clear to me that the process that was envisioned.
So you didn't know about the statute back when you requested the tolls?
I do not recall discussing this statute. I can't recall if I knew about it then or not.
Okay, there's definitely a burden based on what the Justice Department is now gonna do and move forward. There's definitely a burden now, but you didn't think there was any type of burden for you to let the carriers know, these numbers we are giving you are numbers for, excuse me, for United States senators.
As you referenced, the statute has now been changed. And before that change, My understanding is that the statute directed carriers to do this analysis, and in fact envisioned that carriers might get.
So there's no
NDO
burden on you?
applications.
No burden on the prosecutor? That's what I'm getting at.
My reading of that statute as it was drafted at that time is there was not.
Okay. And you ran the public integrity section back in your days at Justice Department, is that right?
Correct.
Did you ever get requests for toll records for this internal analysis that you think was, as Steve said pretty cursorily, did you ever get requests for members of Congress or United States senators, their toll records?
It was some time ago. I'm sure we may have. As I sit here now, I can't remember a specific instance, but I'm not saying.
How long were you head of the public integrity section?
I was the head from May of 2010 until it was either January or February of I believe 2015.
Okay, 5 years, and in that time frame, you don't know if you can't recall, you may have, I think I'm gonna be fair to you, that you don't recall any request for the toll records of members of Congress or United States senators.
Well, I'm saying we may well have, and
Okay.
that may well have happened. I just, as I sit here right now, don't recall a specific instance of that. I'm not denying that that happened.
Okay.
Once the department gets the records, what does it do with it? I know that the FBI has something they call the Cellular Analysis Survey Team, CAST. But do you know what happens with the records once they get them?
The analysis, like how they do the analysis.
Like, what do you do with the records?
That would not be in my area of expertise, how the analysis is actually conducted.
And how does that get rolled back into the team?
What do you mean?
The team's work, the prosecutor's work. So you subpoenaed Speaker McCarthy's toll records after he became Speaker, and you sought records from November 2020 through January 8th, 2021. Like, what were you looking for with his records? Like, what did you do with the information you obtained?
Okay, so what the relevance of those records, there'd be several examples, but his contacts with either co-conspirators, the president, or conduits of information to the president was relevant to our investigation. And an example I could give you is on January 6th, we had information from Mark Meadows, who was present for a call where Congressman McCarthy was asking for help. He was asking the president to come to his aid while the Capitol was being seized. Getting the exact toll records for when that happened was relevant for our investigation, both to question other witnesses about, so we had an accurate timeline, and also to corroborate that the call happened at approximately the time witnesses said it happened.
But it's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy, and we followed all legal requirements in getting those records.
I mean, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time, and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case.
Right, but you could have asked Elliot Burke for that information, the speaker's lawyer. You could have asked Elliot Burke to say, can you get us the speaker's, phone records for this time? And he probably would have said, of course. Avoiding a toll record subpoena.
And your question?
Why didn't you do that?
We got these records in a manner that was consistent with the law and consistent with department policy. There was nothing improper about how we got these records.
The same with Representative Perry's phone. I mean, you could have asked Representative Perry's lawyer. I mean, there's no evidence that Representative Perry or Speaker McCarthy was interested in obstructing your work, was there?
I don't have any evidence that Speaker McCarthy was, I don't recall any evidence, I should say, that Speaker McCarthy was interested in obstructing our work.
Okay, so with Representative Perry, you could have contacted his lawyer and you could have said, this is what we're looking for. Can you help us achieve this without seizing his phone?
Well, with Congressman Perry, I should point out that the seizure of his phone happened several months before I was ever special counsel. I wasn't
Fair
involved in that process.
Yeah, okay. But in hindsight, would you have counseled taking a different avenue to acquiring a member's phone?
I'm not going to speculate on investigative steps that occurred before I became special counsel.
Okay. When obtaining the toll records of members of Congress or anyone, what is the standard? Must there be some evidence that relates to a criminal prosecution or criminal investigation?
So there has to be a reasonable basis to believe that there will be materially relevant evidence.
Okay. Now, with the chairman of the Judiciary Committee, the subpoena, with Speaker McCarthy, the subpoena, the timeframe was November 2020 through January 8th, 2021. With the now chairman of the Judiciary Committee, the timeframe went back to January 2020. So it was for a full year where, between January 2020 and December of 2020, nobody, had any telephone calls about these matters. I'm just curious why you went back to January 2020, the office did.
Sorry, I just want to clarify. When you say you went back, can we just get the date of when these
It was May
subpoenas were
1st,
issued?
2022, and it was before you were appointed. When I say you, I apologize. I mean the office, the effort. I mean, this was before you became special counsel. The DC matters were headed up by Thomas Wyndham, as I understand it.
I believe that's right.
And the Florida matters were headed up by Jay Bratt.
That's
Okay.
correct.
And so the question is, why would DOJ, why would the team seek records from January 2020, through November of that year, before any of these issues, before anyone knew about any of these issues?
Yeah, I played no role in that subpoena. I was still in Europe at the time. And because I wasn't present or involved, I'm not going to speculate on the basis for the range of time that the prosecutors in that case saw it.
Okay. After you became the special counsel, that information obtained from the subpoena, was available to the special counsel team. What did the team do with it after you became, after you were sworn in?
You mean, when you say that information, you're talking about the toll?
The toll record subpoena for the chairman of the committee.
Well, I can tell you that, for example, there was contact on, for example, January 6th, that again, another example for you is Mark Meadows, when we interviewed him, he referenced the fact that afternoon, Chairman Jordan had been in contact with the White House, and like Congressman McCarthy's contact with the White House, it was relevant because, and again, Meadows stated this, that these were supporters, these were credible people that the president relied on. And what I recall was Meadows stating that I've never seen Jim Jordan scared of anything. And the fact that we were in this different situation now where people were scared really made it clear that what was going on at the Capitol could not be mistaken for anything than what it was. And it goes back to that sort of information from someone who is a credible source to the president, proving that that actually happened and that there's actually a record of that call and exactly when it happened and what actions happened after that or didn't happen after that, extremely probative to our case.
Right, but DOJ took Mr. Jordan's phone records from January 2020 through November, through January of the subsequent. I mean, what on earth could the Justice Department want with his phone records before time's relevant?
Sure, and the breadth of that subpoena was before I was special counsel, and I wasn't involved in the deliberations about seeking that subpoena or the breadth of it, and so I can't speak to that.
Okay. Can you see from our point of view that there's a perception that there's some overreach going on there?
I understand your question. I don't have any, and I do understand it, I don't have any reason to believe that that subpoena was secured for any improper purpose or that it was secured in contravention of department regulations or the law.
Okay. And in terms of who is involved with the authorizations for that type of subpoena, it's your team, it's public integrity, any other Justice Department component?
I cannot speak to that before I was special counsel. I can say that when I was special counsel, I was the person who approved subpoenas of that nature.
Okay.
And with, of course, the fact that I wanted consultation with public integrity.
Okay. So that was the universe of DOJ authorization. It was you and public integrity. You didn't have to go to the DAG, you didn't have to go to OLC, correct?
That's correct.
Okay. When the subpoena was served for certain members of the Judiciary Committee, it was served by an official at the Department of Justice's Inspector General, which, from our point of view, raises a conflict of interest. I mean, the Inspector General is supposed to be conducting oversight, if necessary, of department components. Certainly, if department components are being real aggressive with members of Congress, we might want the IG to conduct a probe of that, right? But if the IG's on your team and they're doing this with you, that presents a problem for us. And so the question is, why was the IG's office serving these subpoenas? Why were they, they went in, I know it was before you were the special counsel, but they went on the Perry search. They took his phone and then they imaged his phone. I mean, the IG here is just like a regular part of the team. Can you explain why that happened?
Yes, with the understanding that I obviously wasn't in that decision chain because I wasn't involved in the case, but my understanding is that the Jeffrey Clark component of this investigation, he was a Department of Justice employee during the period of time that we were, and my predecessors were investigating this, and it's my understanding that is why they were involved in the investigation.
But, understood, but why, when it comes to members of Congress, didn't, I don't understand, I understand they had the Jeffrey Clark investigation going on, but when it comes to members of Congress, I mean, the IG has a special, relationship with Congress. Why are they allowed to be involved?
Again, all I can tell you is what I just told you. This was before my time, but my understanding about why it occurred is because they were involved in that aspect of the investigation.
And were they involved after you became the special counsel? Were they involved in serving toll record subpoenas related to members of Congress, to your knowledge?
My recollection is that they may still have been involved. My primary dealings were with the FBI, but they may well have stayed as part of the investigation. I didn't have a lot of interaction with them.
Okay. And when some of these toll record subpoenas were served by the IG's office, Do you know whether they knew they were serving toll record subpoenas relating to a member of Congress?
Are you talking about in the period of time when I was special counsel or before?
When you were the special counsel?
Okay, as I sit here, just to be clear, I'm not aware, I don't recollect that people in the DOJ Inspector General's office were serving subpoenas during my time.
Okay.
Could well be, I just don't have recollection of that.
Okay. I can represent to you that they did serve subpoenas before your time. I mean, they served one in May of 2022 relating to the chairman of the committee.
Yeah, and as I said, before my time, I can't speak to that because I was in Europe, I wasn't
Okay.
in the investigation.
But after you became, after you were appointed, that wasn't occurring to the best of your knowledge?
I just don't have a recollection of that.
Okay.
But I want to just to be clear, I'm not sure in my role, I would know which individual agent was serving a subpoena. So that's not something I would have necessarily known in the first place. Just, I wanted to make that clear.
Fair enough, but if it was from the IG's office, wouldn't that raise like an issue?
I'm just saying to you, in my role, I was not like directing which agent would serve which subpoena.
Okay. Did you have interactions with the IG's office on the Jeff Clark matter?
I can't think of any now, but I don't want to say that it may have been possible I did, but as I sit here now, I can't think of any.
I mean, were they a part of the team after you were appointed?
That's what I said earlier. My recollection is that they were.
Okay. With the toll record subpoenas for the senators, one of the lines requested was a Senate landline. Did you know about that?
I don't recall knowing about any particular lines. My role, as I saw it, was to understand who my prosecutors thought we should be getting toll records for, to make sure we had a basis for that under the statute, a reasonable basis. I don't recall discussions about how they figured out what lines we would be going for.
Because at least in the House, if you place a call from a landline in the House, it goes out scrambled. So, to the extent DOJ thinks they have the right number, it would be scrambled. And so it's just raises questions as to why the office would subpoena toll records for a Senate landline. And you don't have any additional information or recollections on that?
I really don't.
Okay. There was some litigation with AT&T over the subpoenas for the Senate lines. Do you have any recollection of that?
Was it litigation, or I know I saw, or I was shown that there was a letter that from AT&T to Senator Grassley. I don't recall any litigation.
Okay. Maybe litigation was the wrong word, but AT&T, I guess, pushed back on the toll records subpoena. And according to them, after they pushed back and said they weren't comfortable producing the records, the special counsel's office stood down. Do you have any recollections from that?
I don't have any recollection of that.
Okay. And essentially AT&T represented, at least to Senator Grassley's office, that after they said, no, we're not going to give you those records, your office didn't press the matter further, which raises the question why. But your testimony is you don't have any recollection of that?
I don't have any recollection of it. I also don't know from the letter what the reason they gave for not giving it, but I don't have a memory of any of this.
Okay. To the extent members of Congress and senators are up in arms that this happened to them and they're seeking accountability, who should be held accountable for answering these questions?
Well, I think who should be accountable for this is Donald Trump. These records are people, in the case of the senators, Donald Trump directed his co-conspirators to call these people to further delay the proceedings. He chose to do that. If Donald Trump had chosen to call a number of Democratic senators we would have got toll records for a number of Democratic senators. So responsibility for why these records, why we collected them, that lies with Donald Trump.
Well, I understand that's your perspective, but in terms of, there are calls from United States senators to impeach Judge Boasberg because he signed this NDO order. We've asked you questions, for a good bit now about whether your office should have taken additional steps. So it's either your office, the judge, the carrier. In your view, who needs to be held to account on these toll record subpoenas?
Well, I don't, certainly my office did everything consistent with the law and department regulations at the time. As I think we referenced earlier this morning, the department regulations on this, since we issued these toll records, has changed. If, I believe now, and I believe this is in 2024, if we were to make an NDO application to a judge, we would need to identify if they were members of Congress. And so, to the extent you think something needs to be changed, that change happened.
Okay.
But that was not required at the time that we issued these subpoenas.
Okay.
Sort of begs the point there, doesn't it? Don't you think? Sort of begs the point, like, it makes the point, like, maybe that should have been the standard, it should have been a burden on the prosecution to actually give that information to the carriers. Would you agree?
No, as I said earlier, I think we followed the regulations that they existed at the time. If the regulations that are now in effect were in effect then, we would have followed those regulations.
I just want to circle back for a second. Who first contacted you about taking the position of special counsel?
Marshall Miller.
Same guy you reached out to early on,
Correct.
who said you'd be interested in the right position. So when did he call you?
It was some point, I told you earlier, there was this initial conversation where I said.
Understand that.
Right. Some point after that, he contacted me about ultimately the position that I ended up having.
Okay, and I'm trying to find out when that was, because you called him when he took the job in the summer of '22, which is before President Trump announces he's running for president, before you get appointed by the Attorney General. I want to know when you talked to Mr. Miller the second time, or the third time, or how many times did you talk to him?
Between the time that I originally reached out to Marshall Miller and the time that I was appointed as special counsel, I spoke to Marshall Miller several times.
Several times, okay. And then he's the one who first asked you, would you be interested in being the special counsel, is that right?
I don't remember how he phrased it, but my recollection, to the extent I have one, is it was not phrased in terms of being the special counsel. I think it was in terms of being involved in these investigations.
And again, when was that?
I'm having trouble recollecting. It definitely was after he first reached out to me.
Wait. I thought you called him first.
I'm sorry, you're right.
Okay.
After I first reached out to him, we had multiple conversations between then and when I was
Between the
appointed.
summer of '22, when he takes a position as number 3 guy in Justice Department, and between November 18th, 2022, when you get named, you had multiple discussions, multiple conversations.
Yes, I just also to be clear, not all those conversations were about this position.
I'm not saying there were, it was
Okay.
multiple conversations. Did he ask you to, did he talk about special counsel position, the one you took, prior to the Attorney General asking you to take the job? I thought he said yes to that earlier.
Yeah, what I'm trying to remember is my recollection, and it is a little vague, is that the idea that working on these cases would be in the format of being a special counsel. My recollection, that it's imperfect, is that was very shortly
Okay, so
before
what
I
did he
was
say? Did
appointed.
he talk about Arctic Frost? Did he talk about Plasma Gecko? Did he talk about these investigations, the Florida case, the DC case? What did he talk about?
I don't recall him ever talking about Arctic frost or plasma, I don't remember.
Those are some names. Did you talk about the two cases?
Yes, at some point it was not clear to me whether, when he first, my recollection again, and it's not perfect, is it wasn't clear to me if it would be working on one case or the other or both. I'm not clear of how that first came up.
Okay. And these conversations were before President Trump announced that he was running for president?
Yes.
Okay. And were they before the midterm elections in '22?
When were the midterm elections?
November, first Tuesday after the first Monday in November.
I think I spoke to him both before that and after that.
Okay. And then, how did it go down at the end? Did you tell Mr. Miller, you know what, President Trump's announced, I think they may be considered, how did it go? Did you tell Mr. Miller, I'd be interested if there's an official special counsel, or how did it go after President Trump announces? How'd that conversation go?
My recollection of this is that I was asked if I would accept the position if it were offered to me, and that was before President Trump announced his candidacy.
When you were sworn in as special counsel when you were in Amsterdam, is that correct?
Yes.
Who swore you in?
I don't recall.
And was it over Zoom or something?
Don't recall.
Or was someone present? Was, Mr. Cooney, or Mr. Cooney and Bratt and several folks came to visit you in Amsterdam, is that right?
Not in Amsterdam. I was in The Hague, in the
Okay.
Netherlands. They probably flew into Amsterdam.
Okay.
Yeah.
Um,
And yes, they came to see me shortly after I was appointed.
But you don't remember who administered the oath? Who can administer the oath? Like, who's authorized at DOJ to administer the oath?
I don't know.
But you did take an oath. You remember that?
I do recall that, yeah.
But you don't remember whether it was was it in the Netherlands?
I was still in the Netherlands is my recollection.
Okay. So it had to be either a DOJ official came to see you, or it had to be over Zoom, right? Those were the options?
Or over the phone. I don't have a recollection that I can help you here.
Okay. And do you know the total cost of your probe?
I do not.
Rough, can you give a rough estimate?
Well, the special counsel, our office, consistent with past special counsels, gives a public report of expenditures. And the last, I'm not sure if the last one that we covered, the last however many period of time was ever actually published. And so you'd have to add that into the total. So that's why I say I don't know.
At the time, the last published report, I think it was at 20 million.
Okay, I don't recall that. Whatever is in the public reporting on this would be accurate.
Okay. The genesis of the alternate electors case started with the National Archives IG, is that your understanding? They first raised flags that they were receiving alternate electors to the Justice Department?
That I believe would have been well before I was special counsel.
Okay. And when you became special counsel, was that part of your, where did the alternate electors case stand, when you became the special counsel in November of 2022?
So the fake elector scheme was part of what I was investigating, and it ultimately became part of the charges in the case.
Okay. But where did it stand as of November 2022?
Where did it stand? I think the people assigned to that investigation were investigating it. Exactly how many interviews they conducted, things of that nature, I can't recall as I sit here right now.
Before you became the special counsel, there was an effort to get DOJ moving on this, and an individual named Amanda Vaughn, a prosecutor on J.P. Cooney's team, indicated that the, DOJ would not be pursuing the case. Were you aware of that?
Was this when I was special counsel?
This is before you became special counsel.
I don't recall that.
And so the question ultimately is it seems like the alternate electors matter, it seems like it was subject to a lot of starts and stops. And wanted to know whether, after you became the special counsel in November of 2022, were there any starts and stops, or was that full speed ahead on that probe?
That was a part of the case that we investigated from the time I started until the indictment. It ended up being one of the most powerful parts of the case. We had electors who were going to be witnesses. I referenced earlier a congressman from Pennsylvania who had said this was an attempt to overthrow the government. We had other electors who said, I was told that this would only be used if we won in litigation. And obviously the record in our case showed that the co-conspirators were trying to use their elector votes despite that fact. And again, this goes to the point I made earlier. These are people who wanted to be electors for Donald Trump. They are not people who were opposed to him. They were not people who were from a different political party or enemies. And so the fact that we had elector witnesses like that who felt either they'd been misled or they felt that this whole effort was an attempt to overthrow the government, I thought that was pretty powerful evidence. And so we moved that part of the investigation forward with the rest of the case.
Did your office coordinate with state officials?
You mean interview state officials?
No, coordinate, several other, state probes cropped up, in Arizona, in Fulton County, Georgia. And I'm wondering how you coordinated those efforts.
I know that we got inquiries from state authorities. I'm aware of that. My recollection is that we did not share any evidence with them. And I don't think, my recollection is we did not get any evidence from them. We got it from, that is my recollection, that it was all or largely from public sources.
Okay. Was there somebody on your team who had responsibility for liaisoning with the Attorney General for the state of Arizona, Chris Mays?
I don't believe so, but also the liaisoning, I don't think that, my recollection is that there was not like an ongoing discussion. What I was thinking of, I know we got a letter, for example, from the Attorney General in New Mexico asking for information from us. I don't have a specific recollection as well as to other states. It may well be that we got other inquiries.
So there was no proactive coordination?
No.
Okay, there was no proactive coordination, regular communications with Chris Mays' office in Arizona?
I don't recall any regular communications, but I'm hesitating just because I don't recall, as I sit here, how many times they might have reached out to us or that sort of thing.
Right. How about with the Fulton County DA's office with Fonnie Willis and Mr. Wade?
Yeah, I've never had contact with either of those people.
Okay, do you know if anyone on the special counsel team, on your team, had contact with them after you were appointed in November of 2022?
I don't believe so. I will just say, though, that one of the things we were investigating was things that happened in Fulton County. Particularly, there was an election worker by the name of Ruby Freeman, her mother, and she was the mother of a woman named Shay Moss. They were people that Rudy Giuliani and Donald Trump targeted with absolutely false claims of election fraud, claims that Rudy Giuliani later admitted he didn't have evidence for, claims that he was held liable in defamation for, caused them to endure all these sort of vile threats. And that whole episode, as well as sort of the claims, the false claims about the vote count in Fulton County, we did look into that and collect evidence. I don't have a recollection, as I sit here, that we interacted with the Fulton County DA's office for that, but if we did, it would be only for that.
Okay, did you try to deconflict their prosecution from what you were working on?
Well, We didn't, I was not interested in sharing information with them, so I did not give them information. I'm not even sure, testing my recollection now, but I don't even think we got a request for information from them.
Did you have coordination as far as scheduling was concerned?
I don't recall anything like that.
Okay. Because their proceedings were going on concurrently with your DC case, with the Florida case. So you don't remember you or anyone on your team having communications with Fulton County to coordinate scheduling?
No, I was aware, obviously, that their case was pending, but I did not coordinate any scheduling with them.
Okay. How about with the Attorney General for the state of Michigan?
Again, it may be that they requested information from us. As I sit here right now, I should say I don't have a really good recollection of this subject matter you're talking
Okay.
about, but I don't recall us giving them information, and I don't recall getting information from them.
Who on your team would have that information?
Well, Thomas Wyndham and Molly Gaston led that case, and
Okay.
along with J.P. Cooney, that would probably be
Okay.
people who might recall these things
Okay.
with more specificity than I am.
Okay. So if somebody has the information, one of those three people should be able to help us?
There may be other people in the office as well. I'm saying them because they were the direct supervisors of the prosecutors on that case, and they may have a better recollection.
Same question with the District Attorney of New York's office. Did your office have any communications with that office, coordination?
No recollection of that.
Did you have any communications regarding scheduling?
Again, I have no recollection of that. I was aware of their case pending, but I don't recall any coordination with them.
Did your office or anyone at DOJ, to your knowledge, try to dissuade the District Attorney of New York from bringing that case?
I do not recall that at all. And that I'll just say I have a better memory. I do not remember anything like that.
Were you enthusiastic that the District Attorney of New York was bringing that case?
No, I didn't take any position about it.
Okay, because, it was going on at the same time that you were trying to move forward your two cases, correct?
Correct.
And you didn't have a view that the case out of the District Attorney of New York's office was going to be a distraction? Litigating whether there's payments to some performer and how that relates to, the Trump Organization's accounting protocols. I mean, that is very different from the two cases you were pursuing.
Yeah, the two cases are completely different.
And so the question was, do you think that the District Attorney of New York's case presented a distraction for what you were trying to accomplish?
A distraction. I don't know that I thought about it that way. I can't recall any discussions along those lines.
I mean, there were a number of times when you wanted to be in court in DC, and you had to work around the president's schedule because he was in court in Manhattan, correct?
I'm not sure that's right. Maybe that's right. I don't know if there's a record about that. I don't, was there, if, I shouldn't be asking you questions,
Yeah.
but is there, I don't recall.
Yeah, there is.
Okay. So I'm not disputing you then.
I mean, one of the issues is, the president was represented by, he had his team of lawyers. It was pretty small group. They weren't backed by big law, right? So they didn't enjoy a robust, hundreds of, lawyers back at the office to be able to digest some of these things. And so, President Trump's lawyers, were required to be in New York part of the week, and then they had to come to DC, and then they had to go to Florida. And so the question is, did you ever coordinate with the District Attorney of New York to, maybe not be at trial one day, so you could have the president and his lawyers here in DC?
I don't recall that.
Okay. And was any of that a distraction?
It wasn't a distraction from us because, as you said, that case had nothing to do with our case.
Okay. There were a number of times that I believe Jay Bratt took the position that the president ought to go get some more lawyers. Like if Todd Blanche and John Lauro, if they can't handle all these cases, they should just go find different attorneys for President Trump. Were you aware of that statement by Mr. Bratt?
What context was that?
Before the court in DC and Florida. Actually, Mr. Bratt was in Florida.
Yeah, I don't think Mr. Bratt appeared in court in D.C.
In Florida, I'm sorry.
If you could direct me to specifically what he said, as I sit here now, I don't
Okay.
recall that, but I'm not denying that happened.
Maybe we'll revisit that, but we can point you to.
Sure.
But you would certainly agree that the president gets to pick who his lawyers are, and if he wants to have Todd Blanche and John Lauro and not others, that's something that the government ought to be able to work with, correct?
Sure, although, I, not this case, but other cases, I've seen judges say that if you're going to pick lawyers because they're unavailable, that you can't do that. And if
Well, that
you're
wasn't the case here.
Well, if you're picking lawyers because they, that will allow you to sort of delay the case,
Right.
that's not something that judges usually put up with.
But, President Trump, nobody from big law would represent him. Isn't that a pretty well-established case?
I don't know that.
And like Mr. Blanche had to leave his firm to take on the representation?
I know he chose to leave his firm. I don't know the circumstances behind that.
Maybe it comes as a surprise to you, but there are, really two different Washingtons when it comes to lawyers. And, big law downtown just does not, have a great appetite for hiring former, Trump alumni, lawyers that worked in the Trump administration with, Republicans generally. Are you aware of that?
I have not worked in big law. I've been a public servant my whole career.
Right.
That's the world I know.
Okay. By contrast, the lawyers on the January 6th committee, they leave the Hill one day and, they're immediately gobbled up by big law very quickly. That just doesn't happen with Republicans. Would you agree?
That Republicans don't get jobs as lawyers? I'm sorry.
At big law firms.
I don't actually know that that's true. Again, this isn't a world I have worked in, but I think there are Republicans at big law firms.
Okay. Republicans that represented Donald Trump zealously?
I haven't kept track of that, but you'd said Republicans at law firms, so.
When your office filed its proposed DC schedule in August of 2023, were you aware that your office also had a concurrent schedule, operating in the Southern District of Florida? You essentially had two cases going at once.
Correct.
And so how did you deconflict those scheduling appearances?
Well, there were two separate groups of lawyers working on those cases, one on the classified documents case, one on the investigations case.
Was that the case for President Trump?
I'm sorry?
Was that the case for President Trump as well?
I'm trying to recall. I know John Lauro, who I think was the lead counsel in the Washington, D.C. case. I don't believe he had any involvement in the Florida case, and I know Christopher Keiss, I think was his name, was in the Florida case and didn't have any involvement here. I don't know,
Okay.
also I should say, I don't know how many lawyers supporting the lawyers in court President Trump had that were supporting one case or the other case.
In February of 2024, your office proposed an April hearing in the Southern District of Florida. At the time, you were aware that President Trump was scheduled for a full-day jury trial proceedings in New York on April 1st, 2nd, and 4th. So your proposal required the president to attend trial in New York on April 1st and 2nd, travel to Florida for a hearing on April 3rd, and return to New York for trial on April 4th. Do you recall that type of extraordinary logistics the president was put through?
Can you say that back to me? I just didn't, you said some dates in the beginning, if I could just hear it again.
On February 29th, 2024, your office proposed an April 3rd hearing in the Florida case.
Okay.
At the time, President Trump was scheduled for, full-day jury trial in New York on April 1st, 2nd, and 4th. So you picked the 3rd, the one day that he had off from trial. Does that ring any bells as we refresh you about that?
It doesn't ring bells, but I want to be clear, I'm not denying that those dates are accurate.
Do you think that's reasonable in hindsight?
I think our requests to the court were reasonable, yes.
And you think it's reasonable that President Trump had to be in New York on the 1st, 2nd, and 4th, and then travel to Florida on the 3rd?
I think our requests were reasonable, yes.
So just to clarify, what kind of hearing was it? You said a hearing in the Southern District of Florida on April 3rd? Is there any more information about what kind of hearing it was? Was it just a status conference or something different?
As we understand it, President Trump had to be there. I think, if it's a status conference, I'm sure the judge would. We only have about
That's so you can move on.
minutes left, so we'll-
I didn't mean to
Yeah.
delay things. No, you can keep going.
Steve, I think.
Okay.
Mr. Smith, can I just ask a few questions? When you were hired in November of '22, how did the department educate you about the predications for the investigation? What evidence had been collected?
I got educated on the cases by debriefing with the people who were leading the investigations.
And in terms of when that full autonomy was handed over, how quickly did that happen?
Sure. So I was appointed on November 18th, that Friday. And time difference, right, because I'm in The Hague.
Yep.
I requested that evening that someone get on a plane to come over and debrief me immediately.
Who that was?
It was J.P. Cooney was the first person who came over.
He came alone?
I believe he did, in my recollection right now, and I think he got there, maybe it was till, I can't remember if it was Saturday or Sunday, but he got there Sunday and began giving me a summary of the work.
And was that just digital case files? Was it hard copies?
It was oral.
All oral?
He came over to debrief me orally, yes.
When was the first time you started to look at some of the materials? Only reason I'm asking,
Yeah.
DOJ alum, when I got an investigative memo, I would start going through and looking through the materials myself.
I did that.
Yep.
I'm having difficulty remembering exactly when that happened, but I certainly did that. It was early on.
In terms of the way you approach this, did you go through and kind of review the predication for all of the investigative steps that have been taken to that point?
Review the predication for all of this.
So whether it was, pen registers, search warrants, did you review all of that, or were you just looking at kind of the summaries of the information, the evidence that had been collected?
I think I was looking at kind of the overall where the investigation was at this point in time.
Okay. In terms of the staff decisions that you made, how soon did you start staffing up your office?
Well, the office was primarily staffed with people who had already been on the investigations. The majority, I think, were people who had already been on the investigations, and so there was a period of time shortly after I appointed where we had to determine, they had to determine if they were going to stay on the investigation.
Did you ultimately make that decision?
Yes.
Okay. Did you go and meet with every one of those individuals?
I was still in The Hague at that point in time, and so J.P. Cooney had those meetings.
In regards to the law enforcement officers, did you have any say in which agents worked for this investigation?
The squads that worked on these investigations were the same squads that were already working on the investigations when I took them over.
Did you amend those, that personnel at all?
The FBI?
Yeah,
I don't recall doing that.
okay. And then just to follow up on what he said, was there ever any contact between you or any of your team with some of those other prosecutorial offices, whether it be DA, AGs, for the purposes of evidence sharing, information sharing?
Yeah, as I said earlier, I don't have a recollection of that.
But was there a policy, as the boss of the office, did you have a policy with that? If someone had done that, would they have had to report it up the chain to you?
Yeah, if someone had said, I want to call Fonnie Willis and have a conversation and get evidence from them, I would expect no one would do that unless I said it was all right.
And in your recollection, that never happened?
I don't have a recollection of that. As I said, I just want to be as clear as I can. I don't have a great recollection of specifics with different attorney general's offices, but my recollection is we did get reached out to by offices. I'm thinking of one letter I do recall. May have been, yeah.
Other officers reached out to you?
Yes.
Okay.
That's what I recall.
Yeah.
And so there may have been interactions as that result. As I sit here, I don't recall asking them.
You initiated?
Or asking them for evidence, but again, I think, as I directed, I think the people who are the team leaders on those cases and J.P. Cooney might have a closer recollection of that.
But your memory is there was no outreach that you had to approve or sign off on?
Outreach that I did sign off on, I don't recall anything like that.
And who did the letter come from? Again, just refresh my memory. So you got one letter?
The only one I remember is I remember we got a letter from the Attorney General in, I believe it was New Mexico. That's my recollection.
Okay. Anyone else in the Justice Department, just again to circle back, you talked about the series of conversations you had with Mr. Miller, the KDAG. Anyone else in the Justice Department you talked with prior to Mr. Garland offering you the position of Special Counsel? You talked to the DAG, you talked to Lisa Monaco.
Well, yeah, so I flew to the United States from The Hague at some point in late October, and I met the Attorney General and I met Lisa Monaco. That was in late October of 22.
Okay. And anyone else in that meeting? Was Mr. Miller in that meeting?
So it wasn't a meeting, it was separate. I was at the DOJ, I met with Lisa Monaco, and then separately from that, I met with the Attorney General. I do recall the meeting with the Attorney General wasn't that long. Matt Clapper was present for that meeting, and I believe Marshall Miller was present for that meeting. With regards to Lisa Monaco, I cannot recall if Mr. Miller was there or not. He may have or he may not have been.
And the subject matter of both meetings, one with Ms. Monaco and the other one with Mr. Clapper and Mr. Garland was what?
They asked me about my work in The Hague. That was what both conversations were about. And I just also add, that same trip, I also went and spoke to the Human Rights section at DOJ about the work I was doing in The Hague for the State Department.
And that was all? That's all you talked about was your work at The Hague?
My work in The Hague and sort of like my experience as a prosecutor, my sort of how I viewed the job. We didn't talk about these investigations, to my recollection.
In hindsight, was it an interview?
In hindsight, yes.
Okay.
But
okay, go ahead.
in hindsight, yes, but it wasn't in the sense of I wasn't asked about. I don't recall being asked about these investigations.
Fair enough. In your conversation with Mr. Miller, had he already communicated to the Attorney General and Lisa Monaco that you were interested in the special counsel position, if in fact that was going to be done?
I wouldn't know.
Sorry, I just want to clarify the timing on that. This was end of October 2022, and Chairman Jordan, your question assumed that there was discussion about the special counsel position. Did Marshall Miller convey that to Lisa Monaco or Merrick Garland, that Mr. Smith was interested in that position? I just want to clarify, because I thought I heard you say earlier that the discussion was not necessarily in context of a special counsel appointment, or is that not right?
Well, they asked me about my work in The Hague and my work as a prosecutor. I don't know what conversations Mr. Miller had with them
Fair enough.
when I wasn't there.
But you said earlier you had conversations with Mr. Miller about the two investigations, not special counsel specifically, but about the DC investigation, Florida investigation. And then you've also said that in the meeting with the Attorney General and Mr. Clapper, and the other meeting with Lisa Monaco, you didn't have discussions about those two investigations. Is that accurate?
That's right, with the addition that I can't place when the conversations about generally working on the investigations was, but I think my recollection, to the extent I can remember this, is that it was sometime before I took this trip to Washington, D.C.
So those conversations with Mr. Miller about the investigations took place prior to you sitting down with the Attorney General and the Deputy Attorney General.
I believe that's right, but I want to emphasize that my recollection here is not as sharp as it has been on other subjects that we've talked about today.
Fair enough.
Hour's up, so we'll just stop. The April 3rd hearing was a pretrial motion.
Okay, thank you.
Doesn't matter. You can leave it on. We'll now go off the record.
Welcome back, Mr. Smith. I want to start by addressing or starting on the issue about the collection of call records related to certain members of Congress. You recall the majority asking you about this at length in their first 2 rounds so far today?
Yes.
Did Donald Trump and his co-conspirators try to reach out to members of Congress before January 6th and on January 6th of 2021?
Yes.
Can you tell us a little bit about what your investigation uncovered regarding communications with members of Congress that's related to the attack on the Capitol on January 6th?
There was pretty extensive contact with members of Congress. There were instances of members of Congress, again, specifically on January 6th, but also before that, where either they were reaching out to the White House or the White House was reaching out to them, and through, conduits to the president, including, as I said, Mark Meadows.
And what was the nature, let's start with before January 6th. What was the nature of some of these communications with the White House or with co-conspirators of Donald Trump leading up to January 6th and members of Congress?
Well, it varied. Sometimes the communications were relevant to us to show that people were telling Donald Trump that the things he was saying were not true. Other times, they were evidence of the false nature of the things that we're saying. So, for an example, would be there are 2 voicemails that Rudy Giuliani left for senators, and those voicemails show him saying things that were not true, using knowingly false claims to try to get those senators to further delay the certification of the vote.
You just mentioned that there were instances before January 6th of members calling the White House, and I'm summarizing, to basically express that some of the claims the president and his co-conspirators were making were not true. Is that what you just said?
Well, I should be specific. There were a variety of reasons that, and I'm not trying to say that any time someone contacted the White House, they were involved in a crime themselves or doing anything improper. But how this conspiracy that was trying to stop the lawful transfer of power, how that worked, it was important for us to understand. We had evidence from Department of Justice officials that Donald Trump said to them, just say the election is corrupt and leave the rest to me and the Republican congressman. I think given that was the perspective that Donald Trump had, our view is that the case we would have presented at trial would have been Donald Trump preying on the party allegiance of people in his party. And people like the vice president didn't agree to that. People like the elector from Pennsylvania I mentioned didn't agree to that. People like the Speaker of the House in Arizona didn't agree to that. But the extent to which those contacts were happening was relevant to our investigation.
Okay, so let's dig down a little bit in that. Let's start on January 6th. So I believe in the evening, did your investigation uncover or learn that Mr. Trump personally called members of Congress on the evening of January 6th?
Yes.
Do you remember who those members were?
I'd have to look at the records to be sure, but to the best of my recollection, he was trying to get in touch directly himself with Senator Hawley and Senator Haggerty. And then there were several senators who he directed Rudy Giuliani to get in touch with.
And who were those senators that Mr. Trump directed Mr. Giuliani to get in contact with, to the best of your recollection?
To the best of my recollection, and this comes from a email, or I think it was a text maybe, that Boris Epstein sent to Mark Meadows, and it basically said something to the effect of the president told the mayor to call these senators and they needed numbers. And what our investigation ultimately showed was they sent that text after they'd already started trying to call members, and didn't think they had, and ended up understanding that they didn't have the right phone numbers. In fact, the message that they left for Senator Lee, which he voluntarily provided to our office, that was meant for Senator Tuberville, I believe. And the message that he left for Senator Sullivan, I believe it was for Senator, the name's escaping me now, but it was another senator that he meant to call. We had also interviewed Boris Epstein before these subpoenas were issued. He corroborated that they were, in fact, trying to call senators. He dissembled and tried to imply that the president hadn't directed him to do it, even though there was a text message saying specifically that they had. But he agreed that they tried to call these senators and that they had certain senators' numbers themselves, and so they didn't need those numbers. And that would be, I believe it was Senator Cruz, and possibly, I think he said they possibly tried to call Senator Graham as well.
Taking a step back, this might be obvious for a lot of folks, but just to make sure it's clear for the record, who is Mr. Epstein?
Boris Epstein was one of the co-conspirators in this case.
And what role did Mr. Epstein play in the larger conspiracy, if you can summarize it?
Well, he played several roles. He was involved in the fake elector scheme, and also in sort of pushing out some of these false fraud claims. The other thing, I'm sorry, just to go back to mention is, we also, in the course of the investigation, interviewed Rudy Giuliani. And one of the things that we asked him, if you recall, in the message, and I can't remember which senator it was for, but in the message that he left, he said, referenced the fact that he was calling on fellow Republicans. And in the interview, we asked him, why did you say you were calling on your fellow Republicans? And he said, well, I wasn't going to be calling Democrats about this. Even some Republicans wouldn't go along with this. So of course I would call only Republicans. And in fact, that was consistent with our investigation throughout, that the people that President Trump and his co-conspirators reached out to were people who they thought would go along or help them because of party allegiance. And Giuliani in particular would reference that he expected their cooperation because they were Republicans. There was one particular meeting that he attended where he got a hostile reception because he had no evidence to back up the fraud claims. And he said something to the effect of, I thought we were all Republicans here. And so that was a theme throughout the case, and it went to the strength of the case that we had because the witnesses we were going to call were the people that the president reached out to sort of further this criminal scheme.
I want to touch on a point because it seems like the evidence you uncovered showed certain members of Congress, including Republicans, pushing back on this assertion about the big lie. And I'm characterizing some of these claims about the election as the big lie. Is that okay if I use that term?
You can use whatever term you like.
Oh, I'm going to use the big lie. So do you recall any evidence when you were talking to Mr. Giuliani that he truly believed all the voter fraud claims that he was putting out around the country?
Our evidence was he did not. And in fact, when we interviewed him, he disavowed a number of the claims. He claimed they were mistakes or hyperbole. Even the claim about Ruby Freeman, where he, basically destroyed this poor woman's life by claiming she was a vote scammer. President Trump did the same thing in a recorded call with the Secretary of State. He disavowed things he'd said in that interview.
Thank you.
Can I ask a question? Were you able to interview some of the individuals that our January 6th committee was unable to interview? For example, did you interview Mark Meadows?
We did.
We were unable to talk to Mr. Meadows. Were you able to find out what the communication was between Mr. Meadows and Mr. Bannon and potentially Mr. Stone on the evening of January 5th at the so-called War Room at the hotel?
I don't recall that as I sit here right now. I know Mr. Meadows spoke to a number of people who were either involved in or adjacent to this conspiracy. As I sit here right now, I don't recall that specific evidence. I think he was in touch with Bannon, but I don't recall specifically the answer to that question.
Mr. Bannon made an extraordinary video basically predicting the events of January 6th on the day before. Were you able to discover, either by interviewing Mr. Bannon or those who had knowledge of what he was doing, how he was aware of the riot before it happened?
We did not interview Mr. Bannon. I believe that particular statement you're talking about would have been part of our proof, and my recollection is that we had evidence that would indicate from some point, not immediately after the election, but shortly thereafter, sometime, might have been closer to December period, that Bannon, who had been out of touch with President Trump for some period of time, got back in more regular touch with him at some time. And in fact, this is reminding me, my recollection is that we had a text thread that between Bannon and Epstein that went through a lot of this period. On that text thread, I believe it was the evening of January 6th, right around the time the senators' calls were occurring at the direction of the president. And there was an exchange between those two wherein I believe it was Epstein asked Bannon, "Are you in touch with him?" And the answer was affirmative, and it was something to the effect of, "He's still on fire." And that's right at the same time that these calls are happening, after he refused to do what he could to stop the attack on the Capitol, after the tweet about Mike Pence.
In December, there were several meetings in the White House where efforts were to overthrow the election were discussed in terms of the fake elector scheme. The president issued his tweet calling the mob to Washington that it would be wild. Did you identify members of Congress who participated in any of those meetings
Participated in meetings at the White House.
in December?
I'm thinking now, I can't say that we didn't, but as I sit here right now, I can't think of a member of Congress in particular that attended the meetings I'm thinking of right now. Not saying it didn't happen, I just don't have a
I want
recollection.
to follow up on that. There was a December 18th meeting. Do you remember a December 18th meeting at the White House right before President Trump then issued the "Will Be Wild" tweet in the early morning of December 19th? Do you remember? I believe Ms. Powell was there, and others were at the White House discussing with Mr. Trump.
I remember there was a meeting with Sidney Powell where there was a discussion about whether she would be appointed a sort of special counsel for to sort of have this role that would assist Trump in pushing these claims of election fraud that were false. My recollection of that is the meeting ended, I believe, with President Trump saying, "I want her in that position," but then it didn't happen because she didn't fill out the paperwork, clearance paperwork necessary for that. I don't know if that's the 18th, but it's around that time.
And do you recall any members, just following up on Ms. Lofgren's point, do you recall any members of Congress being present or participating in that meeting?
There's a record of this in our files. I remember certain individuals. I think Mark Meadows was there. An individual by the name of Eric Hirschman was there. I think Rudy Giuliani was there. There was a number of people there. I'm not remembering if there's anybody in particular you can ask me and I could see if I could remember, but that's what I remember now.
Who introduced the idea of Mr. Clark becoming Attorney General?
Our investigation determined that Congressman Perry had a role in getting Jeff Clark on the radar of President Trump as someone who could help him. and getting meetings with Jeff Clark and the president.
And we might touch on Mr. Perry's involvement later on. Just want to flag that for you. So it sounds like, and I want to hear it from you, did your request for the toll records of certain congressional members, did that relate to phone calls made to these members of Congress on or around January 6th of 2021?
Including that, yes.
And how big was the window of records that you requested for these members of Congress?
The records regarding those calls on January 6th, the period of time was from, I believe it was January 4th to 7th, but there was earlier subpoenas, including the one referenced earlier today regarding Congressman McCarthy. There was a broader period of time from, I want to say it's about November 3rd through, again, it was either January 6th or 7th.
And I've heard you mention evidence such as text messages with Mr. Epstein, Mr. Giuliani. Did you also have Mr. Giuliani's records as part of your investigation? Did you collect those? Phone records, I mean?
We did.
Okay. So in your prosecutorial experience, do you generally seek to obtain call records from both individuals involved in a telephonic call or message?
We do, and in this case, with the records for that evening, it was particularly important because when we interviewed Boris Epstein, one of the things that came out was that Rudy Giuliani had two phones and that Boris Epstein had another phone, and we needed to make sure that we weren't missing any calls in terms of where the calls came from. And so it would corroborate the records that we had, but also make sure that there's not calls that we missed.
Did you ever learn why Mr. Giuliani and Mr. Epstein had multiple phones?
No.
Okay. Did the toll records that you requested from the senators, did they include the content of the phone calls?
No.
Did the records that you requested, the toll records from the members of Congress, include the content of text messages?
No.
Can you explain for us on the record what information generally is included in a toll records request?
Sure. Again, my understanding from a prosecutor's perspective is it is non-content information. It's generally about when the call started, when the call stopped. That would include obviously the duration of the call and who the call is to and who the call is from. That's the basic information that you want to get from a toll records subpoena.
And let's fast forward to, say this would have gone to a trial. How would you, in your experience, have used this type of evidence in a trial?
Oh, it would have been relevant in a number of ways. So it would have been relevant. You could put it together in a summary chart to show the series of contacts, and it could be relevant to show the campaign that evening to reach out to senators to delay the proceedings. Could also be relevant to show, for example, on the afternoon of January 6th, of notice that there was notice that violence was going on. Congressmen, both Republican and Democrat, and the Vice President were in danger. That text records would make that incontrovertible that those calls actually happened. They'd also be relevant for examining witnesses, whether it would be a prosecution witness who might not remember exactly when a call happened, or a defense witness, for example, if any of the co-conspirators were to testify, which, as I mentioned before, was something we would have welcomed. We would have had toll records to question them about the calls that they made, the calls that they received, things of that nature, which in my experience can be very effective.
Can I ask, we attempted in the January 6th committee to question Peter Navarro as well as Steve Bannon, and they were both prosecuted and spent time in jail. Roger Stone appeared but took the fifth. Were you able to provide, to get information from any of those three individuals, and in the case of Mr. Stone, provide use immunity so that he would have to testify?
We did not.
Why not?
We pursued the investigative routes that we thought were the most fruitful. We pursued those that we thought were necessary to get a complete understanding of the scope of the conspiracy. And given the highly uncooperative nature of the individuals you talked about, I didn't think it would be fruitful to try to question them. And the sort of information that they could provide us, in my view, wasn't worth immunizing them for their own possible conduct.
Going back to the toll records, I just want to make sure we make a few things clear. When you were requesting toll records, did it mean that DOJ or FBI was conducting surveillance on members of Congress?
No.
When you were collecting toll records, did it mean that DOJ or FBI would be able to wiretap phone calls made by members of Congress?
No.
Yes,
Yeah, okay. I want to actually go back to some of the lines of questioning that you endured by the majority. There seemed to be this insinuation that there was a lack of respect for the defendant's schedule. Do you recall kind of some of that line of questioning?
I recall questions about his schedule, yes.
Okay. I just want to level set because this is going to be a record and it may be public one day. Considering all the years of experience that you have prosecuting, is it more often or less often that you've had a defendant that has been charged in 4 different jurisdictions with crimes?
I don't know if I've had that before, but it certainly hasn't been often.
Okay. And as it relates to these 4 jurisdictions, we know that he was charged not only on the federal level, but he was also charged on the state level, correct?
That's correct.
And in your experience, typically has it been that if you have a defendant that is charged in multiple federal cases that the federal magistrates or the sitting judges typically confer and figure out scheduling conflicts?
That can happen, yes.
Okay. The issue in this case, or a number of issues in this case, was not so much your prosecution, but was the fact that there was alleged criminal conduct all over the place, correct?
Well, I was focused on my case and my prosecutions.
Okay. So, I guess what I'm trying to figure out how I want to do this because they were doing this a different way. Essentially, did it seem as if President Trump was actually enjoying privileges that the average defendant did not?
I certainly wouldn't want that to be the case. I think the law should be the same for everybody. I don't think anybody should be above the law. I think in a case like this, that could be challenging, but it was my goal to make sure he was treated as anybody else, as any of us would be treated.
So let me ask you this, because in my experience, I've never had a defendant have so many charges and not spend 1 day in jail. In your experience, have you ever had a defendant charged with so many cases and not spend 1 day in jail? And when I'm talking about a day in jail, I'm talking about pre-incarceration. What I was observing is that the president was experiencing walkthroughs for seemingly every case that he got instead of going through the typical process that a defendant would normally go through.
Well, I have to say in our cases, in terms of, we did not try our cases. We did not prove our cases in a court beyond a reasonable doubt. And so any sort of sentence, whether it would be incarceratory or otherwise, we never reached that point in the proceedings. And in our case, whether someone would be detained before trial, there's factors you look to for that. We did not ask for President Trump to be detained before trial. And so, as I think I've made clear, I wish we had been able to try these cases because I am confident we had the proof to sustain convictions. And I did try at every place to make sure he was not being treated better or worse than anybody else. But with respect to those things, that was the state of the record in our case.
You've tried cases on the state level, correct?
I have.
Okay. So he was charged in Georgia as well as New York. Are you aware of that?
Yes.
And in your experience in handling trial cases on the state level, typically, and correct me if I'm wrong, typically a defendant is incarcerated and then given a bail or not to get out. Has that been your experience as it relates to trial level on the state level?
Depending on the charge, yes, and obviously the charge depends on what the bail level is.
Correct, correct. Okay.
I just have one more question about the toll records. So in this past October, in a Senate Judiciary Committee hearing with Attorney General Bondi, Senator Josh Hawley claimed that the subpoena of his phone records was, quote, tapping his phone. As part of your investigation, did you or anyone from your office tap the phone of Senator Hawley?
No.
So is his suggestion that his phone had been tapped just simply false?
It's inaccurate.
Okay, thank you.
I believe earlier, and we're turning back to January 6th, the conspiracy leading up, the events on January 6th, and I believe earlier you said that the reason why, and I'm paraphrasing here, that you charged the president was that he was the most culpable person related to the crime of attempting to criminally overturn the 2020 election. Do you recall saying words to that effect earlier today?
Yes, and because we had proof beyond a reasonable doubt and met the requirements in the federal principles of prosecution.
And I believe you said some of the false claims he was putting out created a certain level of distrust about the validity of the election of 2020. Do you recall saying something like that as well?
Correct. That's alleged in the indictment.
Great. So I want to start with how that level of distrust was created. In your report, you say, and this is a quote, the through line of all of Mr. Trump's criminal efforts was deceit, knowingly false claims of fraud. Can you generally describe some of these knowingly false claims of fraud that were spread after the 2020 election?
Sure. There's a number of them. And you know, part of the explanation is why they're false. And so, you know, just off the top of my head, an example is he was on notice in this election that in Pennsylvania, for example, that he would be ahead in the vote count for a period of time, and then when the mail-in ballots were counted, his lead would dissipate. He chose to represent that phenomena that he'd been briefed on, that was normal course of an election, that all sides knew that that's how it was going to be. He chose to present that as evidence of fraud. And to people who are not maybe as informed as him or informed as his campaign managers who told him these things, that's the sort of thing that creates distrust. There were fraud claims in, you know, Michigan, Georgia, where he was specifically disabused by people he trusted, by political allies, by the people when he chose to call them who are best situated to know. In Georgia, I'm thinking of the Secretary of State. He reflexively rejected those things and continued to state false things after he'd been told that repeatedly that they weren't true.
And why was it important? It probably goes to the mindset, but why was it important of all of these repeat statements from individuals that Donald Trump's claims were untrue? How did that play into your overall investigative findings?
Well, I think the pattern and the depth of the pattern and the length of the pattern was pretty damning evidence that he knew these things were false. He only brought fraud claims that involved states that he'd lost. He only approached people generally who had party allegiance to him. When he was told that a fraud claim wasn't true, he didn't stop making it. Another example I can give is that Sidney Powell, who's alleged as one of the co-conspirators, was part of his team at the beginning of this conspiracy. Shortly after, she began making statements that really nobody could credit, that were facially false. And at some point, Giuliani made a statement that she wasn't on the legal team anymore. And Trump, at one point, was on a call, President Trump, where he basically, if I recollect it right, he muted the call and said she was crazy. But then after that point, he continued to promote her fraud claims and lawsuits. He considered putting her as a special counsel, even though he'd admitted, you know, he used the word crazy, and the statement she was making could, by any reasonable person be viewed as true. And so I think that sort of like claims that were so outlandish and so just fantastical, continuing to push those sort of claims after they've been disabused with strong evidence of our case.
It seems like the evidence that your case uncovered was, I think you said Mr. Trump contacting mostly or all Republican officials about his voter claims from the election of 2020. Is that correct?
That's my recollection. As I sit here now, I can't think of anyone who wasn't someone who was loyal to him politically. And again, many people who would have been our witnesses rejected his entreaties to do that. And again, I think it was in Michigan and in Arizona, and also the Attorney General in Georgia. It stated, I voted for him twice. I wanted, and others stated, I wanted him to win. I campaigned for him. So it's not as if it was effective in every place, but that was who he focused this at. And that's why I had said earlier today that the witnesses in this case, the subjects of the toll records in this case, those were chosen by President Trump.
So if President Trump would have pressured, for example, a Democratic state leader about these false claims for the election, would you have looked into that Democratic state member as well?
Absolutely.
You mentioned earlier talking about, individuals pushing back on these false claims. When you're talking about the fake electors, you mentioned a congressman from Pennsylvania who I guess would have been a witness who might have pushed back on the fake elector scheme being legal. Do you recall saying that earlier?
I do.
Who was that member?
My recollection, I think his name was Thomas Marino. He was a former U.S. attorney, and he's a Republican, former congressman, and he had agreed to be, and this is before the election, agreed to be an elector for Donald Trump. And when he was presented with this idea of the fake elector scheme, my recollection of his reaction was that this was an attempt to overthrow the government, and it was illegal.
You also mentioned a few of the states that Mr. Trump and his co-conspirators, such as Mr. Giuliani and Ms. Powell, targeted about these false claims about the election. Do you recall which states were the main targets of this group?
Yes, I believe it was 7 states. Let me count them. Georgia, Pennsylvania, Wisconsin, Michigan, Arizona. I'm missing one because New Mexico was memorable because he lost that by 10%. There's one more I'm forgetting.
Nevada?
Nevada, thank you.
And I just want to confirm Nevada was the last state, is that
That's
correct,
correct.
sir? Okay. Did your investigation uncover why Mr. Trump and individuals like Mr. Giuliani and Ms. Powell might have selected these 7 states?
Well, the states were all states that he lost by a pretty small margin, except for, again, New Mexico was 10%. I mean, depends what you define as small, but the others were all much closer than that.
And these states had all voted in support of Mr. Biden being president, is that correct?
Yes.
Okay. So just to be clear, Donald Trump had lost all 7 of these states, but it appears narrowly, depending on how you define narrowly.
That's correct.
One of the bigger parts of your report, and which you've talked about here today, comes down to the knowledge, Mr. Trump's knowledge that he had lost the election. I know you've talked about it at various stages of today, but I would just like a pretty clear answer, if you don't mind, about what evidence did you collect about Mr. Trump's knowledge that he had indeed lost the election of 2020?
Okay. Well, there are 2 types of knowledge. One, that he lost the election, and another, that the things he was saying, the fraud claims, were in fact false.
And I want to start with the first one, that
Yeah.
you said that he had lost the election.
Yeah. I think, again, it's the same sort of bucket of evidence that he was repeatedly told by people that the very fraud claims that would change the outcome were not true. As you may remember, when he was told by his campaign team, in essence, that if you can't win Arizona, you can't win the election, and then he'd lost Arizona, he changed out that team and went with Giuliani and his group. We also had statements from other individuals. I believe it was General Mark Milley who said he was going to leave this for the next guy. There was another staffer who overheard him saying something to the effect of, and I want to make sure I'm not inaccurate here, it's in our final report, but basically, like, you keep fighting regardless of whether you won or lost, things of that nature, which were corroborative of the very strong evidence of that the things he was saying about about the election claims were not true.
And then you said earlier when I asked you the original question, I thank you for parsing out the various knowledge, right? The second part was that Mr. Trump knew that his claims were false. And in the report, you say that Mr. Trump, and this is a quote, knowingly made false claims. So I'm assuming that talked about the false claims he made after he knew that he had lost the election. Can you describe or summarize some of these false claims he made to the American public after he knew that he had lost the election?
Sure. These would be false claims about dead voters. It would be false claims about underage voters. It would be false claims about illegal alien voters. The false claims were generally, as a general matter, about urban centers where he had lost the vote in a particular state that was otherwise close by a lot. Yes, and again, these were claims that were rebutted by people around him who knew that they were false, and in many cases told them they were false.
Can I go to January 6th itself? The president gave a speech on the rally, and we received information and testimony that a couple of things, that his supporters were leaving their weapons outside the magnetometers because they couldn't go through, and also that at some point Mr. Trump said, let them come through anyhow because they're not going to hurt me. It was subsequent to that knowledge that some of these supporters were armed, that he called on them to go to the Capitol. Was that set of facts subject to your investigation and review?
I recall what you're talking about. I remember we interviewed different people who were we interviewed people who were near or around President Trump in that period of time before the ellipse speech. And on that point, there were different recollections and different points of view. Some people said what you said. Other people had more innocuous explanations about why people stayed outside the magnetometers. Clearly, people did stay outside the magnetometers. You could see that in the video of the crowd. So I do recall that. And as I said, I remember different people hearing different parts of that and having different perspectives on it.
Metropolitan Police, as well as Secret Service, identified a number of people who were armed along the route, some of them in trees. Did you get information about that?
I don't recall. I do recall there were people who certainly had weapons at the Capitol. That I recall with certainty, and there's people who used weapons, whether they be poles or sticks or other weapons, against police officers. I know there was one officer who they took his gun. And so the use of weapons against members of law enforcement, it was outrageous, but it figured heavily in what happened at the Capitol that day.
Thank you.
I'm actually, if you don't mind, I believe it's Exhibit 10. It's your volume 1 of your report. I think we entered it as an exhibit earlier, and I'm going to direct you to page 39 of your report. And I'm going to focus on the middle paragraph. There's 3 different paragraphs on this page. I'm going to focus on the middle one that starts with Mr. Trump's intent in spreading knowing falsehoods. Do you see that paragraph, Mr. Smith?
Yes, this was this paragraph was what I was referring to when I spoke earlier.
That's what I thought. Did President Trump ever acknowledge, and I believe you talk about it in this paragraph, but did President Trump ever acknowledge that he knew that he had actually lost the election of President Biden?
Yeah, so this paragraph references different statements that he made in the presence of other people. One is that it doesn't matter if you won or lost the election, you still fight like hell. And then the other was, can you believe I lost to this effing guy?
So,
referring to Joe Biden.
So if this would have gone to a trial, and using your years of experience being a prosecutor and a trial attorney, how would you have argued this admission from Mr. Trump? Or how could you? What's a way you could have argued this admission from Mr. Trump to a jury?
Well, I think I saw these admissions as corroborative of the larger case. We would have presented what I viewed as very strong witnesses from each state to explain how the elections occurred in that state and why the events, the outcomes were trustworthy, and debunking various fraud claims that President Trump made. We would have presented the false claims that he made repeatedly, interspersed with debunkings to him or other evidence that showed they weren't true and that evidence got to him. This sort of evidence would corroborate that, but it would sort of be the cherry on top, if you will. The evidence that I felt was most powerful was the evidence that came from people in his own party who, as I said earlier, put country before party and were willing to tell the truth to him, even though it could mean trouble for them. I think witnesses like that, in my experience, would be very powerful witnesses in front of a jury, and this sort of evidence that you're pointing to here would be extra, but I think those other witnesses would be very strong proof.
And I want you to elaborate a little bit on that, on your experience with these types of witnesses. I'm assuming, individuals from the same party as Mr. Trump pushing back on his assertions of voter fraud and various other claims. Why would that, in your opinion, have been powerful to present to a jury?
Well, I think someone who puts country before party, I think my understanding of people, of jurors, that people appreciate that. I know I certainly do. The other part about that is the reality of, like, when people speak out against their political party, there can be costs. And when people are willing to pay those costs because they believe in something, because they're going to tell the truth, I think people get that. And I think the witnesses I'm talking about, if I had to cross-examine them and make them not look credible, that would be very hard. I think that would be a very hard assignment.
You mentioned just now, as part of your trial strategy would have been, having individuals from each state come up and talk about their experiences, pushing back on Mr. Trump's false claims about the election. And one of those states you mentioned earlier was Pennsylvania. And so I do want to give Ms. Scanlon from Pennsylvania a chance to ask a few questions.
Thank you. Appreciate you being here, and certainly we were paying very close attention to this whole process in Pennsylvania, since Pennsylvania was one of the main targets for the president's attempts to overturn the 2020 election. Can you just outline for us what actions President Trump, if any, took in Pennsylvania, a state that Joe Biden clearly won in the 2020 presidential election, to overturn its results and gain the electoral votes for himself?
Sure. Like the other 6 states involved, there were knowing false statements about fraud claims. You're testing my memory here, but one was, I remember, there was a persistent claim that more people had voted than it had been given ballots. And it was a very clear thing that we were talking about 2 different elections, and there's email traffic among his staff and people who work for him about how obvious this wasn't true, and persistently kept making that statement over and over again. I also remember in Pennsylvania, the chair of the Republican Party in Pennsylvania, a guy by the name of, I think his name was Tabbas, very shortly after the election, this is in, I want to say, mid to early November, disabused President Trump of the idea that the reason his vote total, his lead was going down, was because of fraud. And he explained again, that's how, we all knew that that's how this was going to work with absentee ballots in the state of Pennsylvania, which we had very strong evidence that Trump, in fact, had been briefed upon by his campaign staff. So those aren't the only examples, but they're the ones that come to mind as I sit here now.
You have a really good memory, but that first one you mentioned, the claim that there were more ballots being cast than had been issued, is one that some of our colleagues here have repeated, despite the fact that the entire state election apparatus has contested it for 5 years now. I think your report mentions the conversation that the president had with Larry Thomas, the chair of the Republican Party, in which he explained to him just a couple days after the election concluded why Pennsylvania's system had all these absentee ballots, which Democrats had embraced because the president had told Republicans not to use them. Did the fact that the chair of the Pennsylvania Republican Party told the president that there was nothing fraudulent about the fact that the Democrats' vote total was continuing to grow, did that stop the president from continuing his efforts to promote claims of voter fraud in Pennsylvania or elsewhere?
It did not, but again, that witness, Mr. Tabbas, was of a similar group of witnesses who, these are not enemies of the president. These are people in his party who supported him. And I think the fact that they were telling him these things would have had, in my view, would have had great weight and great credibility with the jury.
It's kind of the principle that we use in the law of an admission against interest. You know, when your party loyalty leads you to support the president, but instead you're saying no, he's wrong. You think that might give them credibility?
Yeah, I think witnesses of that nature would have had very strong credibility.
I agree. I know some of these folks. Did President Trump try to carry out his fraudulent elector plan in Pennsylvania as well?
Yes.
And how did he do this?
Well, what happened with the elector plan was when they came up with the idea of having these fake electors, there were certain electors who would just not put up with it. Thomas Marino, I think he was from Pennsylvania, is an example of that. And so as a result, and he wasn't the only one in the scheme generally, as a result they had to replace electors. And again, just to keep in mind, all the electors we're talking about here are people who supported Donald Trump. These are people who signed up and said, I want to be an elector for Donald Trump. And these people, when they stepped out, they had to replace them. And part of what's required under the Electoral Count Act is that there are procedures for doing that. And they couldn't follow those procedures because they were replacing people without the consent of the governor, things of that nature. Also in Pennsylvania, I believe it was Pennsylvania, there was a call where, and there's a text of this, where electors were pushing back on this and also wanting to be covered if there was liability and, you know, to be indemnified and things of that nature. And they wanted like statements in their certificates basically saying you're only going to use this if, you know, you win these lawsuits. And there was a text chain with some of the people who were carrying out this scheme for President Trump. Basically, it ended with these people should be shot because, and that we can't let this snowball like this, otherwise we're going to have to do this in all the other states.
Again, your recollection.
I'm sorry. I don't think he said these people should be shot. I think they said whoever put this slate together should be shot. I think that's what it said.
Well, I think it is one of the reasons the Pennsylvania fake electors didn't get prosecuted was because they pushed back and said, we're not going to sign this unless you include language saying that this will only be used if there are court cases say that we are the real electors. In your investigation, did you find that the people who were conspiring with the president to push this plan were telling electors one thing and then using their certificates in another way?
Yes, the electors were told that they would only be used in these circumstances, and as you know, other ways of overturning the election fell away, and as President Trump and his co-conspirators became more desperate, they came up with even more obviously illegal ways to try to stay in power, and it eventually devolved to, let's just say that these are the electors, regardless of whether any court has said so, the governor has said so, the people of the state and most have said so, and they didn't go back to electors and say, hey, we're going to use your, I know we told you we were only going to use this if we won a lawsuit. They just went ahead and used it. And I think, again, even among the fake electors, there would have been witnesses. I'm thinking of one witness in particular in Georgia who I thought would have been very powerful of, I would never have done this if I thought they were going to use my name to overturn the will of the people just because one person said so.
Okay, I mean, there were other efforts in Pennsylvania. We had the very famous Four Seasons Landscape Day press conference, which is famous to this day. But there was also a meeting that Pennsylvania State Senator Doug Mastriano hosted in a hotel in Gettysburg, Pennsylvania around Thanksgiving weekend. So, between the certification in Pennsylvania and the presentation of the electors in DC. So even though it was framed as a hearing, Giuliani attended that event and ended up speaking to promote some of these falsehoods about election fraud or wasting votes or whatever, and made it sort of a rally. Donald Trump even called into this event and claimed that he had won Pennsylvania by a lot. Are you familiar with that event?
I do recall that. I think that's in our final report.
I believe so, yes. Did you uncover anything in connection with that event with respect to what they were trying to do with Pennsylvania votes?
Well, I think they were calling them hotel hearings, and it's because they couldn't have hearings actually in the legislature, and so I don't think Pennsylvania was the only state where that happened. Now, there's obviously nothing illegal about having a political rally or having a meeting of people of one political party. Our case was about knowingly false fraud claims.
Right, yeah, it did appear to be more of just some of the kind of performative stuff that we see here where they try to make something out of nothing. Well, I want to thank you for your testimony, for your work, for your integrity, and that of your entire staff, who I know worked extremely hard and with great integrity. And wholly support your request to testify before the American people. I would really like to see that. Americans' tax dollars, including my constituents, have funded your investigation, and I think that they should hear from you directly about what you found and not have your testimony hidden from them. So, thank you.
On another state, on November 20th, Mr. Trump called Republican legislators from Michigan to the White House and urged them to remove the Biden electors and replace them with electors that would elect Trump. They, subsequent to that, made a statement that there was no evidence for that and went back, and the electors were certified as the votes had indicated they should be. Subsequent to that, in December, there was an effort to create fake electors. And in fact, on December 14th, when the electoral colleges meet in all the state legislatures, there were 16 fake electors in the basement in Michigan, and 4 of them tried to get into the Capitol to overturn the election. Did you look at that whole phenomena?
We did.
And what was your conclusion? What was how would that have played, if at all, in your prosecution?
Well, I think that event you're referring to, and I think we interviewed some of the law enforcement officers who were there that day when they were trying to get in. What they were doing and what the email traffic among co-conspirators showed is they were trying to mimic the procedures that are required by the Electoral Count Act, but they couldn't mimic them. And if I recall, the email traffic on this started with, we have to follow these procedures. And then when it became clear they couldn't follow all the procedures, it was like, well, do the best you can to follow as many as you can. And so I think, if I do recall, certain states, it may have been Michigan, that the electors had to convene in a certain government location. And so as a result, I believe there may have been a state official involved in trying to get them into, if I'm thinking of the right situation, get them in there so again they could mimic the procedures. Even though they were not the electors that represented the will of the people, how the vote was actually counted.
Thank you.
I know we're getting close to our hour, we've about 5 minutes left, so I want to end on asking about, and can you just summarize for us the actions that Mr. Trump took with Vice President Pence? What did Donald Trump want Vice President Pence to do to overturn the election results?
Well, ultimately, he wanted him to just hand him the election to say he won. There were different proposals that President Trump and his co-conspirators put to Mike Pence, but in essence, he wanted Mike Pence to impose his own choice about who should be president over the will of the American people who voted in the election.
Was one of those ways that Donald Trump tried to pressure Mr. Pence was to reject the lawful electors' certificates of their votes during the electoral counting process? Was that one of the ways that you recall?
That's correct.
How did Mr. Pence respond back to Mr. Trump's pressure about rejecting the lawful elector certificates?
I think Mike Pence, Vice President Mike Pence, falls into the category that I described before. He did something that was very hard to do. He went against his party. He paid a price for it. But I think, again, someone like that putting country over party, I think he would have been an effective witness. He did not agree to go along with it.
Did you have the opportunity to interview Mr. Pence as part of your investigation?
Can we stop for 1 second?
We go off the record. Go off the record, yeah. I'll repeat my question. Did you have the opportunity to interview Mr. Pence as part of your investigation?
I think the answer to that question might involve 6E, and so I'm not going to answer that.
Going back to the response that you just talked about with Mr. Pence's response to President Trump's pressure, is this yet another example of evidence that showed Mr. Trump knew or should have known that what he was saying to the American public was false regarding the election of 2020?
Yes. The vice president was one, and this is alleged in our indictment and our filings, was one of several people saying he was not seeing the outcome determinative fraud that Donald Trump was claiming.
And what would have happened if Vice President Pence would have gone along and refused to count the lawful elector certificates?
Well, thankfully we don't know, but I would say that he and the other people who stood up and said, I'm not going to do that, may have changed the course of history in terms of our country, of having an election where someone took power in our country who didn't actually win the election. So, as I said, I think it took a lot of courage on his part. He's also someone who, as you all know, when the attack on the Capitol happened, he wouldn't leave. People wanted him to leave. And I think, again, that reflects very well on him.
My last question, I know earlier when you were talking to the majority, there was this discussion of First Amendment issues with Mr. Trump talking about these false claims of the election. Do you remember that discussion?
Yes.
And during our hour, we talked a lot about the knowledge that Mr. Trump had, one, that he had lost the 2020 election, and two, that what he was saying to the American public was false about the 2020 election. Can you help now bring us full circle on how you analyze the First Amendment claims with the knowledge of the fraud that Mr. Trump was putting out to the American public in 2020 and 2021?
Sure. From a legal perspective, this is really quite clear. I think all of us want to make sure people's First Amendment rights are not abridged in a way that they shouldn't be. I think I certainly feel that way. I'm sure everybody in this room feels that way. But there is a very clear carve-out for fraud in our case law. The Supreme Court, I think there's one case, is the Stevens case, talks about that, and there are others. And so when you're committing a fraud, meaning you're not just saying something that's untrue, you're saying it knowing it's untrue or with reckless disregard for the truth, that's not protected by the First Amendment. People commit crimes all the time using words. And when someone commits a fraud, an investment fraud, or someone commits an affinity fraud where you try to gain someone's trust, get them to trust you as a general matter, and then you rip them off, you defraud them. That's all words, but it's not protected by the First Amendment. And in a lot of ways, this case was an affinity fraud. The president had people who had built up trust in him, including people in his own party, and he preyed on that. Some people wouldn't do it, others would. We're lucky that enough wouldn't, that the election was upheld.
Thank you. With that, we'll go off the record at 3:30 p.m. Eastern Time.
I understand, Mr. Smith, you wanted to make some additional comments about the exchange you had regarding your communications with the payday, Marshall Miller.
Yes, thank you. Chairman Jordan didn't ask me this directly, but I just wanted to make sure it was clear on the record. In the series of conversations that I had with Marshall Miller before I accepted the position of special counsel, previous to discussing the idea of working on any of these investigations, he did bring up the idea of me working on another case before that. So that happened, and I ultimately declined to work on that case, and then the other conversations happened after that. So I just wanted to put that on the record.
Okay.
Another case not related to.
Not related, correct.
At that point, were you ready to seek a new opportunity? You know, you'd been in The Hague for some time. Were you looking for an opportunity to come back to the United States?
I really loved my work in The Hague, but for family reasons, if the right opportunity happened, I wasn't desperate to come back, but if the right opportunity happened, I was willing to do that. That's one of the reasons I spoke to Mr. Miller.
Okay. At the end of the last round, I asked you whether you had any communications with the Michigan Attorney General, Dana Nessel, and you said you did not.
Yeah, I don't recall any.
And to the best of your knowledge, you don't believe anyone on your staff was having communications with the Michigan Attorney General's office?
Well, what I thought I said was, I don't recall that. It may be that we got inquiries from them. That may be possible, and it may be we responded to those inquiries. I don't recall sharing information with them or getting information from them.
But to the extent there's an allegation made that your office was coordinating with state attorney general's offices to have prosecutions go on, and different prosecutions happen in the states, would you say that did not happen and that would be false if somebody made that allegation?
We were not trying to coordinate prosecutions with other offices, no.
Okay, and you were not trying to encourage prosecutions at the state level?
No, I don't recall anything like that.
Okay. And so the same can be said with the Attorney General for the state of Wisconsin, Josh Call. Did you have any communications with him?
I've never spoken to Josh Call.
Okay.
Again, we may have got inquiries from their office, and it could be by phone or by a letter. I can't say that didn't happen.
Okay. And to the best of your knowledge, your staff did not have a regular set of communications with the Wisconsin Attorney General's office?
I don't know about regular. If there were requests, or if there were people who reached out to us, we may have spoken to them back. I don't recall with much specificity anything about that. We definitely were not trying to coordinate a case with them.
Okay. And can the same be said for the Attorney General for Nevada, Aaron Ford?
I don't even know that name, Aaron Ford. Again, I just want to be clear. This subject you're asking me about interactions with State Attorney General's office, this was not a focus of mine. As the special counsel, I was focused on our cases, our investigations, and our case and what we were doing in court in our investigations. This is the sort of thing that other people in my office would have dealt with, and so I'm probably not your best witness in terms of the level of interaction or witnesses, but I don't recall sharing evidence with those offices.
But if your office did have meaningful coordination with the state attorney generals, you probably would know about it. Is that fair?
Meaningful coordination, I don't know what that term means, but like I said, I'm trying to be as specific as I can, limited by my memory. I don't recall us sharing information or sharing our files with attorney general's offices. I don't recall them giving us their files, things of that nature. Beyond that, the number of times an office may have reached out to us and how we replied to that, I really don't have a recollection of those sort of subjects. I'm trying to be as clear as I can.
Fair enough. How about with outside Democratic lawyers such as Norm Eisen? Did you have any communications with Norm Eisen
No.
during the pendency of your investigation? Do you know if anyone on your staff did?
I don't know of anybody having such a communication, no.
Okay. And how about with Mark Elias? He is a election law attorney for Democrats.
No, I've never met him.
Okay. And to the best of your knowledge, your staff wasn't communicating with Mr. Elias?
To the best of my knowledge, yes.
Same question. A gentlelady by the name of Mary McCord.
Mary McCord, I do know. I didn't know her well, but I knew her from when I had brief interactions with her. She was, I think, at the U.S. Attorney's Office in Washington, D.C., while I was the Chief of Public Integrity. I don't recall having any interactions with her during the pendency of the investigations. At the conclusion of the investigations, one of my lawyers went to work at her project at Georgetown, and I did speak to her about that.
Okay. And what is her project at Georgetown?
It's some sort of clinic at Georgetown University. As I sit here right now, I don't know the specifics.
But you didn't have any discussions with her about the facts of the case?
No, my recollection, that may have been the first time her and I had ever actually had a conversation, her and I talking to each other.
Okay.
But we definitely didn't talk about the case while it was being prosecuted and investigated.
We've discussed, both sides, I think, have, raised the fact that President Trump was, he's being prosecuted by a lot of different tribunals at the same time. I mean, he had the District Attorney of New York, he had a civil case with the Attorney General for the state of New York. He had two federal cases. And, I had asked you about how you managed the calendar and the calendar with President Trump. I mean, there were times when he was required to be in New York 3 or 4 days of the week, and then he had to be in Florida for, I think we discussed at the end of our last round, for a pretrial motion hearing. And it just seems that at every instance when President Trump and his lawyers requested a little bit of a delay because of the cases they're defending, your office was not willing to indulge that request.
It is correct that we were not willing to indulge delays that we thought were inappropriate. I will add, and this is in the litigation, there were numerous instances where judges chided counsel for President Trump for trying to delay things. I'm thinking, as I'm saying it now, I'm thinking specifically of the executive privilege litigation that we had. This is referenced in our final report of him attempting to delay things. And so we agreed to dates that we thought were appropriate. All of that, as far as I'm concerned, was very public and transparent. What the dates were and the arguments to the judges about those dates were clear, and I thought they were fair and reasonable.
Even against the backdrop that he was being tried by the District Attorney of New York, and even against the backdrop that he was involved in a high stakes proceeding with the New York Attorney General?
Yes.
For example, at the time you proposed the DC schedule, you were also aware that Georgia prosecutors had proposed motions hearings, essentially during the same time period. If President Trump's lawyers had requested a delay for that, would you have indulged that? Or did you indulge that if they did ask for it?
I don't recall if they asked for a delay, and to consider whether I would indulge that, I would have to be back in that moment and look at the facts as they existed at that time. I don't recall that as I sit here now.
President Trump complained that he was treated unfairly with respect to access to the classified information that was at the heart of the Florida case, that He wasn't able to review the materials at the heart of the trial because of restrictions imposed by the government that required him to only review the materials, you know, on your turf. Is that something that your office did intentionally?
I think this may be one of those subjects that may be in the final report in Florida, so I don't think I can get into that.
Okay.
I'm not sure it is, but it may be, and I just want to exercise
Okay.
caution.
So I have some questions along this line. If that's going to be your answer, I understand that. So I'll just,
If you can point to a public filing where this has been discussed, I'm happy to comment on the subject in the public filing, because I think my understanding is it's pretty clear that I'm allowed to discuss public filings, and so if there is a public filing you're aware of, I'm happy
yeah,
to address that to the extent I can recall it.
okay.
I want to answer your questions as much as I can, I just don't want to run afoul
Right.
of this injunction.
The heart of the question is, you know, he had a skiff at Mar-a-Lago that was decommissioned when he was no longer president, but during the pendency of the case, it would have been relatively easy for him to get that skiff at Mar-a-Lago back up and running. And, you know, he indicates that your office blocked that and, you know, required him to only look at the classified documents, only talk with his attorneys about the content of the classified documents in a DOJ suit.
So-
And that puts us, you know, a remarkable burden on him, especially given all the other cases that he was defending.
Okay, so if there is a public filing about this, I am happy to discuss this with you. I just want to make sure that there's a public filing, so I'm not running afoul of anything in the injunction.
See if we can get it quickly,
Sure,
if not,
of course.
maybe we'll move on.
Yeah, and then we could come back.
Come back to it. After the immunity determination at the Supreme Court was decided in July of 2024, you filed a remarkably long brief in September of 2024. I think it was like 165 pages, and it, you know, the brief was very, very unusual in terms of length and content. What can you tell us about your decision to proceed with that type of meaty brief? It's almost as if you were writing your, you know, special counsel report in that brief.
Sure. So, as an initial matter, I think the vast amount of the factual material in that brief was not new. It was just put in there to address the issues at hand. The context of this is we received this immunity decision. The immunity decision affected not only the indictment, it affected the evidence we could use at trial. And so for there to be a litigation of this, the defense would have to know the evidence at trial. We would have to say, this is the indictment, and here's the other evidence that we're going to use at trial, in summary at least. We all understood, at least certainly I did, that this case was going to go up to the Supreme Court at least one more time for an interpretation of a lot of the questions that the Supreme Court left open, which we addressed in the final report. Our goal was to have that be one time, and to have the evidence and the indictment get rulings from the court. If the defense didn't like them, they would get to appeal them. That would go up to the Supreme Court. We get a final understanding, and then we'd be back before the court to try the case. And so to do that in one trip as opposed to multiple trips, and multiple trips could mean years in terms of how long it would take to try a case, that required us to go first, to in essence put this there. And I said this earlier in the day to you, one of the challenges in this case is we had, in my view, a very strong case with a lot of evidence, and trying to condense that into a brief at that stage where we were not going to be precluded from offering things that we thought were important, that could possibly be relevant to any of the immunity issues, but also have a fulsome brief. That's what we filed. It was my judgment that that was what was necessary, and I think, again, if you look at that brief, the vast majority of factual information in that brief had been in the public or something close to it in the past.
Required you to go first, or you chose to go first? Because the normal case is my understanding, you file a superseding indictment, defense is gonna make some motion, they're gonna have some reaction to that, and then you would do agree. But you flipped it.
Well, because in this particular case, we had the opinion that caused us to supersede the indictment. The court said not only what's in the indictment, but the evidence too. And there had never been a point at that point where we had put on the table, here's all the evidence that might be related to immunity. And so we needed to do that, otherwise the defense couldn't respond to it. What would have happened would be, we file a brief of our trial evidence, of our indictment, they say no or not, then that goes all the way up to the Supreme Court, then we come back from the Supreme Court, now we're gonna do a second year.
Doesn't change the question, Mr. Smith.
I'm
Was
sorry.
it required, or did you choose it?
I believe that was the most appropriate way to go forward, yes.
It's not my question. Was it required, or did you choose to go that route?
Oh, I chose it.
Okay.
But I'm sorry that I wanted to explain the reasons why I chose it.
And did you have to file a motion with the judge for leave to offer that type of filing?
We had a status conference with the judge shortly after the return of the superseding indictment, and we proposed, my choice, that sequence, but we left it to the judge to decide the timing of that sequence, of when our brief would be due.
And what was the timing of that sequence, to the extent you can recall?
I'm happy to venture a guess, but there's a public record of this. I want to say it was 2 to 3 weeks we were given to write our brief, but trust the record instead of my memory on that.
And so the brief was filed right at the beginning of October, I think, or the end of September?
Whatever the record shows.
And the election was just weeks away, correct?
The election was November 3rd?
Yes.
Yep.
Did you have any communications amongst your staff that this presented potentially a problem with the Justice Department's election year sensitivities guidelines?
So when we got the immunity decision, we had a series of decisions to make. The first was to look at our evidence and see, do we still have a case here? Do we still have admissible evidence that would allow us to proceed to trial? So that's what we did first. Once we determined that we did have that evidence, the next thing we determined is, do we need to supersede the indictment? And because there was evidence before the grand jury that the Supreme Court had clearly said was immune, we determined that we needed to supersede the indictment. And I'm sorry I'm being long, but I think the context will help. Once we determined that, we had to make sure that our conduct in going forward with an indictment and everything after complied with the election year sensitivities policy. And to do that, we consulted with Public Integrity on drafts of the indictment, on our plan forward, and as we set forth in the final report, Ping concurred that we had complied with that policy. And I would just add that policy does not stop prosecutors from trying their cases in court.
Okay. Did you or anyone in your office discuss the potential political or electoral impact of publicly filing that amount of information, just with the election a month out?
My focus was on making sure we complied with the election year sensitivities policy, which is the way the department addresses those issues.
Okay. And so, the whole purpose behind the policy is not to interfere with elections, right?
Correct.
And so, the way the policy is written, I guess, is that as long as you have filed your case and as long as you're already in court, then there's no limitations on the types of court filings you can make. Is that right?
Well, I will say, and as you know, I was the chief of public integrity. Historically, I don't recall any cases where it ever applied to anything. It was really about investigative stage steps, doing a search warrant or taking investigative steps before an election. But this is one of those issues where this is why you consult with Public Integrity, because they're now the keepers of that policy.
Right.
And so we consulted with them about the path we took, and they agreed that what we ended up doing did comply with the rules.
I mean, after you left Public Integrity, you know, there was a February 2020 memo from Attorney General Barr and Attorney General Garland, in effect re-upped Barr's memo with his own election sensitivities
Yeah.
memo. I think he incorporated it by reference, in
Yeah.
fact. You know, and this is against the backdrop that a lot of what happened during the 2016 election caused a lot of concern that what happened at FBI, what happened with, you know, both the Crossfire Hurricane investigation and the mid-year exam investigation, you know, may have affected the outcome of the 2016 election, correct?
I'm not saying that's wrong. I'm not sure I followed that closely.
Okay. I mean, you're aware of the concerns of the Justice Department, you know, in the fallout of the Crossfire Hurricane investigation.
I don't think the election year sensitivities policy was born out of that. I think it's existed for a long time and in kind of the same format for a long time. And I know the last person to sort of restate it was Attorney General Garland, who I think did it shortly before I was appointed, if my recollection is correct.
But he incorporated by reference, you know, Attorney General Barr's memo from 2020. And Attorney General Barr, you know, his memo was in the fallout, you know, it was in the wake of everything that happened with the Steele dossier, what happened with, you know, Crossfire Hurricane, and so forth. And so the question is, your 165-page brief, a month out from the election, it's, you know, it seems from an outsider's perspective that runs the risk of, you know, impacting the outcome of the election.
Yeah, we certainly were not in any way intending to affect the outcome of the election. And to make sure we complied with the policy, we met with Public Integrity to make sure we were doing that. They agreed, and they're the ones who enforced that policy. And so I felt comfortable taking the course that we did going forward.
Did your office ever consider some of the things that happened to President Trump, you know, in the 2016 election with the Steele dossier, with, you know, using the Steele dossier to get, you know, FISA warrants? Did you ever discuss any of that as you know, background that we need to be careful here with President Trump, that we don't you know, repeat some of the things the Justice Department went afoul of in 2016?
I don't recall ever discussing the Steele dossier or anything like that with my staff. I don't recall that.
And, you know, I know Justice Department officials often like to say that, hey, everyone at the Justice Department is nonpartisan, apolitical, they check their politics at the door. And I think you would say that is the case with everybody on your team, correct?
I would say that has been my experience in the Justice Department through both Democratic and Republican administrations. I've worked in the department through both, and that has been my experience.
And, you know, we learned in the fallout of the 2016, the events of the 2016 timeframe, that, you know, there's Peter Strzok and Lisa Page, and, you know, I think we can all agree they were not apolitical and nonpartisan. They were, you know, very clearly, you know, as their text message traffic, you know, bears out, they were, you know, very interested in preventing President Trump from becoming president. Is that something that you were aware of?
I was aware factually of that,
Right.
yes.
And can you agree that, you know, as the text message traffic bears out, those two officials were not, you know, nonpartisan and apolitical?
Well, I certainly agreed with Director Mueller's choice to move them off the team once he discovered those, absolutely.
And did you ever have any discussions with your senior management to make sure that your team wasn't infected by any of those types of issues?
Yes, I did.
Okay. And can you tell us about that?
So I made it clear from the day that I began at the Special Counsel's office, this was going to be a nonpartisan investigation. This was not, the politics would play no role in it. I think everybody in my office agreed to that. I can tell you of one incident where we were reviewing the email chains of agents who might be witnesses in the case for Jiggly review. And we needed them to give us all their their emails. An FBI agent who was working on the case took that direction and actually provided us with his private emails with his family. We didn't ask for that, but he gave us his private emails. In one of those emails, and I can't remember if I saw this or my deputies saw this, he was having a dispute with family members where it was about January 6th. Once I saw that or heard about that, I decided he could no longer work on this investigation. And I think that was consistent with how I ran the office. And I want to also be clear, I never saw that agent do anything that I considered partisan. But just to make 100% clear to my staff, and this is an agent who volunteered this beyond what was required. I wanted to make very clear that anything like that was not going to be part of our investigation.
The 165-page brief that you filed at the beginning of October, was there any consideration of maybe filing it under seal, at least until the election was over?
Well,
obviously you'd have to go to the court and all parties would have to agree, but certainly if all parties agreed, the judge would be amenable.
I feel like this came up in the status conference that we had. I can't recall. What I can recall, though, now that you're reminding me, is there was an issue, and this is referenced in our final report, where we filed our brief. They were given time to file their brief. They wanted more time, which would put their brief after the election. We had our exhibits, which were really the evidence, that we were citing. That evidence, they made a motion that evidence, the key facts, should be filed under seal. And before filing their motion, usually the practice is to ask opposing counsel what's your position about this. But they filed their motion before they could get our position. And so we contacted the court and we said that we had no objection to that evidence being filed under seal if the court agreed. Now, the court ultimately did not agree. And so this is referenced in a footnote in our report. I think that is pretty direct evidence that we were not seeking to put the maximum amount of facts in the public record, that we were happy to have that be under seal, and even after the election, if that's what the court agreed.
Okay, but you could have sought permission to file that big brief under seal, right?
I suppose we could have, and again, this is where my memory is escaping me. I feel like this issue was possibly discussed with the court, and I think the record of what any briefing on this or what the court said will be better than my memory about this.
Okay. Did you think it was important that evidence be in the public realm before the election, so people could make up their mind about who they were going to vote for?
No, I did not see it as our role to provide evidence for people to make their voting decisions on. Yeah, if I could, the final report on page 107, footnote 258. On the 17th of October, Mr. Trump filed a motion to delay public disclosure of our appendix to the brief, meaning the actual evidence.
Sorry, say that page again?
Yeah, sure. It's 107. I'll let you get to it. 107, footnote 258. They filed a motion to delay the appendix, meaning the evidence, until after he filed his own appendix, which would have been November 14th, well after the election.
Yeah.
So that both appendices will be released simultaneously after the election. He filed that motion before obtaining our position, so we emailed the court's chambers, copying defense, informing the court that we did not object to that procedure, meaning we did not object to our evidence being, in essence, embargoed from the public until after the election. So I think that's pretty strong evidence that we were not trying to have an effect.
Notwithstanding the fact that it's a 165-page brief that you sent.
It was.
And that's, in my understanding, first of all, you choose to do it, 165 pages. I think it's 4 times the size of the normal briefs that are supposed to happen with these type of motions. And I believe the judge said this was not typical. Is that right?
Yes, but
Judge Juckins said it was not typical.
She used a word like that, but I would just say when you say these type of motions, I think filing a brief after an immunity decision is not a common issue, and having to have a new evidentiary issue added to the mix in addition to the immunity issue, I don't think this is...
Is there any new evidence in the 165-page brief?
I'm sure there was, but as I said, my recollection is the majority of the evidence was already public. The brief emphasized how we could prove our case using evidence of his role as a candidate, as opposed to evidence that might otherwise be precluded by the official act. So, for example, a thing in the brief would be that at least 2 of the White House staff members who would have been witnesses, that they also were also working on the campaign. And so, not a particularly important fact in the world, but important for our particular brief. So there were facts like that and others that were new that were in the brief.
I just want to summarize those, but you choose to do this, not required. You go out of the normal order, so that's different. It's 4 times the size of the brief that the court wants you to file, 45 pages, and you do 165 pages. The judge herself said it was atypical. You introduced new evidence that is public, and you did this 32 days before the election. And public integrity said, just fine.
They agreed that our course was consistent and in compliance with the election year
Same public
sensitivities policy.
integrity said that all the toll analysis was just fine. Okay. Thanks.
Were you, during the pendency of the investigation, were you aware that at the Capitol on January 6th, FBI had confidential human sources?
I'm sure I probably was. I think there was public reporting on that.
But did you know that also as part of your work?
I'm sure, yeah.
Okay. And do you know how many there were?
As I sit here now, I can't recall. I know there was an Office of Inspector General report about this, that there were no undercover officers there, as had been reported, but there were informants there, some who had gone on their own.
And did your office oppose President Trump's discovery request for information relating to the confidential human sources?
I would have to look at our filings on that.
Okay. As we understand it, your office did oppose that and said any such information is not relevant to the charged conduct or as a valid defense in the case. And so consequently, you were not in favor of that. Does that refresh your recollection at all?
I'm not disputing what you're saying. I haven't read the filing. What I recall is there was also a database of evidence from January 6th that the D.C. U.S. Attorney's Office would give access to defendants who were involved in those cases, and we gave President Trump and his attorneys access to that. I'm not sure they ever accessed it, but
Okay.
I do recall that, and there may have been a filing like you talked about.
Okay. Let me make it an exhibit. The next exhibit will be number 12, and this is a letter from Stanley Woodward, Stan Brands, about the interactions they had with Jay Bratt on August 24th, 2022, before you were appointed special counsel. You familiar with the allegations that Mr. Woodward raised about Mr. Bratt?
Yes.
I'm going to refer you to 2 paragraphs in this letter. The first paragraph is the last one on page 1, and the second paragraph on page 2. And please, familiarize yourself with this. But I just wanted to flag in advance that I'm going to zero your attention in on those 2 paragraphs.
Yes.
Okay. This letter to Judge Boasberg from Brandon Woodward states that again, this is the last paragraph on page 1. Despite the purported purpose of the meeting, it began with Department Attorney Jay Bratt referencing a folder of materials in highlighting Mr. Woodward's professional background. Specifically, Mr. Bratt remarked that he was aware of the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. Mr. Bratt also advised that the government's case against Mr. Nuada was strong, referencing his belief that one way or the other, Mr. Nuada would be giving up a lifestyle of private planes and private golf courses, and that it would behoove him, Mr. Nuada, to cooperate in the government's investigation. It was inappropriate for Mr. Bratt to mention the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. The only rational inference to be drawn from this reference, combined with the assertion that the government's case against Mr. Nuada was strong, and that Mr. Woodward was not a so-called Trump attorney who would do the right thing, is that somehow Mr. Woodward's potential nomination to the Superior Court would be implicated by Mr. Nuada's decision not to cooperate in the government's investigation. Indeed, to the best of Mr. Woodward's recollection, Mr. Bratt concluded his observations with words to the effect of, "I wouldn't want you to do anything to mess that up," referring to the potential nomination. It is, of course, noteworthy that the statements giving rise to this inference were coming from a senior official with the Justice Department. I asked you whether you had a recollection of these events, and you said you did.
I do.
Do you think it was inappropriate for Mr. Bratt to make a suggestion to Mr. Woodward that, he ought to cooperate, and if he does cooperate, if Mr. Nuada chooses to cooperate, the implication was that his application to be, a judge will be looked on more favorably by the Democrats at the Justice Department?
I don't think that happened, but I'm happy to share with you my perspective on this.
Okay.
So,
And let me just say one
Yeah.
thing, if I may.
Sure.
These judges for the District of Columbia, the Justice Department weighs in on it. Is that not the case? The White House counsel's office, works to come up with the names they're gonna submit for a nomination. But the way the procedure works is the Justice Department, does the vetting.
I don't think I knew that until this issue came
Okay.
up, which I'm happy to explain. So, with the District of Columbia particularly.
Okay.
Very short time before this, matter of days, this is right around the time we had given notice that we intended to move forward with an indictment in the classified documents case of both Mr. Trump, President Trump, and Mr. Nuada. As is my practice in cases like this, we gave Mr. Trump's attorneys an opportunity to come in and give me arguments as to why not to indict the case. And in the course of my life, I've heard those arguments and sometimes not move forward on cases. In this particular situation, because my decision would ultimately be reviewed by the Attorney General, who could countermand it, that meeting was with me and Bradley Weisheimer, who was in the Justice Department. Mr. Trump's attorneys were there. It was Jim Trusty, Lindsay Halligan, and there was a third attorney who I can't remember, but I'm sure there's a record of who that was. They gave reasons why they thought the case shouldn't be indicted. And for the first time, this is my recollection, they raised this issue that somehow Jay Bratt had threatened Stanley Woodward. Now, I was surprised by this because we had interacted, I hadn't, but my counsel had interacted with Mr. Woodward numerous times over my time as special counsel. He not only represented Walt Nauta, he represented other witnesses on the classified documents case. He represented, I believe, multiple people in the elections case. And so all this time passing, this has never been raised before. I went back to my office. That meeting was at the main Justice Building. I went back to my office, and very shortly afterwards, I informed my deputy, J.P. Cooney, about this and Ray Hulser about this. They contacted Mr. Woodard to ask him about this. I believe there are notes about that, notes of either J.P. Cooney or Ray Hulser, I'm not sure. My recollection of that, and again, they would remember this better, is that Mr. Woodard expressed surprise that anybody had raised this, and he said something to the effect of, well, I know how to make a complaint if I want to. Take that for what you will. That was the initial response.
What day was this?
Yeah,
What timeframe, generally?
like early June, so like before the meeting with the attorneys was in the days before we ultimately went forward with the case. I'm not sure how late this letter was after this when I came back to the office. I tasked Mr. Cooney and Mr. Hulser to speak to the people who were present for this meeting. None of them believed that Jay Bratt would threaten Mr. Woodard. It didn't make a lot of sense that a career prosecutor would, in the first meeting with the counsel they never met, threaten them. One of the things they asked about was this issue about the judicial nominating thing. And Mr. Bratt explained that he had not met Mr. Woodard before and not had a case with him, so he had looked him up. And when you pull up information about Mr. Woodard at the time, there's a page that comes up, and we attached this in one of our motions. It says Stanley Woodard Judicial Nominating Commission. That page makes it look like he is on, at least if you look at it quickly, on the Judicial Nominating Commission, not that he has a candidacy. Mr. Bratt explained to us that he was under the impression that Mr. Woodard was on the commission and raised it as a sort of like icebreaker, like, I understand you're on this commission. Now, whether Mr. Woodard misunderstood that or some other reason, here he says he drew an inference that he was making some sort of threat. That didn't make a lot of sense to me, given all the interactions he'd had with our office. I think Mr. Woodard later started talking about a campaign against him, but he had meetings with people in my office repeatedly in positive ways. And finally, I also thought it was noteworthy that Mr. Woodard didn't bring up this issue for many months. And then the first time that he brings it up in this letter, he's doing it to seek strategic advantage because he didn't report it to OPR, didn't want it reported to OPR, never asked that. And now he wants it not only reported to OPR, but he actually wants to delay the indictment of the case until that's concluded. I will say that when we confronted, I say we, my deputies spoke to Mr. Bratt about this, he self-reported it to OPR, which is pretty standard in these sort of situations. And so, and I would also just say, this was some time ago, we did a filing on this that I believe is public, and that filing will reflect my best recollection of these things. And so I did not credit these allegations, but we made sure they were referred to OPR.
But, you know, a counterpoint to that, if Woodward has a bunch of cases before your office and he's, you know, representing a bunch of people, I mean, he may have felt threatened, but he also may have felt that it was in his strategic advantage to just try to forget about it because he doesn't want to make an enemy of Jay Bratt. I mean, isn't that a fair counterpoint?
I don't think so, based on the number of interactions we'd had with him, and also the fact that he didn't even bring it up. Someone else brought it up, and when he was, again, I was told when he was confronted with it, he was surprised someone brought it up, made a reference of, I know how to make a complaint if I need to, that was my recollection. And then when he did make the complaint, he didn't just say, I think this should be referred to OPR, he said, and it may be in this letter, that yes, I think that this, let me make sure I get the language correct. Yes, we respectfully suggest that this matter be referred to the department's Office of Professional Responsibility for a thorough investigation, and that any indictment arising from this investigation not lie until such an assessment is reached, knowing, as we do, that an OPR investigation can take many, many months. So that's my take on what happened. I think our office responded appropriately to this. I don't credit it, but at the same time, we referred it to OPR so they could look into it.
So if it did happen the way Mr. Woodward or Mr. Brand say it did, you would have an issue with that then? Is that fair?
I have no evidence that any of my prosecutors threatened defense attorneys. If prosecutors under my supervision threatened defense attorneys, they wouldn't be working with me any longer.
Okay. Woodward here is talking about essentially a veiled threat that he believes Brat was mentioning this off the cuff to try to get him to play ball with NARA's cooperation. So if that had happened, you certainly wouldn't condone that, would you?
I would not condone anyone threatening a defense attorney, but I also say that if you've practiced law and practiced criminal law, I mean, that's just not something that would work. I mean, that's not something that I've seen an experienced prosecutor do, and to do it in front of several other prosecutors. It just, in addition to, for all the reasons I said I didn't credit it, I also think it just doesn't make a lot of sense. But to your point, if, unlike this situation, a lawyer who worked under me threatened a defense attorney, yes, that would be inappropriate.
During the last hour, turning the page to a different topic, you said that you had not yet considered a sentencing recommendation had President Trump been found guilty in either one of the cases. I mean, do you think that you would have recommended a jail sentence, prison sentence, if he was convicted?
I'm not going to speculate on that because that would require a very detailed analysis of the sentencing guidelines factors, of what he was convicted of any mitigating factors. That's not something you do off the cuff, whether someone should be incarcerated or not, or how long. That's not something I would do without significant analysis.
And had your office undertaken any type of analysis on that front?
In terms of a thorough analysis, I don't recall anything like that. I'm sure that we knew how much the sentence could be in each individual thing, but I certainly had not turned to thinking about what sentences should be. As a rule, I don't do that until there's a conviction in a case.
Okay, and what would have the sentence have been for the charges that you indicted for?
I'm not going to speculate. I mean, if we sat down and went over the sentencing guidelines, we could talk about what that would be, but I have not done that analysis, and I haven't thought or looked at or thought about that issue.
Would that analysis have yielded some jail time, or recommendation for some jail time?
Again, I'm not going to speculate on that because, as I mentioned earlier, you only get to that if you try your case and you prove it beyond a reasonable doubt. We did not do that in this case. There was no trial, and we didn't do that.
Do we have any members here? Just, we only have a couple minutes left in our round, so I was just making sure
Sure.
if we had some members here that needed to ask some questions, we'll make sure we factor that in. The individual who worked for Mark Meadows by the name of Cassidy Hutchison was she was a star witness for the January 6th committee proceedings, and she made some real outlandish claims that, for example, one of them was that President Trump tried to take control of the wheel of the Suburban that he was being driven in. Is that an allegation that you're familiar with?
The circumstances regarding President Trump getting in the Secret Service vehicle after the alleged speech, yes, I am.
Okay, and what did your offices, did you evaluate that claim?
We did.
Okay, and what was your determination?
Ms. Hutchinson, regarding that particular claim, was a second or even third-hand witness. She had heard other people talk about that.
Okay,
And so we went to, we interviewed, I think, the people she talked to, and then we also interviewed, my recollection's correct, officers who were there, and including the officer who was in the car.
right,
And that officer, if my recollection is correct, and I want to make sure I'm right about this, said that President Trump was very angry and wanted to go to the Capitol, but the version of events that he explained was not the same as what Cassidy Hutchinson said she heard from somebody secondhand. That's
Okay.
correct.
On the morning of January 6th, White House officials told President Trump that people at the rally had weapons. This is the President Trump's speech on the ellipse, and that they did not want to go through magnetometers because they didn't want their weapons confiscated. Cassidy Hutchinson initially testified that no one informed President Trump before or during the rally that people did not want to pass through the magnetometers because they didn't want their weapons confiscated. During a subsequent interview, she sort of changed her tune a little bit and claimed that Deputy Chief of Staff for Operations Tony Ornato and other officials did inform President Trump that people standing outside the rally area did not want to go through the magnetometers because they did not want their weapons confiscated. Other witnesses contradicted this claim pretty thoroughly. Did your office evaluate that claim?
Yes, and I think I discussed this earlier. We interviewed a number of people, and I think on this particular claim, there were a number of different perspectives about that. I believe it was Ms. Hutchinson, Mr. Ornato, I believe Mr. Meadows we spoke to about this. As I sit here right now, I cannot recall what each of them said. I know each of them were seeing it from a different perspective, and they were with Mr. Trump at slightly different times. So as I sit here now, I can't recall, but I do recall that there were different perspectives on that question, yes.
Did your office consider whether you would call Cassidy Hutchinson as a witness at trial?
We didn't make a final determination about any witnesses, but my recollection as I sit here now is that one of the issues, there were two issues really. One, there were so many witnesses that we could have called, and there was a need if we wanted to present a case in a digestible format where there wasn't just weeks and weeks and weeks of testimony, we had to slim it down. And my recollection with Ms. Hutchinson that at least one of the issues was a number of the things that she gave evidence on were secondhand hearsay, were things that she'd heard from other people. And as a result, that testimony may or may not be admissible, and it certainly wouldn't be as powerful as firsthand testimony. So I don't recall if we made a final determination about that, but I remember in my mind that being a consideration that some of the things that she could offer testimony on would be hearsay, and we wanted to condense the case as much as possible for a clear presentation.
Did you reach a determination about whether her testimony was reliable?
I don't recall reaching any sort of conclusion like that because we were, again, far away from trial. We hadn't made final determinations.
If you were a defense attorney and you were given the assignment of cross-examining Ms. Hutchinson, would you consider that assignment a very challenging one?
Well, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do is seek to preclude some of her testimony because it was hearsay. And I don't have the full range of her testimony in front of me right now, but I do remember that that was a decent part of it, and so that would have been my first gambit if I was a defense attorney.
There was other evidence where she said she wrote a note, whether it was to Mr. Meadows or Mr. Trump,
Yep.
but it wasn't her handwriting. Eric Hirschman wrote the note.
Yes, there was a conflict between them on that issue, that's correct.
You know, a witness says, I wrote a note, that's my handwriting. I mean, that's a pretty serious, potentially false statement, correct?
Well, like I said, we didn't make any final determinations about who we were going to call or not, but there were instances, you cited a couple where we had evidence, we had different perspectives about an issue, we had secondhand hearsay about an issue, or two witnesses not remembering something the same way. So those are all accurate.
Was your office, let me restate and just say that numerous witnesses that were ensnared by the investigation complained that they were debanked. Does the term debank mean something to you?
No.
Where they were basically told by their bank that they needed to go find a different bank. And there's a long list of, Trump allied, officials that were subpoenaed for the grand jury that were, brought into your investigation that claim they had been debanked, and that Capital One told them to go find a different bank, and numerous other banks. Do you know anything about that?
No, I do not.
Okay, so your office didn't have any communications with banks urging a bank to separate from any of their customers?
I have no knowledge of that.
Are you aware of that allegation, or is this the first you're hearing of it?
I'm trying to think. I didn't know what the term meant when you first said it, so, I mean, in the scheme of the world, have I heard of the word debanking? Maybe, but if you'd asked me to define it when you first said it, I don't think I could have.
Okay. But have you, so you haven't heard that allegation that some of the folks in President Trump's inner circle have complained that they, were kicked out of their bank?
Complain to the special counsel's office?
No, they've complained publicly that the fallout from this investigation has made their life very difficult, that they have been, been forced to get a new bank because, Capital One won't support them.
I don't recall that, but I'm not denying that people may have said that. I'm not aware of it.
This is sort of the first you're hearing of it?
As far as I can recollect, yes. Well, actually, sir, can I just add one thing there?
Of course.
When you were interacting with my counsel and talking about the issues you might ask about, you said debanking was one of the issues. That was the first I'd ever heard about it.
Oh, okay. All right. Fair enough. Looks like our hour's mostly up here, so I'll stop there. Can we go off the record?
In the last hour with the minority, Mr. Smith, we asked you about folks that were interviewed during the course of your January 6th investigation. I think we talked about Mr. Giuliani, we mentioned Mr. Meadows, we mentioned Vice President Pence. An individual that I failed to ask about was whether you interviewed Director Kash Patel as part of your investigation with the Special Counsel's office.
I can't get into that because of the Judge Cannon's injunction.
Okay. Did Director Patel testify before the grand jury as part of your investigation?
Same answer.
Can you mind saying that just for the record, to make it the record?
I cannot answer that question due to Judge Cannon's injunction.
And did Director Patel assert his right against self-incrimination as part of your investigation?
Can't answer that question.
In general, just using your years of experience as a prosecutor, are you aware of any prohibitions that would prevent Mr. Patel or Director Patel from disclosing his own testimony if he did testify with the Special Counsel's office?
Just as a general matter, not specific to anything with this case, my understanding is the witnesses can disclose their own testimony.
Thank you. Mr. Raskin?
Mr. Smith, do you believe that the Supreme Court's decision on executive immunity constitutes an exoneration of President Trump's conduct in the months and weeks leading up to January 6th and on January 6th?
No.
Would you just explain that for us, why you don't see that as an exoneration for what he did?
Sure. I understand the Supreme Court decision. If I just go back for a second, this was an issue we litigated in the district court. The district court agreed with us. We litigated it in the Court of Appeals. The Court of Appeals agreed with us. We litigated it in the Supreme Court. The Supreme Court majority did not agree with us. They took a view of executive power that was more expansive than what we argued. I disagreed with it for the reasons we set forth in our brief and the reasons stated by the dissent in the case, Justice Sotomayor, but it is the law of the land. And what my office sought to do in responding to that was to follow the law and see, do we still have a case? And I think the evidence that we had after that decision remained powerful. I talked earlier today about state officials who put allegiance to the country before party. Those officials from Arizona, Wisconsin, Michigan, Pennsylvania, all those, I'm sorry.
Georgia.
All those witnesses, right, all those witnesses would still be available to us. The heart of our case would still be available to us. And I think it's important to know that, well, you know, our view was that he abused his authority in the Justice Department to effect, as one way to effectuate this scheme. This was about him as a candidate trying to say he won an election he didn't win. And so having to frame this in that manner, obviously it limited some of the evidence. That's why we had to supersede the indictment. But I don't think it was an exoneration because I still believed that there was substantial evidence that would allow us to prove the case beyond reasonable doubt.
Someone can be guilty of a crime in a factual sense, but still be immunized from prosecution, right?
Well, I mean, that's getting sort of like theoretical or metaphysical. I mean, if the court says that that's not a crime, then it's not a crime. But in our case, our view was that that ruling excised a certain portion of our proof, but all the charges we brought, we felt were still valid. We felt we still had a lot of evidence to support those charges.
Right. Did you have any questions? But I wonder if you would answer a question based on your experience as a war crimes prosecutor. And I don't know whether over the course of your long and distinguished career you've come to articulate a difference between ordinary crimes, run-of-the-mill crimes, and crimes that have some kind of world historical significance. Perhaps so, perhaps not. But I wonder if you do put war crimes, for example, in a different category from, say, for example, robberies that you've prosecuted, how you would think about classifying the crimes that you had investigated and were prepared to prosecute related to January 6th and the attempt to overthrow a presidential election.
So I think as a prosecutor, how you go about investigating those cases and make a decision to prosecute those cases, in my view, the principles in the robbery case or in my early career domestic violence case, those are the exact same principles you'd use in the most terrible war crimes case or in the work I had as special counsel. You follow the facts and the law. Nobody's above the law. You treat everybody the same. Applying those principles in more complex cases requires experience, and it's one of the reasons I felt I was qualified to do this job. But the principles, I think, remain the same. In my view, my personal view, is that the difference is the harm. Domestic violence case is awful, should be prosecuted the full extent of the law, but generally there's one victim. War crimes cases that I've worked on can affect an entire country and entire culture. I think, and this isn't just me, the Court of Appeals in this case, when we litigated it, said that if the things we alleged were proven, it would amount to attack on the structure of our democracy. Those aren't my words, those are the court's words. And so whether a case is of that import or of less, I think you go about it the same way, but obviously the consequences for our country are quite different.
Have you made any statements, or are you willing to make any statements on the firing and removal of the Department of Justice prosecutors who worked on January 6th, on people at the FBI who were involved in the FBI investigation, or on the president's mass summary pardon of 1,600 January 6th insurrectionists and other people involved?
Yeah. I think what has happened to career prosecutors and career FBI agents is awful. It's contrary to the rule of law. It's contrary to who I think we are as a country. One of the agents on our case, he served his country overseas multiple times, war zones. Family of dedicated public servants, wife's family, dedicated public servants. He got fired for doing his job 2 weeks after his wife died. I went to the funeral. I saw his family. I saw a church full of public servants. No reason a person like that should have to go through that. And I'm getting emotional. I'm sorry about that, but I just think that's wrong.
Well, thank you for your service to America and to the Department of Justice and the people.
Following up on that a little bit, if individuals are fired or lose their jobs simply for taking part of an investigation into someone who is an authority figure or in a high position of government, how does that impact our democracy?
Well, if you take the position that you cannot work in the federal government unless you have a political allegiance to the president, I think there are many harms to that. Our country tried that in the past. It's called the patronage system. And what we learned in our history is, and this would be, if it's a Democrat or Republican, would not matter. But what we learned is that those systems are rife with not only corruption, but with incompetence. Because the people who have these jobs, they didn't get them because of merit, because they dedicated their career to learning national security law, to learning how to properly investigate a case. They got their jobs because they're loyal to a particular person. That's not fair, but it also makes for people who really don't know how to do the work. And so I think that's a danger to the country. It saddens and angers me in the short term, but I think there are great costs to us long term if that's the direction we go in.
I'm going to pull on that last bit of your answer, if you don't mind, the damage it could cause long term. Do you mind elaborating that a little bit, especially as it relates to, recruiting the talent to the government, to public service who actually has the knowledge and the specialty and the competence to do the job? What types of dangers do you see if this continues?
Well, I've just seen career prosecutors who have served, again, Republican and Democratic administrations over and over again. These are the knowledge sources in the department in different areas. These are the people who mentor young lawyers. And when you take them away, those young lawyers don't have anybody to learn from. My experience in the department, again, doesn't matter the administration. These are not partisans. They're people who have decided they don't want to make a lot of money. They're not looking for fame. They just want to do good work. And I think when you lose that culture, you lose a lot.
Speaking of, sections within the government or within DOJ specifically that have particular skill sets and knowledge, I want to talk a little bit about the public integrity section, or PIN. That's come up earlier in the majority's hours, but what's the mission of PIN?
The public integrity section was formed after Watergate, and the section litigates complex corruption cases around the country. It does some of those cases on its own. It does, or at least during my time there, it also does cases in conjunction with, in partnership with local U.S. Attorney's Office, bringing expertise about some of the issues we've talked about today to them. And it also is a sort of clearinghouse for expertise on these issues, like the speech or debate clause or things of that nature.
Does the public integrity section play a role in checking potential abuses by DOJ as it relates to investigating members of Congress?
Well, in particular, I think it's valuable for prosecutors to make sure they get things right. They're the sort of keeper of these issues, and they're the people you go to make sure you're doing things the right way.
I guess, are you aware of some of the firings or dismantling that's been going on with the public integrity section since the beginning of 2025?
Yes.
Do you care to elaborate on how this might affect the investigations or prosecutions of public corruption and bribery case that you just mentioned?
Well, I'm concerned that the department is going to cease to have an ability to prosecute public corruption, that there's going to be the expertise necessary to do that, or the direction to do that. And so, again, I think there's short-term costs and long-term costs.
Isn't PIN also kind of a gatekeeper or for even beginning any kind of prosecution or investigation of public figures or congressional members? Right? Don't department regulations require that PIN be consulted or provide approval before certain steps can be taken, or litigation can commence?
That's correct. There are several enumerated investigative steps or procedures that public integrity oversees. It's not so much for public figures, but more for, again, members of Congress, people who are in government positions where the investigations are sensitive, and it's important that we get it right and we do it, work on the same standards, everyone works off the same standards.
And what happens when public integrity is dismantled and that protection is removed?
Well, it always existed during my career in the department, and I fear without it, there'll be, as I said, an inability to prosecute public corruption, and also a lack of expertise that when you do it, to do it the right way.
I think during the majority hour, there were some intimations that, PIN sometimes maybe rubber stamping approvals, or when, prosecutors consult with them, they just provide their clearance or approval without really engaging with the issues. Has that been your experience?
No.
All right.
Well, we're going to turn now to the classified documents investigation. We want to ask a few questions. We understand the disclosure that your attorney said at the beginning and some that you talked about during earlier questioning, but we do have a few questions, and we're going to interim record, it'll be at Exhibit 13, which will be the superseding indictment filed in the Southern District of Florida on July 27th of 2023. It's the United States versus Donald Trump, vaulting now to Carlos de Oliveira. And when we ask questions, we're going to be referencing this document, which is docket number 85 with the court. So I'll give you a chance to look at the document. I'm sure you're very familiar with it, but as I ask questions, I will do my best to reference paragraphs in this indictment. Before we actually get to the substance of this indictment, and I might have just said this, but I just want to make it, what court did you, or what district did you actually indict Mr. Trump for mishandling of classified documents and his obstructive behavior after he left office in 2021?
Southern District of Florida.
And can you explain to us why you sought the indictment in Florida versus, for example, Washington, D.C.?
When I took over supervision of this investigation, the investigation was pending in a grand jury in Washington, D.C. Actually, I just want to think now whether the answer to the question about venue is something, if you have a filing about that, I'd be happy to answer it. I don't think there's anything about venue in this indictment, and so otherwise, I don't want to address that in the event that it's in the final report and not somewhere else.
Okay. Understood. I understand. Actually, let's just move on then to page 38 of this indictment. Let's talk about the charges that were actually brought in the Southern District of Florida. Can you summarize for us? I know we haven't gotten to it very much, but can you summarize, starting with page 38 through 52, the charges against Mr. Trump and his co-conspirators related to the classified documents that he kept after leaving office in January of 2021?
Sure. Counts 1 through 32 charge Donald Trump with willful retention of national defense information. This regards classified documents. The remaining counts relate to, and they charge Donald Trump, Waltine Nada, and then other counts, I believe, also charge Carlos de Oliveira with various counts relating to attempting to obstruct that investigation, whether it by be moving boxes so that those boxes wouldn't be found by an attorney who was doing a search of documents to return to the government, and also false statements by, I believe, both Mr. de Oliveira and Mr. Walt Nada, and I think there's also in here counts related to attempts to destroy video footage and delete security camera footage related to all three of the defendants.
Thanks. Let's walk through what you just described, but through the lens of the indictment. So let's start with page 10. I believe you talked about boxes of classified documents, and you were just giving your summary. Can you describe, there's a picture on page 10. What do we see in this picture on page 10 of the indictment?
Okay, these are some of the, and it's referenced in the paragraph above. These are some of Donald Trump's boxes that were brought from the White House and then stored in various places. In this particular photograph, it shows them being stored on a ballroom stage at the Mar-a-Lago Social Club.
And do you know what, you said the ballroom, is the gold ballroom? I believe that's what's in the indictment in paragraph 26?
The white and gold ballroom, yes.
White and gold ballroom. What was the purpose of including these photos in the indictment?
I think it was important to lay out the facts of our case, and sometimes a picture can lay out the facts more clearly than words, and can make the words have more clear meaning. And so here, I think they show the sort of circumstances in which these boxes were being kept, boxes that contained highly classified documents.
So going along that same theme, if we go to page 12, there's another picture of, it appears, boxes. Can you describe to us, and I believe it's in the indictment, so in paragraph 30, but can you describe what we see in this picture with the boxes on this page 12 of the indictment?
Yes, I think the photo on page 12 actually refers to the paragraph before that, the paragraph 29. And this is, the indictment lays out that these boxes were moved around to various locations where lots of people had access to them. After they were on the ballroom stage, they were in a business center, and then moved to a bathroom and shower in the lake room. And you can see that you can see the shower curtain behind the boxes. And so that's the room that's referred to there.
And the last picture I'm going to ask about is on page 14, and on paragraph 32, it looks like Mr. Nata texts another employee and says, quote, "I opened the door and found this," and attached two photographs that he took of the spill, it looks like, of documents. Can you describe this picture as well, which is on page 14 of the indictment?
Sure. So this refers to paragraph 32 of the indictment, and I believe it's blurred out in this picture, but one of the classified documents that's actually charged in the case is visible in this picture. I think it's count 8, and this is a room where others had access to. Obviously, someone was able to go in there and spill this box of documents, and Mr. Nata took a picture of it, so I think it shows how accessible these documents were and the sort of manner in which they were, the care with which they were kept.
The court-authorized search of Mar-a-Lago has been subject of lots of discussion on this committee. I think an important question to ask, I'm going to reference paragraph 38 on page 17, was whether any government agencies or individuals within the government had tried or attempted to collect the classified documents from President Trump after he left office in January of 2021.
Yes. Sticking specifically to the indictment we have in front of us, beginning in paragraph 38, these paragraphs detail efforts by the National Archives and Records Administration to recover, I think originally it wasn't to recover classified documents, it was to recover presidential records that were missing. In the effort to do that, and as you can see, that took several months, what they eventually got was a number of boxes. I believe it was, I think he said it was going to be 12 boxes, and then it was 15 boxes, yes. What came back was a large number of highly classified documents, including secret documents, top secret documents being documents that would cause grave danger to the national security.
Turning to page 21, paragraphs 51 and 52, did the FBI open a criminal investigation into the potential classified material at Mar-a-Lago after President Trump left office in January of 2021?
That's correct. The dates are stated here. And that was obviously before I became special counsel.
And did a federal grand jury open an investigation, which I believe is referenced in paragraph 52?
Correct.
And why did the FBI open its investigation, the federal grand jury open its investigation based upon the referral of an agency? And I believe it might be referenced in paragraph 50.
Yes, there was a referral by NARA to the Department of Justice on February 9th.
Staying on page 21, after opening its grand jury investigation, did the grand jury issue a subpoena for all documents with classified markings?
Yes, and you're referring to paragraph 53, is that correct?
Yes, sir.
Yes, the grand jury did.
So after sending out this grand jury subpoena, I believe this is when the most of the obstructive conduct takes place. And so we're going to be flipping through pages 21 through 26 of the indictment. And I believe the indictment even titles this conduct as the defendant's concealment of boxes. Sticking to the indictment, can you summarize for us the efforts that the defendant took to conceal the boxes of classified documents in Mar-a-Lago?
Sure. So paragraph 53 references the fact that a grand jury subpoena was issued on the 11th of May, and that two attorneys representing Donald Trump informed him of the subpoena, and he authorized them to accept service. So he was on notice of the subpoena at that point. 11 days later, Walt Nato, who was the parlance, I think, is his body man. He'd previously been a valet for him at the White House. Went into the storage room, which was the landing place, the last place these boxes were, and left 34 minutes later carrying one of President Trump's boxes. The next day is the day that Donald Trump met with his attorneys to discuss the subpoena. They told him that they would need to search for the subpoenas and provide a certification to show that they were in compliance with the subpoena. And below that is a number of statements that one of those attorneys memorialized that Donald Trump said during that conversation. And paragraph 56 would be as well. Paragraph 57, Donald Trump confirmed his understanding that one of those attorneys would return to the club on June 2nd to search for any documents with classification markings to satisfy the subpoena. And Donald Trump indicated that he actually wanted to be there that day when he returned to look at the boxes. He told the second attorney that second attorney didn't need to be there. And so after that meeting, he had planned to depart Mar-a-Lago, but he changed his summer plans to be there on the 2nd when the first the attorney came to review the boxes.
I'm going to stop you real quick.
Sure.
So I want to make sure this movement of boxes is clear from the indictment, and I want to reference paragraph 59, I believe. So it sounds like you were able to determine, the evidence showed from this indictment, that Mr. Trump directed Mr. Nato to remove the boxes of documents from the storage room in Mar-a-Lago. Is that correct?
Correct.
And how many boxes in total did Mr. Nato remove from the storage room in Mar-a-Lago? And I believe it's referenced in paragraph 59 as well.
Yes, I believe, as it says in paragraph 59, between the 23rd of May and I think it was June 2nd, he removed at Donald Trump's direction a total of 64 boxes and brought them to Trump's residence.
And he took them to Mr. Trump's residence from the storage room, is that right?
Yes.
And just to confirm, Mr. Nato moved these boxes just a day after Mr. Trump met with his attorneys about responding to the grand jury subpoena, is that correct?
Well, yes, he'd actually, the first day that is listed here is in paragraph 54, when he moved the first box, and then yeah, so then if you look at paragraph 59, subsection A, 3 boxes were moved on the 24th. On the 30th, Trump and Nato spoke by phone for about 30 seconds, and very shortly after that, over a period of a little less than 2 hours, Nato moved another 50 boxes from the storage room. That same day, there was a text exchange between Nato and the president's wife, and in that, she, I'm summarizing here, but it's on paper. She was saying, we're not going to have room for all these boxes on the plane, and Mr. Nato replied, I think he wanted to pick from them. I don't imagine him wanting to take the boxes. He told me to put them in the room and that he was going to talk to you about them. And then on the 1st 11 more boxes were moved out of the storage room.
So let's, that's a lot of movement of boxes, right? And it makes sense that it's under the concealment of evidence section of your indictment. I believe going to paragraph 63, you provide a pretty succinct summary of the number of boxes that were moved versus the number of boxes that were returned to the storage room. So do you mind summarizing that piece for us so we understand exactly how many boxes were left in the summary room?
So paragraph
Or the storage room, sorry.
Sure. Paragraph 63 summarizes that between May 23rd and June 2nd, NAUDA, at Trump's direction, moved 64 boxes from the storage room to the residence. And then afterwards, NAUDA and De Oliveira returned to the storage room only 30 boxes.
So there were only 30 boxes left in the storage room, although there were 64 boxes that were at Mar-a-Lago, to your knowledge, based upon this indictment.
Well, they returned 30. How many more were still in there that they hadn't taken at all? That would be added to that.
Why was there any significance to moving all these boxes prior to June 2nd of 2022? And I believe this is referenced in the false certification of the FBI section of the indictment. But what's the significance of moving all these boxes just before June 2nd of 2022?
Because Donald Trump was on notice that his attorney was going to search that room, search for classified documents in that room, and in between the time he was put on notice of that and the time that he actually did that, at Donald Trump's direction, 64 boxes were taken out, but only 30 were returned.
So how many boxes did Mr. Trump's attorney actually review when he returned to Mar-a-Lago for the review on June 2nd of 2022? And again, I believe this is in the false certification section of the indictment.
Right. The attorney looked through all the boxes that were in the room and located, reviewed the contents of the boxes in the storage room, and he located 38 documents with classification markings that he took out and he put in a red roll folder, and that he then taped up.
Did the evidence show in the indictment that Mr. Trump's attorney believed that he had reviewed the entire universe of documents at Mar-a-Lago?
I'm trying to see if that's here in the indictment. I could answer that question. Well, I can't answer anything that's not in this indictment, but
And just to make it clear for the record, why can't you answer anything that's not clear in this indictment?
well, that issue, the question of whether he reviewed, in his view, all the boxes, if the answer to that would be within the final report, and again, I don't have a recollection one way or the other, unless there's another public filing about that. My understanding is I can't discuss issues like that due to the injunction.
Understood. Let's move on to the next section about the attempt to delete security camera footage. And we're working our way up to this August court-authorized search of Mar-a-Lago, if you can't see where we're going here. So on page 27, that's the section that starts the attempt to delete security camera footage. Did the evidence show that Mr. Trump attempted to or tried to direct someone else to delete security camera footage at Mar-a-Lago?
Yes.
Can you please describe from the indictment for us what evidence showed that Mr. Trump directed someone to delete security footage at Mar-a-Lago?
Well, just speaking to what's in the indictment, not anything outside it unless you direct me to public filing. It starts on paragraph 74 and it goes through paragraph 87. Is there any particular part you'd like me to
I'm going to
address?
start with June 22nd of 2022. It's paragraph 75. I believe the Department of Justice sent a message to an attorney from Mr. Trump's business organization that might have provided knowledge for him. What was emailed to an attorney from Mr. Trump's business organization that kind of started off this process?
There was a draft grand jury subpoena for the production of security camera footage. And the previous paragraph notes that agents had observed surveillance cameras near the storage room where the classified documents were stored. And so a draft subpoena was sent on the 22nd of June.
Yes. And then following the draft grand jury subpoena being sent to the attorney for Mr. Trump's business organization, it looks like Mr. Trump had a phone call with Mr. De Oliveira the day after, on June 23rd of 2022. Is that correct?
For 24 minutes.
Yes. And then the actual subpoena was sent by the Department of Justice to an attorney for Mr. Trump's organization on what day? And I believe this is in paragraph 77.
Yeah, Friday, June 24th.
And what was that subpoena? What records was it requesting?
Any and all surveillance records, videos, images, photographs, and/or CCTV from internal cameras at certain locations at the Mar-a-Lago Club, including on ground floor basement, from January 10th to June 24th of 2022.
Notably, the same day that the Department of Justice emailed Mr. Trump's attorney the actual final grand jury subpoena, it looks like Mr. Trump may have tried to reach out to Mr. Nauta, and it's described in paragraph 78. Do you mind discussing or telling us what this interaction might have looked like between Mr. Trump and Mr. Nauta?
What paragraph 78 describes is an attorney for Trump speaking to Donald Trump about the subpoena for security footage. A little over 2 hours later, Waltine Nauta received a message from a coworker indicating that Trump wanted to see him. And then less than 2 hours after that, Nauta, who was supposed to be traveling with Trump to Illinois that day, changed his plans to travel and began making arrangements to travel to Palm Beach instead of Illinois, where he was scheduled to be with Trump.
So fast forward to paragraph 80, the same day, we're still on June 24th, right? So Mr. Nauta changes his travel plans, and then Mr. Nauta and Mr. De Oliveira, it looks like they reach out to a Trump employee. What position did the Trump employee have that Mr. Nauta and Mr. De Oliveira reached out to? This is in paragraph 80.
Let's see. He was the Director of Information Technology.
And what was, and this is in the subsection of paragraph 80, subsections A through E, what was the nature of the conversation between Mr. Nauta, Mr. De Oliveira, and the Director of Information Technology at Mar-a-Lago Club?
Paragraph 80 reflects a series of contacts and conversations. First, Nauta reaching out to the Director of IT, asking if he's around. Nauta then also reaching out to De Oliveira, and then it appears they had a call after he reached out. And then that same employee, the Director of IT, texted back to Nauta that he was available. Nauta responded to that. At 6:56 that same day, De Oliveira texted the Director of Information Technology saying, "Hey buddy, how are you? Walter called me early, said it was trying to get in touch with you. I guess he's coming down tomorrow. I guess needs you for something." And the employee responded that he reached out but didn't say what he wanted. I told him I'm local, entertaining family that came from New York City, and he told me no worries. And then the last entry is Trump, that same employee, the Director of Information Technology, texted Nauta to say, if you need me, I can get away, just let me know. Nauta responded saying, sounds good, thank you.
So fast forwarding to paragraph 82, because now we're moving on to the next day, which is June 25th. After having these conversations, it looks like Mr. Nauta and Mr. De Oliveira actually go and look at some of the information technology at Mar-a-Lago Social Club. Can you tell us what Mr. Nauta and Mr. De Oliveira, who did they go visit? I think they went to a security guard booth, is that correct?
Yes, there's a security guard booth where in that, at that booth, it has where the cameras are, so you can see where the surveillance cameras, like that would be where you could see them. And then they walked with a flashlight through the tunnels where the storage room was located and observed and pointed at the surveillance cameras that were there.
And then Monday morning, first thing in the morning, or 9:48 a.m. in the morning on Monday of June 27th, 2022, and I'm trying to keep this tight timeline going. It looks like Mr. De Oliveira continues talking or at least visiting other IT officials at Mar-a-Lago. I believe this is in paragraph 83 and 84. Do you mind summarizing what happened just 2 days later on June 27th of 2022? And as you can see, we're building our way up to July and the August court authorized search of Mar-a-Lago.
So that day, this is paragraph 83 and 84, De Oliveira walked to the IT office where this same director of IT was working with another employee. There were two people there, and requested that the director of IT step away so he could talk with him. They left the area and they walked through a basement tunnel to a small room that was known as an audio closet. And once inside that closet, he told them, he being De Oliveira, told the employee first that their conversation should remain between them. He then asked how many days the server footage was retained, and the employee told him approximately 45 days. And then De Oliveira told the employee that the boss wanted the server deleted. The employee responded that he would not know how to do that, and he did not believe he would have the rights to do that. Trump employee, that same employee told De Oliveira that De Oliveira would have to reach out to another employee who was a supervisor of security for Trump's business organization. But De Oliveira persisted and insisted that insisted to Trump employee that the boss wanted the server deleted and asked, what are we going to do?
That same day, so June 27th, I believe, of 2022, did the evidence show that Mr. Trump had any conversations with Mr. De Oliveira? And I'm referencing paragraph 87.
Yes, on 3:55 p.m., they spoke for about 3.5 minutes.
So we're on June 27th of 2022, and then we move to July of 2022. Did the FBI and grand jury actually obtain any of the surveillance that they requested through their grand jury subpoena?
They did.
And then following the FBI and grand jury obtaining the surveillance video, can you explain what happened? And this is referenced in paragraph 89.
Sure. The FBI executed a search warrant at Mar-a-Lago. The search warrant was authorized the FBI to search and seize, among other things, all classified documents. There's one thing I just want to correct, though.
Yeah.
The chronology we've gone through, all of those facts were not known to the FBI at the search warrant. Many of them were, but for example, this last bit where we talked about attempting to delete the server, that was not uncovered until later.
Thank you. And during the execution of this court-authorized search of Mar-a-Lago Club in Florida, did the FBI actually seize any documents with classification markings?
Yes.
And approximately how many documents did they seize with classification markings?
Paragraph 90 states that they seized 102 documents with classification markings. And there's a chart that lists the level of classification and where they were found.
And just a note for the record, some of the classification markings that were found included top secret classification markings, secret and confidential, and as you just said, for a total of 102 documents.
Yes, and if I could, I want to correct something I said before. I stated what it means if a document's top secret, and I said it is grave damage to the national security. Actually, a top secret document, and I'm looking at paragraph 14A, is information that reasonably could be expected to cause exceptionally grave damage to the national security. Secret is grave damage to the, serious damage to the national security.
Going back and taking a step back, say actual Mar-a-Lago Club, and this is referencing paragraphs 11 through 13. Was the Mar-a-Lago Club a place that members and staff frequently attended or was in the presence of or on the location of Mar-a-Lago?
Can you direct me to a paragraph again?
Paragraphs 11 through 13.
And I'm sorry, what was your question?
Were there
again?
hundreds of members of the Mar-a-Lago Club?
Yes, there were hundreds of members and 150 full-time or part-time or temporary employees.
Were some of the members or people who attended Mar-a-Lago, were they foreign nationals?
I can't answer that question.
Were any of the staff that might have worked at Mar-a-Lago foreign nationals?
Both of those are questions I can't answer because they're not in the indictment here. If you have a filing about that, I'm happy to answer those questions.
And were any of the temporary employees, were they foreign nationals?
Same answer.
In addition to just the members and the staff that were there, what types of events might have been held at Mar-a-Lago where these classified documents were found during your court-authorized search in August of 2022? And this is referencing paragraph 12.
So paragraph 12 states that in the period between January 2021 and August of 2022, the club hosted more than 150 social events, including weddings, movie premieres, fundraisers, and those events together drew tens of thousands of guests.
We're going to enter into the record 2 exhibits. I believe they'll be exhibits 14 and 15. Thank you. Exhibit 13 will be a House Judiciary GOP tweet that says, "This is what happens in third world countries, not the United States. Doesn't the FBI have better things to do than harass the former president?" And this tweet is from August 8th of 2022. And then exhibit 15 will be an August 8th, 2022 tweet from Speaker Kevin McCarthy that says, "Attorney General Garland, preserve your documents and clear your calendar." What is your response to statements, and actually I want to preface this by saying, look, I understand that you were not the special counsel when this search was conducted in August of 2022, but what is your response to statements made accusing the FBI of harassing Mr. Trump in the aftermath or after the FBI conducted its court-authorized search of Mar-a-Lago?
I don't think those statements are accurate.
Do you, can you explain why you do not believe they're accurate?
The search of the Mar-a-Lago Social Club was conducted pursuant to a warrant, a search warrant, as the Department of Justice and FBI does every day, continues to do every day. It was approved by a United States magistrate, and
In your prosecutorial experience, can you describe what types of factors a prosecutor would have considered before seeking a court order to search someone's home or private residence?
well, most clearly, you would need to have a factual support for that basis, and a reason to believe that evidence of a crime would be recovered, and probable cause to believe it would be recovered at the location you're asking to search, based on the facts.
And that's kind of, we just went through the indictment, the various paragraphs we just went through in the indictment, is that correct?
That's correct.
Can I just wrap that
Yes,
up in a
please.
bow? So
Yes, please.
before there was the court-ordered search at Mar-a-Lago, your folks went before a court and established probable cause that a crime had been committed and that evidence of that crime would be found at the site of the search, Mar-a-Lago.
It was before I was special counsel, but yes, they presented an affidavit to a court, and that court approved a search warrant.
Okay, thanks.
And even earlier than that, I mean, would you say that President Trump had multiple opportunities to return the classified documents that he had retained back to the federal government voluntarily?
Yes.
He had an opportunity to return them when the National Archives first asked for them back, right?
Yes.
And then he also had another opportunity to return them when he was subpoenaed by the grand jury, right?
Correct.
And he did not return all the documents during that time, right?
That's correct.
And based on your indictment, is there information that led you to believe that he was aware that at least some of these documents are highly sensitive documents?
Yes.
Can you draw any conclusions about his refusal to return those documents in spite of having been given multiple opportunities?
I don't think I can answer that question because it may involve non-public facts that are part of the final report that is currently under an injunction.
Can you draw any conclusions about his motives for refusing to return those documents?
Unless you can point me to a filing or a public filing on that issue, I don't want to run any risk of running afoul of the injunction, and so without a public filing on that issue, I don't think I can answer that.
Just one last question. Did you come across in the course of your investigation any evidence about why President Trump took those documents in the first place?
Again, I don't think that's in the indictment here, and unless you have a public filing, that, given the current state of the injunction, I don't think that's a question I can answer.
Thank you.
So starting in paragraph 33 on page 14. Mr.
Sorry.
Mr. Coffey.
Oh, yeah. I mean, just one other fact to mention. This is my counsel just gave me, this is a filing on the docket of Southern District of Florida. This is an order from Judge Cannon on June 27, 2024, denying a Franks hearing.
We'll make that an exhibit.
Yeah.
We have that.
And this issue about whether there was in fact probable cause for the search warrant was litigated, and the judge denied the motion for a Franks hearing. And found, and this is in footnote 2, that the defense motion does not even meaningfully challenge the presence of probable cause in the affidavit.
Thank you. And we've marked this order denying the motion for a Franks hearing, which I believe is document 655 dated June 27th, 2024. We marked it as exhibit 16. I know with the, how much time do I have left? 5 minutes? About 6 minutes. All right, my remaining time, I want to talk about and direct you to paragraph 33, and I believe this focuses on conversations at the Bedminster Club. The Bedminster Club is separate than the Mar-a-Lago Club in Florida, is that correct?
Yes.
Okay. And the Bedminster Club's in New Jersey? Is that your recollection from the indictment?
Yes.
Okay. In paragraph 36, you detail a meeting at the Bedminster Club in August or September of 2021. Can you describe what happened in this meeting and whether Mr. Trump shared classified information?
Well, I just want to start by saying I don't feel like I can say anything more than what's in the indictment here, unless you point me to anything otherwise. So I can read a portion if you want.
Please.
Well, in paragraph 34, references on July 21st of 2021, Trump gave an interview, and this was when he was no longer president, at Bedminster. 2 members of his staff were there, and the interview was audio recorded with his knowledge and consent. Before the interview, media had published reports that at the end of Trump's term as president, a senior military official purportedly feared that Trump might order an attack on Country A, and the senior military official advised Trump against doing so. Paragraph 35 says, upon greeting the writer and publisher and his staff members, Trump stated, quote, "Look what I found. This was senior military officials plan of attack, read it, and just show it's interesting. And then following that, there are additional statements that Donald Trump made regarding the document that he was showing and what other people in the room said.
Going to paragraph 36, did the individuals that Mr. Trump shared this information about the ongoing military operations with, did they have the security clearance or need to know about the classified information about that military operation?
In paragraph 36, it states that the PAC representative did not have a security clearance or any need to know classified information about the military operation.
Are you aware of whether the FBI conducted a similar search of Mr. Trump's residence at Bedminster?
Whether that happened or didn't happen, I'm just trying to be very cautious. I don't think I can answer that due to the injunction.
Do you think that the FBI was able to retrieve all the classified documents that President Trump improperly retained after he lost the 2020 election?
I'm struggling because I can't recall if that is in the final report, and because I'm not sure of whether it's in there, I don't think I should answer that question.
All right, we'll go off the record.
record marking Exhibit 17. This is on the topic of the misordering of the documents, and there's a filing that I wouldn't ordinarily mark, but given the situation on the Florida case, we'll mark that because you, your office addresses what came to be a misordering of the documents. And so the question is, do you have any information about how the documents that were seized from Mar-a-Lago were misordered?
Let me start by saying I think there's also another filing on this
Okay.
that we did later as well. So between those two filings, what I can tell you is when a search warrant is executed at a location and there are documents in boxes, the search warrant can be executed in a manner where you just take out the documents that you're looking for, or you take the box with the documents that surround that box. Both ways are proper. In this particular case, obviously the search warrant happened before I was special counsel, and the special master litigation occurred, or began certainly before I was special counsel. In that litigation, my recollection is that President Trump's attorneys took the position that the government should not have even taken all the documents in the boxes and just taken the classified documents, such that if things were done the way they proposed, there would not be other documents in the boxes. It would just be those. As I think we set forth in our filings, when this issue got raised initially in court, our attorney misstated that the documents were in fact in the exact order that they were found. I think you can see from the timing of these filings that once we realized that was incorrect, we corrected it with the court as quick as we could. And then at that point, when President Trump's attorneys were now alleging that this was an important issue, we looked into in more detail exactly why it was not possible to keep the documents in the exact order. And I would just say, everything I say today, I'm deriving just from the filings we did on this. But my recollection from those filings is that one of the central issues about keeping the documents in the same order is that President Trump kept these incredibly highly classified documents in boxes with all different sorts of things of all different sorts of shapes and sizes. Clothing, memorabilia, newspaper clippings, things of that nature. And so while agents, I think, sought or wanted to keep the documents in order as best they could, I think once they saw the order of these boxes, clearly that was going to be an impossible thing to do. And so we set out our views about that in these filings. And again, I'm speaking only from these filings.
What's the upshot of the documents being taken out of order?
My view is there is no upshot in the sense of these documents were, staff members referred to these documents as the, quote, beautiful mind boxes, meaning they were, and this wasn't just one staff member, it was multiple staff members, and they referred to the fact that Donald Trump, these were his boxes, they were exclusively his belongings in them, he had curated them and what was in them. And so in our view, that was not a live issue in the litigation. Once the defense raised it and said, oh, now that you can't say what order they're in, we think that's a big issue, we responded. But I think ultimately in the litigation, given President Trump stated that he believed these were all these were his documents. And so the litigation in this case, in my view, was not going to turn on the location of documents in the boxes, given his position was, all of this is mine.
Do you know if he was intending to save those materials for his presidential library?
You mean the classified documents?
The items in the boxes, all of them.
Well, if his defense were that he was intending to take classified documents that he had no authority to take, and he did it intentionally because he wanted to start a presidential library and keep those documents in the locations that we talked about today, that's a crime.
No, but my question was all the items in the boxes, the shirts and the other mementos, were they being saved for a presidential library? To the extent you were able to develop that in the course of your investigation?
You know, I mean, there were newspaper clippings in there. There were, I think, you know, different sorts of things that wouldn't to me seem like the sort of things that would be in a presidential library. To be honest, I've never been to a presidential library, so, but if I were starting one, I don't think that's the sort of things I would put in it.
Okay, but you didn't develop any evidence during the course of your investigation that the materials were intended to be saved for a presidential library?
I don't recall that, and I also want to be careful of not getting outside the parameters of these filings, because I don't think we addressed that issue in the filings we're talking about.
Okay. And during the times relevant that we're discussing, Mar-a-Lago was protected by the Secret Service. Is that correct?
That's correct.
So to the extent an adversary wanted to come in and steal some of these classified documents, they would have had to go through the Secret Service to get them, right?
Well, as we alleged in paragraph 13 of the indictment, the Secret Service provided protection services to Trump and his family after he left office, including at Mar-a-Lago, but it was not responsible for the protection of boxes or their contents, and the indictment states that Trump did not inform the Secret Service he was storing boxes of classified documents at Mar-a-Lago, meaning they didn't know that they were protecting classified documents.
But if Joe Q. Citizen had classified documents from their time serving in government and they brought it home to their basement, and some foreign adversary was aware of that, it would be much easier for a foreign adversary to break into the Joe Q. Public's basement and take those classified documents. If the foreign adversary wanted to go and get those documents out of Mar-a-Lago, it would have been a lot more difficult. I mean, a person can't just walk into Mar-a-Lago and try to abscond with these materials, right?
I would very much like to answer that question, but I cannot answer that question due to the final report.
Was there an effort by your office, did you consider seeking the removal of Judge Cannon?
Again, I don't think that's in any public filing, and so I cannot address that given the injunction.
Whether, you know, the internal office discussions involved consideration of removing Judge Cannon? I mean, that's not something you can talk about?
I don't think I can talk about things today, again, consistent with our discussion this morning. If it's not in a public filing, I haven't seen the final report in almost a year. I'm not comfortable discussing issues like that solely because of that issue.
Okay.
I'm trying to be as consistent as I can about that.
Okay. The book by the Washington Post reporters that we were referencing earlier reported that you considered, and by you I mean your office, your collectively, the collective you, considered petitioning the removal of Judge Cannon, but the Solicitor General's office recommended against it because and if you had gone to the Attorney General, that would have had to been reported to publicly reported to Congress. Is that something you have a recollection of?
Mr. Kessler, sorry, I just, on this point, I just want to make sure that we're in agreement that the Department of Justice has taken an expansive interpretation of Judge Cannon's order in its application to Mr. Smith, and that he's not permitted to disclose non-public information that may be contained in Volume 2 of the Special Counsel's report. And I know you cited this book, but the email that we both received from the Department of Justice this morning said that this prohibition does not apply to information that has been made publicly available through authorized means. And so if something was leaked to some reporters who wrote a book about it, I would not consider that to be made publicly available through authorized means.
Okay. You got a page? Noted, and I'll just to give more context to what I asked, it's on page 349 of the book. It states, the final straw for Smith came when Cannon dismissed the documents case, citing as a basis Thomas's concurring opinion, which carried zero legal weight, making the choice a striking departure from judicial standards. Solicitor General Elizabeth, how do you say her? Is it Prelager?
Prelagar, I think.
Prelager? Okay, excuse me. Ultimately approved the appeal of Cannon's ruling, but the former Garland law clerk rejected Smith's plan to seek to have Cannon recused, saying he didn't have enough evidence to try to remove her. Smith could have asked Garland to reconsider his trusted counselor's position, but he did not. If Garland turned him down, it would have to have been reported to Congress. And so I guess the question in light of your counsel's observation is, if you asked the Attorney General for something and he turned you down, wasn't your understanding that it had to be reported to Congress?
So putting aside this whole
Yes.
situation, I believe it states something to that effect in the special counsel regulations.
Okay, and was that something you were concerned with? That you wouldn't want something like that reported to Congress?
That was not a concern of mine.
Okay. I believe earlier you indicated you did not have any communications with White House officials. I think that Marna already asked you about whether you spoke with President Biden. You said no. Did you have communications with any White House staff?
I did not.
Okay. Did anyone in your office?
My office interacted with staff in the White House in the following ways. There was one instance where, that I recall, where we sought to interview a career National Security Council staffer, and to make arrangements to do that interview, we had to do it through the White House. With respect to the classification of the documents that we were using in the classified documents case, there were some of those documents the National Security Council had equities in, and as a result, we needed a contact point to speak to, I believe it was to speak to a career person who could be our contact point for that classification review. And so there was interaction between my staff and people, I believe, from the White House counsel's office. I would add that all of my understanding and my direction was that any interactions would be pursuant and consistent to the White House contacts policy.
Okay.
And I think also in the beginning of my time as special counsel, there was this litigation I referenced previously about executive privilege. And we noticed both the current White House and though I don't know that we had to, we noticed also President Trump on that in terms of whether they would waive executive privilege or not. I think in that instance, I'm not sure of this, but I think in that instance, we requested the DAG's office to ask the White House about that, and so we didn't have direct contact, but I wasn't involved in those contacts, so I'm not sure.
Okay. So nobody in your office had communications with White House Chief of Staff Jeff Zients?
Not that I recall.
And nobody had communications with the counsel's office in terms of your strategies for prosecuting these cases?
No.
In conjunction with your final report, a letter was prepared by President Trump's defense counsel, Todd Blanche and John Lauro, and they raise issues concerning their review of the report over the Christmas season. And they indicate that they were placed in a veritable hardship trying to review the report because the special counsel's office required them to come to DC. The special counsel's office wouldn't let them, use their laptop. They wouldn't, have access to any, internet. Can you walk us through your posture on some of those onerous conditions that defense counsel raises?
Sure, and just for clarity, I'm going to confine my remarks to the election side case because whatever letter they sent or didn't send regarding the classified documents case, I don't remember if there was a letter, but I don't want, for the reasons we talked about, talk about that.
I am referencing the letter in the part 1 of the report.
Okay, great. So I do recall that, and I recall being surprised and disappointed about their letter on that point because my recollection is that I'm not going to remember the specific dates, but I remember we gave them a time period and conditions to look at the report, and it was around the Christmas holidays, and they were unhappy with those conditions, and we then changed the conditions to better suit what they wanted. And I think this is in what I'm talking about, if I recollect it correctly, this may be in the letter that we attached to to the final report as well. And I remember them expressing appreciation to us for allowing them to change the schedule. That's my recollection of that. So when they complained about the schedule, I remember being surprised about that.
Okay.
And again, the letter that we wrote, I believe, reflects this, and that letter will be a better recollection of this than my memory a year from now.
They indicate in that letter, though, that they were required to delete prior discovery productions, preventing them from reviewing underlying documents referenced in the report.
Well, the deletion of discovery, that was pursuant to the protective order in the case, and so put aside the final report of their review, the protective order that both parties signed, and again, there'll be a record of this, that protective order stated that when the case was concluded, the discovery had to be deleted, and that was an order that both sides signed with the court, so that was as much an obligation on their part to the court as to us, and by this point in time, the case is as to Donald Trump had been dismissed, whatever date that was in November.
Right, but they're reviewing the final report to try to, position their client to, make some rebuttals and that type of thing, which is certainly, I think you would agree, is a fair reason to want to have access to the report, correct?
Yes.
What types of communications did you or your staff have with the January 6th committee?
So when I was appointed as special counsel, I asked at some point whether we had gotten evidence from the special counsel, from the select committee. We had not, and so I directed my staff to get that evidence, get whatever evidence we could from them. I think it was in December or so that we did, in fact, get evidence from them and get a copy of their final report. And this is referenced in the in our final report. There's a paragraph or footnote regarding that.
Okay. Do you know who at the select committee your staff was communicating with? Were you?
I was not.
Okay. So you didn't have any communications with members or staff at the select committee?
I did not, no.
Okay. And who on your staff did?
What I recall is tasking J.P. Cooney to do this. I don't know if he then tasked somebody else or if he did it himself or with somebody else, but that's who I remember speaking to about this.
Okay. the book we've been referring to reports that on January 1, less than 48 hours before Republicans could lock down all the evidence or perhaps delete it entirely, I don't think we would do that. A committee staffer summoned an attorney from Smith's team to Capitol Hill to receive a hard drive containing the committee's work. Is that consistent with your understanding of what happened?
I wouldn't have remembered that level of detail if you hadn't read it, but we asked to get everything they would give us, and we took everything they gave us, and we disclosed to the defense everything we got.
Okay. You disclosed everything you received from the
Yes,
January 6th
the stuff we
committee?
got from the January 6th committee, I directed my staff to disclose it to the defense.
And the book reports that, Cooney drove to the Capitol and at the last minute succeeded in collecting 2 hard drives containing about 200 interview transcripts, less than 24 hours before Republicans began shutting down the committee's website. Is that something you have any recollection of?
That level of specificity, I don't. I can't say that that's not accurate, but I don't recall that level of specificity.
And do you know if the hard drives that you obtained contained video of the interviews the January 6th committee conducted?
As I sit here right now, I don't recall one way or the other. If they were in there, we looked at them and we provided them to the defense, but I don't know one way or the other.
And when it comes to deleting documents, while the Republicans didn't do that, what I can tell you is that the January 6th committee files, when we were able to have access to them, did not include the videos that they recorded. And so the question is, do you know, and I apologize if I'm repeating this, but do you know if the special counsel's office, took possession of the videos of the interviews? Because we didn't get it, they were gone by the time we had access to it.
Yeah, as I sit here now, I don't know. What I recall is give us everything you can, give us any evidence you can, and then we review that evidence and disclose it to the defense. What it included in terms of that level of specificity, I don't have that recollection right now.
The videos that they used at their at the public hearings were obviously snippets, and they were they were cherry picked. I don't really mean that in a pejorative way, but they were selected to make the points they wanted to make. And if there was a defense attorney involved with the proceeding, if there was a active minority involved with that proceeding, we would have had a chance to point out that the videos are selectively edited and didn't have the full context. And you would agree as a prosecutor that if there is a video, you'd want the whole video, not just the snippet.
Yeah, we asked for everything they would give us, so we wanted whatever they were willing to give us.
Okay. Let's mark the next exhibit, which will be number
18 and 19.
These are exhibits relating to
Thank you.
what I referenced during our last hour about President Trump's access to classified information. Was it your understanding that the skiff that was in existence at Mar-a-Lago before President Trump, left office, was it your understanding that there was a possibility they could have recommissioned that skiff?
Can I just take 1 minute to look at this? Yeah. Okay. Thank you for allowing me to look at that.
Sure. So you would agree if an individual, not necessarily President Trump, is being prosecuted for mishandling classified information and is going to trial, you would agree that putative defendant would have, ought to enjoy the ability to discuss the charges in a skiff with his lawyer, correct?
Yes.
Have an ability to review the documents in question in an environment with his lawyer, correct?
In a skiff, yes.
Right. Now, if, in President Trump's case, he had a decommissioned skiff at Mar-a-Lago, correct?
I am not sure about that. That may be true. I don't recall that, but I'm not, if there's a filing that says that.
Do you have any recollection, did the defense ask that, the skiff be recommissioned or a secure area at Mar-a-Lago be established so that he can have these communications with his lawyer?
What I recall is that there was a skiff at some point at Mar-a-Lago, or a temporary skiff sort of thing. When you say decommissioned, I didn't know that there was anything like a skiff, unless you can show me something otherwise. I don't remember there being a skiff like there that was like there but not being used. I'm not sure, and again, maybe that's my recollection, but our position about this is reflected in this filing, and it's in sum that the government was not aware of any case in which a defendant had been permitted to discuss classified information in a private residence. And this would be exceptional treatment consistent with the law. I'll just add one other thing that might be helpful is we did work with the FBI to make Donald Trump's review of classified information at this skiff, and I think it was in Miami, more convenient and easier. I do recall having conversations to do that. We did oppose him having classified documents at his home and social club, which is the same place where he was keeping these illegally. So that is accurate.
Right, but if a skiff was established, I mean, this isn't just any normal person. This is the former President of the United States, now current President of the United States. And, if a skiff could be recommissioned at the Mar-a-Lago residence, I mean, why would you have an issue with that?
Well, I think you just hit on it. Any normal person. He should have the same rules as everybody else. And he, at this time, was a private citizen. And I'm not aware of any private citizen in a litigation, no matter how important a person they are, no matter how busy they are, being allowed to have a skiff in their home for their convenience. Again, I think my recollection is we worked to make his review of classified documents at the skiff, and I think it was in Miami, more convenient, and we did that, but I did not think it was appropriate because I think he should be treated like anybody else.
Okay. Initially, in the documents case, sorry, not the documents case, the DC election case, how quickly did you want to proceed to trial after that case was indicted? What was the time frame, if you remember?
I know we requested a trial date. There's a public record of this. I think the judge had a status conference where we discussed it. We proposed a date. They proposed a date in 2026. The date that the judge chose was not the date that we proposed, but was, I think, 2 months after the date we proposed. I'm going to say I'm going to guess 4 months, but there's a record of that.
Right. Yeah, I think the special counsel's office proposed initially trying President Trump in January of 2024. The judge, Judge Chutkin, came back with the Super Tuesday date, which of course raises a whole other set of questions which aren't necessarily directed to you. But do you think in hindsight that, I mean, how many months, was that 4 or 5 months after when did the indictment drop? Was it August?
The indictment was in August.
August 1st of 2023?
Thereabouts. I don't remember the exact date.
Okay. So we're looking at 4 months or 5 months, depending on when it is in January. That's a pretty aggressive timeline, isn't it?
We organized the discovery in a way that we felt that that was a fair date.
Do you remember, as you sit here today, how many pages of documents there were for that case?
I don't.
Okay. Does the number 13 million, I mean, if I told you 13 million, would that be something that you would, sounds about right?
Again, I couldn't say.
And how many witnesses, did the defense need to digest? How many possible trial witnesses did the defense need to digest?
I don't think we got to, because the court obviously didn't accept that trial date, so I don't think we got to that question.
And how many hours of video footage?
You mean like footage at the Capitol of the attack on the Capitol?
Just how many hours of video footage, if the defense was going to take that to trial in 4 months, how many hours of footage would they need to digest?
I'm just trying to think if there was any video footage other than the footage of the attack on the Capitol. I can't answer that. I don't
President Trump's defense team, indicated that it was like thousands of hours of video. And so to digest thousands of hours of video, to digest 13 million pages of documents, would have put them in a situation to, either A, not review the documents, or B, they're looking at like reviewing 100,000, pages per day. I mean, do you think that's reasonable?
I thought the trial date that we proposed, given the case, given the discovery, was reasonable, yes.
So if the math works out that they had to digest about 100,000 pages a day, you think that's reasonable?
I don't know if that's the math, and I don't know if that's the proper way to measure it, but I do think the date was reasonable.
And while all this was going on, we went into this a little bit before, but you have the DC case going on, you have the Florida case going on, and you know that President Trump is required to be in Manhattan for the District Attorney of New York case. At any point in time, did you stop to think that maybe you should have given him a little bit more time to deal with all these cases, these competing cases?
Well, we thought through the dates we asked for. We thought they were reasonable. We also deferred to the judges. So when we asked for a date and the judge picked a different date, I don't recall that we objected to that date.
A lot of times, though, the judge just splits the baby, right?
Well, I don't know that that's always the case. Sometimes they pick the date that one party says, sometimes they pick the other, sometimes it's in the middle, so.
Judge Chutkin certainly picked the date closer to yours than the 2026 date. Getting back to the Robert Jackson, statement that I read this morning, he concludes that a sensitiveness to fair play and sportsmanship is perhaps the best protection against abuse of power, and the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth, not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you think in hindsight that you exhibited the kindness in dealing with President Trump that Robert Jackson evinces here?
I think in our conducting both of these investigations, we did it consistent with the best traditions of the department and the principles that Justice Jackson was talking about there. So yes, I do think in both cases, we adhered to those principles.
And is it also fair to say that you were, in fact, trying to get these cases wrapped up before the election in 2024?
We were trying to move these cases expeditiously. In our briefs, we cited to repeated Supreme Court precedent that states that the interest in a speedy trial, the right to a speedy trial, isn't just the defendant's right, it's the public's right as well. And given the gravity of these crimes and the public interest, it was our duty to move them forward as expeditiously as we thought fair and reasonable.
So in hindsight, there's nothing about the aggressiveness of your schedule that you would have done differently?
I thought the schedule was appropriate.
I just have a couple other questions. I'll jump around and I'll be done. Hopefully I can do that very quickly. The Florida case, initially, you had a grand jury operating in Washington, D.C. How does that work? You're taking evidence in D.C. for a case that, you ultimately decided to venue in Florida. Were you able to use the material from the grand jury in D.C. for the case, or did you have to repurpose that? Did you have to recirculate that material through grand jury in Florida?
Mr. Castro, I'm sorry, I'm a little concerned that questions about the grand jury in DC and the Southern District of Florida may implicate both 6E issues and the scope of Judge Cannon's
fair
order.
enough. Can I ask hypothetically then, if you have a case that you're operating a grand jury in the District of Kansas, and you decide to move a case to, the Central District of California, how would you ordinarily, what's the department's posture on that?
In what sense?
So you have a grand jury operating in Kansas, and you collect evidence. Are you allowed to use that evidence if you ultimately decide to venue a case in the Central District of California, collected in Kansas?
Yes.
Okay. And are there any concerns about that?
You're speaking about a hypothetical case, but I think we're kind of speaking about the case in Florida, and so I think whether there would ever be concerns depends on the specific case we're talking about. And again, I don't feel comfortable answering that because of this injunction, but for the injunction, I'd be happy to answer it.
Okay. Mr. Jordan wanted me to point out that there was a discussion earlier, I think it was with Congresswoman Scanlon, talking about the Pennsylvania election. And I think you used the term that, in the normal course of things, the, things that happened in Pennsylvania. Am I jogging your memory with this?
I know we spoke about that. There was another series of questions about this, so I do remember that, yeah.
Okay. And we just wanted to point out for the record that, there was nothing normal about what happened in Pennsylvania during the 2020 election. The state legislature, who ordinarily is responsible for making, the election law, picking the time, place, and manner, and prescribing the blow-by-blows in an election, was, basically usurped by the Pennsylvania Supreme Court. And they changed all sorts of things in the 2020 election. For example, they said that the election, instead of ending on, ordinarily would end on a Tuesday, election day, was going to end on a Friday. The Supreme Court said that where signature verification was ordinarily required, that was the Pennsylvania state legislature's, that's how the statute's set up, in terms of administering elections. And the Supreme Court changed that and said that, signature verification wasn't required. The volume of absentee ballots was completely different than an ordinary election. There were over 2 million, absentee ballots. And so, we just wanted to point out, and I guess ask you the question, were you aware of all these irregularities and disparities because of the COVID and so forth? So many things had changed by the time it got to election day in Pennsylvania.
Well, what I can say is that some of the issues you raised are the sort of issues that a campaign or someone who's a candidate can raise in the courts, and I believe a lot of these issues were raised in the courts. I think Donald Trump lost those litigations, and as we pointed out in our indictment, that bringing a lawsuit for some of the issues you talked about, that's the proper way to dispute these things, or asking for a recount, as President Trump did in 2 states. Our case was about false allegations of fraud. Our case, the things you just mentioned, we didn't allege those. to be part of the fraudulent conduct targeting a government function. And so, again, those are issues that I think we are aware of in studying these things and in speaking to election officials there. But they're the sort of issues that are dealt with through litigation in our court system, and I think that's what happened in the election after.
Okay. Let me go off the record briefly. Recall any discussions with public integrity? This is in the toll records topic area. Any back and forth with public integrity about acquiring toll records of staff, congressional staff?
One of the subpoenas we asked for was for a staff member. That's yes.
Okay, and do you remember with House or Senate?
House.
Okay, and do you remember who it was or what the circumstances were?
I do. It was a staff member for Congressman Gomer.
Okay. And that was the only time that you saw toll records for a staff member?
That's my only recollection as I sit here now, yes.
We can go with record.
So, Mr. Smith, you spoke earlier today about threats and attacks against, made by Donald Trump against witnesses, prosecutors, judges who had challenged him, including threats against yourself. Do you remember that?
Yes.
So, did President Trump target you personally in posts on Truth Social?
Yes.
Are you aware, for example, that he called you a, quote, deranged lunatic, unquote, quote, Trump hater, unquote, and, quote, psycho?
Yes.
Do you recall that on October 15th this year, President Trump speaking to reporters standing next to the Attorney General and the Deputy Attorney General said, quote, deranged Jack Smith, in my opinion, is a criminal, unquote. Then he also talked about investigating Lisa Monaco, Andrew Weissman, and Adam Schiff, saying, quote, I hope they're looking at all these people and I'm allowed to find out. I'm in theory the chief law enforcement officer, unquote.
Yes, I'm aware of that.
And are you aware that President Trump posted on Truth Social on October 29th of this year that, quote, these thugs should all be investigated and put in prison, a disgrace to humanity, deranged Jack Smith is a criminal, with 3 exclamation marks, unquote.
That may be. I know there were several posts like this.
Okay. Do you think those were a direction, potential direction to the Department of Justice to retaliate against you because of your role as special counsel in the investigation of him.
Yes,
You are joined by your counsel today from Covington and Burling, is that right?
yes.
And did President Trump or the White House take any actions against your attorneys due to their relationship with you?
Yes.
And what action did they take?
They filed an executive order against the law firm and sought to withdraw the security clearances of my attorney.
Okay, I'm just gonna offer this as Exhibit 20, and this is exactly what you just talked about. So, Exhibit 20 is an executive order issued by
I know it.
the White House on February 25, 2025. And it is entitled Suspension of Security Clearances and Evaluation of Government Contracts. And I just want to read into the record that this executive order says, I hereby direct the Attorney General and all other relevant heads of executive departments and agencies to immediately take steps consistent with applicable law to suspend any active security clearances held by Peter Koski and all members, partners, and employees of Covington and Burling LLP who assisted former Special Counsel Jack Smith during his time as Special Counsel, pending a review and determination of their roles and responsibilities, if any, in the weaponization of the judicial process. And the executive order also directs the Attorney General and heads of agencies to take such action as are necessary to terminate any engagement of Covington and Burling LLP by any agency to the maximum extent permitted by law and consistent with the memorandum that shall be issued by the Director of the Office of Management and Budget. Did I read that correctly?
Yes.
To your knowledge, is this executive order still in effect?
I believe it is.
What do you think was his purpose for issuing this executive order?
To seek retribution against me.
Is it also to harm your relationship with your attorney and to make it more difficult for lawyers to represent you?
I think it's to chill people from having an association with me.
I just want to say for the record, we're still here, proud to represent Jack Smith.
Thank you. So once President Trump took office, were members of the Special Counsel's office, was their employment affected?
Yes.
Were they fired?
Yes.
Do you know roughly how many people were fired?
I don't have specific numbers.
Is it more than a dozen?
I believe so, yes.
Okay. Do you know who fired the former members of the Special Counsel's office?
You mean who told them or who issued?
Yeah, who actually communicated? Well, let's break it. Do you know who authorized the firing of these staff members?
I'm assuming the president did. I don't know the specifics, but
Okay. Do you know how the termination messages were communicated?
I don't recall if how they were communicated.
And these are career attorneys and agents, is that right?
That's correct.
Okay. They're not political appointees. They've served different administrations with different political parties at the head. Is that right?
That's correct.
Do you know what justifications were given for terminating those staff members?
My understanding is no justification was given.
Are you aware of any reason to target these individuals besides their work on your investigation or association with your investigation?
None. I think it's a travesty.
Do you believe, well, you just answered it, but do you believe it's proper to retaliate against career prosecutors for their involvement in a federal investigation?
Of course not.
What about the support staff who aided those prosecutors?
I don't understand that, why you would do that.
And what about FBI agents who carried out this investigation?
As I said earlier, I don't understand why someone would seek to do that.
Do you think that firing all of these public servants make the country safer?
No.
Why not?
As I mentioned previously, I think when you fire people who are career public servants serving both parties over many decades, you lose the expertise about how to do the job properly, and that has an effect on the department today, and it'll have an effect on the department for some time if those people aren't there to be leaders and to teach young lawyers how to be public servants.
Do you feel like you have a target on your back?
I believe that President Trump wants to seek retribution against me because of my role as special counsel.
Would you be surprised if President Trump directed the DOJ to indict you?
No.
Are you concerned about the safety of people who associate with you, like your former colleagues and your attorneys here today?
I would prefer, if it's all right, not to talk about my safety, because I think doing so could in fact endanger my safety and those of people around me.
Understood.
I'm going to turn a little bit to the folks who actually attacked the Capitol on January 6th. I believe your report talks about the rioters, the crowd that violently attacked the law enforcement officers attempting to secure the building on page 25 of your report. One of those rioters was Daniel Rodriguez, who multiple times plunged a stun gun into the neck of Officer Michael Fanone, causing Officer Fanone to suffer a heart attack and sustain other injuries. Mr. Rodriguez was subsequently sentenced to 12 years in prison after a federal judge called him a, quote, one-man army of hate. Are you aware of President Trump pardoning Mr. Daniel Rodriguez?
Not him specifically, but my understanding is he pardoned all the people who violently assaulted police officers that day.
So in pardoning all the people who assaulted police officers that day, another example is a Mr. Patrick McCaughey III, who used a stolen police riot shield to crush Officer Daniel Hodges in a metal door frame at the entrance of the Lower West Terrace Tunnel, and he left Officer Hodges trapped, bleeding, even crying for help from his fellow officers. Officer Hodges testified, and this is a quote, if I was there much longer being assaulted in such a way, I knew that there was very likely I wouldn't be able to maintain my consciousness. Judge Trevor McFadden described Mr. McCaughey as a, quote, poster child of all that was dangerous and appalling about January 6th, stating that his actions were, quote, some of the most egregious crimes ever committed that day, end quote. Mr. McCaughey was sentenced to more than 7 years in prison. Are you aware that Mr. McCaughey was one of those rioters who assaulted law enforcement on January 6th that were pardoned by President Donald Trump?
Again, I don't know his specific name, but I know people like him who did things like he did were pardoned.
And are you aware of the more than 140 police officers who were injured by the pro-Trump mob on January 6th, sustaining injuries such as cracked ribs, traumatic brain injuries, smashed spinal discs, and heart attacks as rioters used bats, flagpoles, chemical sprays, stolen police shields, and batons to beat officers? Are you aware of those facts from that day?
Very much so.
Do you believe that pardoning individuals like this who committed crimes against law enforcement that day makes our country safer?
It does not, in my view.
Can you explain why, from your prosecutorial experience, prosecuting gangs, prosecuting violent crimes, why pardoning individuals who committed violence on January 6th doesn't make our country safer?
Well, I don't think it's really my opinion. I think we've already seen some of the people who were pardoned go on to commit other serious crimes, and I don't have much doubt that in the coming months and years we'll see more of that. People who would otherwise be incarcerated, communities protected from them, they're out in communities, and my view is that we will continue, unfortunately, to see people who were pardoned for committing violence on January 6th continuing to commit additional crimes. That's my view.
Can we go off the record for a second? Were you aware that on November 10th of 2025, President Trump issued a second sweeping pardon proclamation granting a quote full and complete and unconditional end quote pardons to at least 77 individuals related to efforts to overturn the 2020 election? Were you aware of that second pardon from November 10th of 2025?
I was.
And many of these individuals that were one of these 77 individuals, they were individuals identified as unindicted co-conspirators in your investigation. Is that correct as well?
I believe that's correct.
Some of these individuals that were pardoned include Mr. Giuliani, who we talked about earlier today, who was willing to spread knowingly false claims and work to subvert the results of the 2020 election. Are you aware of that?
Yes.
I guess taking a step back and looking at the fact that President Trump pardoned these folks, these 77 individuals who were previously working to overturn the election, the 2020 election, what message does that send to folks living in the country, particularly as it relates to election integrity in future elections?
You know, I just, I don't understand why you would pardon people who assaulted law enforcement. I think it sends lots of messages. One of the messages is to law enforcement. The people who defended the Capitol that day, in my view, are heroes. And I think pardoning people who assaulted them is wrong.
And what about pardoning the folks who actually worked on the conspiracy to overturn the election? What message does that send about election integrity to folks living in the country?
Well, I don't have a full list of all the people that he pardoned there, and so I don't want to speak generally about all those cases. We didn't charge anybody other than Donald Trump, and so I'm not going to speak about pardoning people who weren't charged with crimes.
All right, we'll go off the record.